Good morning. It's Thursday. I can't believe it. I've got to pull up the date because why? Because I don't even remember. It's October 24th. I am covering Florida versus Sarah Boone. We are in day 5. This case has gone very quickly. Remember, evidence just started last week on Friday, and we got through almost the entirety of the state's case last week on Friday and Monday. So here we are on Thursday. The defense is going to rest first thing, and we're in the rebuttal case. Yesterday at the end of court, the state said that they had a couple hours of video and their own expert. So we have now gotten into the battle of the experts. We'll see how the state's rebuttal case goes. They should be done by the end of the day today because the jury instructions are going to be contentious and one of the most important parts of the case. I expect we'll get to closing arguments early Friday morning, and then the jury will deliberate. How long will that take is up to the jury. There are 6 deliberating, so we will see how long it takes them to do that. But this morning in court, all the defense has to do is admit those exhibits they talked about yesterday and then rest. So we are through the defense's case in chief. Whether it was persuasive to the jury, I don't know. What we will see, or what I've seen from this case, is that it leaves me sad. This was avoidable. I think Sarah Boone knew she was zipping him into the suitcase. I don't think she intended to kill Jorge Torres. If she did and the state could prove it, they would have charged first-degree murder. They didn't. And it's just an incredibly sad case that is so avoidable. And I'm not surprised when we heard from Sarah Boone's own expert that she said, I asked her why you didn't unzip him. And she zipped him in the suitcase. She says it's because she was in fear. And then she went upstairs and went to bed. So we'll see what the jury makes of all of that, and we'll see what the state makes of it on their rebuttal today. It is gone quickly. I think overall the attorneys have moved this case along smoothly. There's been some normal trial hiccups, but nothing substantial. There's been some scheduling hiccups that happens, especially when a case is moving this fast. And the judge, I think the judge is great, but the judge is pushing the speed of this case too. He's like, can we stay another hour? Can we just get it done? So I think they'll be all the way done tomorrow. So with that, law nerds, great to see you again. Thanks for making this the #1 place to watch live trials. And when I say that, it's because this is the #1 place to watch live trials, trial after trial after trial. And it's because you guys are amazing to watch a trial with. So everyone, we're still trying to keep our open minds. It gets harder as the case goes on, right? Because we know more. The jury is still told to keep an open mind until the close of evidence and closing arguments, which I'm interested to see. So with all of that, let's roll the intro. Let's go to court. Are you guys ready for court?
Bring the jury.
Members, it was great to see you last night. Thank you for telling me to go to bed. I still stayed up too late, but it's good. Why? I have a lot. I have a cappuccino. I made a cappuccino. We got a cappuccino. We're going to caffeinate, and we're going to go to court.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
So I have left us some Zoom room this morning. We're going to need it because there's a few breaks in court this morning. So we will Zoom past those to get to live court with the state's expert. So as the court comes in, we're already there with everybody standing as court is called, I think. All right. Let's go.
Jury.
There we go.
You all can be seated.
Just before the jury came in, everyone confirmed that there were no further issues. The defense renewed their judgment of acquittal motion. The court promptly denied it. The defense is going to move in those 2 exhibits the state withdrew their objections to yesterday, and we're off and away.
Good morning, members of the jury. Welcome back to 12 Alpha, the Orange County Courthouse. If you could, just raise your hands.
And yes, thank you guys for reminding me.
Instructions last night during the break.
There was a note from one of the jurors saying they couldn't go past 5:30 today. So bless them and thank you.
Record will reflect that all jurors have raised their hands.
You guys are telling me that you have an echo in court. That's not helpful. Give me one. And then my device is like, I've got you. And I'm like, no, device. You are not helping. So let me try, refresh and try again. when we build our own streaming stuff.
We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there, okay? All right, thank you very much. Mr. Owens, you may proceed, sir.
Yay. He's going to just admit those into evidence.
Judge, at this time,
All that's happening.
I would move to introduce defense identification exhibit AB into evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification defense
Yep.
AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
Yep. Suzanne in the chat said, Emily, thank you for narrating the trial. Some of us are driving while listening. We wonder what's happening when all goes quiet. I do my best to keep everybody in the loop.
You may proceed.
Original E said, does the judge have his groupies today? The court piece? No.
Defense exhibit
You guys know I went to see Yachtly Crew. Their fans are called the Croupies. I was trying. I'm not clever enough this morning to do that. He has one of his trial ad students there with him. And they are just, going through it. Witness said, thank you for considering us listeners. I try to make sure I read super chats too, so that I'm not just responding to stuff on screen. Lyndon, as always, much more clever than I, said, Benchies. I love it. The Benchies. It's perfect, Lyndon, as always, the humor and the wit, 10 out of 10, and swift as can be. All right. He's going to hand those, it looks like, to the jury for them to look at. We're going to zoom. Maya V in the chat, happy birthday. The judge also with a tankard of coffee. So. And you guys, I think for some of you that say, I listen along too, thank you for describing. This content is easy to listen along to, I hope, in the background. I try to make it that way. But I listen to most things in the background too. All of my books I do by audiobook. I am very much more of an auditory person. So I also try to do that. Because that's how I prefer content. All right, let's zoom. Zoom. Everybody's taking copious notes this morning. What are we doing? Your case is done. Zoom. Oh, long break. The judge is just looking at the jury. The jury's passing
Mr.
those
Owens,
around.
any other additional witnesses,
There we go.
evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rests.
There we
Thank
go,
you.
y'all. Officially
Defense,
on the
State, Are you
record.
intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
There we go. They're calling their expert. The defense rests, and away we go. And guess what? We're going to time travel. Look, I'm not a Time Lord, but I can play one on YouTube. I mean, badly. No one can be David Tennant, except for David Tennant. But I can pretend. And then I'm going to have breakfast. Because it's our time while we're
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tonia, T-O-N-I-A,
Emily, no eating in court. I get it.
Thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian.
They didn't even let this lovely woman sit down. They were just like, good morning, where are you employed? She's like, I'm not in my seat yet. She's barely put her stuff down and they're asking her where she's employed. The state is ready to fucking go. They're just like, zoom.
Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury
No, ma'am.
what your educational
She
background is?
immediately pushed the microphone out of her face, probably so she could see the lawyer better. But immediately when I see them go, ooh, I'm like, no.
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
Ma'am, because I find you to be so clear and the questioning to this point so concise, I'm going to put you at 1.25 because you're an expert and we're going to hear a lot about your background. We're going to hear about psychology, forensic psychology, what those things are, all of that kind of stuff. Her name will be pinned in the comments. So yes, she spelled her name, but it was as she was standing.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015.
Oh, that's
I
a long
retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
She is sped up a little.
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law, so anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut. While I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have,
Approximately how many?
thousands of times.
That's a lot.
And does this include
For me,
on matters
a lot.
such as competence?
Yes, it does.
And does it?
Think
just
Tom
explain briefly
Girardi.
to the jury, what does that mean? Legal competence.
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
So she's
And
done
have you
quite a
ever
lot
been involved in
of
working with
appointed
forensic
work.
psychiatrist involving the subject matter of battered spouse syndrome?
I have.
I imagine
Describe your
that's not as
experience in that area
frequent.
for the jury.
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are
She
describing as
is,
battered spouse syndrome?
No.
Done
And I see
this
there's
quite a
book in
lot.
front of you. What book is in front of you?
Yes.
I
So
can
this
guess.
is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5?
We were so close to getting back to what if any, but no, where if anywhere is the what, the cousin to what if any, the sister to what if any?
TR?
It
Where,
would come
if
under
anywhere?
one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another
They go
person
get
does or
muffins.
says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
He was about to say calls for speculation.
described,
She hasn't been offered as an expert yet.
There's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair
Relatable.
to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase, and that's the third phase.
And yes, they're gonna ask every
where the
witness to
individual
describe
who
these things.
created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in, and then it starts all over again, where you feel the kind of tension start building up again to the incident.
And to be fair on that, it generally takes people a couple times to hear something to really understand it. And sometimes people explain things different ways. So each expert is going to explain this. And one expert might resonate with a juror where another one doesn't. So if these jurors have never been on jury duty before, this might be completely new to them. So hearing it from 3 different experts might help. For those of you that watch a lot of trials and have watched trials with me, this comes up on occasion. So you've seen it more than just with these witnesses. You've seen it case after case after case. So that is why the attorneys are always going to ask. They're not going to rely on that expert might have explained it in a way that all jurors understand. So that's why they repeat it, and to make sure that the jury understands.
Abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access the funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the
All right. The state's going to start getting into what I think their rebuttal truly is that the victim here was the abused, not the abuser, or at least at times was the abused. And they're going to be getting into power dynamic. So I'm going to slow her down as we're getting into the vague, more specific facts of the case
receiving end
from the state's perspective.
Emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence, and end up having this syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And Can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's?
I need to know more about this. He keeps asking about it.
Yes.
Like giving something and taking it back. It's
And-
got to be in those body cam
In this
videos.
particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I
Oh,
do.
hallelujah.
Point out where she is and what she's wearing.
She's sitting at a table there wearing a dark suit and a pinkish top.
Finally.
What date did you have the evaluation of Ms. Boone?
It was early in October, I believe
This is what
October
date?
2nd.
October 2nd.
And this was at the request of the state.
Here's the important note for me. October 2nd is after the other expert's last evaluation. So the other expert talked to Sarah Boone on 9 occasions. This expert talked to Sarah Boone October 1st of this year. So it was after that, as this was speeding towards trial.
State of Florida
Yes, it was.
and subject to a court order.
Yes.
And where, who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, her work background,
Did she tell you she's a straight A student?
her marital background. I go through
I was
health,
not a straight A student. There was one
psychiatric
semester.
background, any substance use issues.
I framed that report card
I
for
do
a
a
little
mental
bit.
status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So
What?
a mental status examination.
Counsel, with respect, what in the fucking hell? Can I stop you there? Please elaborate. She's allowed to detail what she did in her examination it's not a narrative.
Is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate?
I'm going to stop to answer a quick super chat or comment on a quick super chat from Kadora 1090. Now you have to transcribe me talking about your super chat that you stopped and typed into here, who said, sipping on my Larner cup and using this trial as dictation practice for my court reporting class. I think this is a great use of stream. Your interruptions are actually helping me practice for when attorneys go off the rails, as they do often. Cheers, law nerds. Cheers, Kadora, and thank you for what you do. There is an incredible court reporter shortage that is going to impact people's access to courts and continue to slow down courts. So thank you very much. I appreciate you. Let us continue.
Occurred on February 23rd, 2020 to you.
All right. Is it all right if I refer to my notes just to make
Just, if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink.
Pause.
But that she...
What you will notice different than yesterday with the defense experts is that you've seen the prosecution object with the defense experts, and with this expert go to, what did Sarah tell you? What did Sarah tell you happened? And that's because it's being offered against a party opponent. Sarah is the opposing party. She is the defendant. The prosecution can ask that. The defense can't elicit that from witnesses. They can elicit that from their client. And I wanted to thank one more super chat before we get back in. Power Girl said, what doesn't make sense to me, using battered spouse. She feared him enough to put a dresser in the way. If we believe she moved a 200-pound dresser, yes. On other days, yes. But wasn't afraid of what he would do when he got out of the suitcase. So not afraid of him or knew he wasn't getting out of the suitcase. I think it's a fair observation. And there's a lot of questions to Sarah's story. It's not super linear. It doesn't always make a ton of sense. Also, chat, thank you for no spoilers. We are a little behind real time, so we can zoom. So I appreciate it.
Asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork.
I love sitting out on a porch too.
Felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen.
What?
He didn't explain that to the brother. And
Oh, she's like, although that didn't happen. I'm like, wait, what? And she's like, she didn't explain that to the brother. They talked about choking. They didn't talk about that. Orpha said, this woman is far easier for me to understand than the expert yesterday. Some of that is the expert and her manner of presenting. Some of it is the questioning is going in order. So the questioning of this witness is tracking linearly instead of jumping all over the place. It's also much easier for me to follow. I don't count that against the experts from yesterday. Some of that was really bad questioning, and those experts might be a little easier to follow under other attorney questioning.
According to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs.
I will stop interrupting her in a minute, maybe. One thing that's notable to me in all of this is Sarah Boone. And again, the more I sit with this case, the more my brain is just like, oh, this case. Sarah Boone talks about the fact that in the past, she made up the game that they were sword playing, and that's how she got stabbed in the leg. I'm sure we'll hear more about that today in body cam. But Sarah didn't seem to have any negative response to tag you're it. No response of terror, no response of shit, this is going to be bad. No response of fuck, this is going to be a problem. So it's just some of the things in the way Sarah's explained her story are internally inconsistent for me. So I'm interested to see if how that goes, but it's interesting to note the way that her story has changed as she has had experts that work with her.
And hid in the shower and waited for him to come, and he never came upstairs.
Because you were supposed to be seeking Sarah. You were
And
it.
so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And
Just hand her a water,
Sorry.
counsel,
and
someone.
so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes
Again.
at this point.
This is October 1st, and Sarah still said,
Down and then tell us what you remember.
Sarah still said October 1st, I became angry. Not I was scared, not I thought he was going to come after me, not I realized that his tone changed and now I'm afraid. It was I'm angry. And so if the jury's looking at second-degree murder, can they find that Sarah Boone said, I'm angry.
She said that she shook the suit.
I'm angry. I zipped him in and was like, fuck that. I'm going to bed. You stay there then. That can get the jury to either manslaughter or second degree murder if that's what they think she did.
Case, and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right.
Also, I would imagine if you're afraid, the thing you're not doing is waiting for them to come get you. Right? You're not waiting for them to come upstairs and go to bed with you if you are in fear.
Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol?
You might be waiting in bed.
Yes.
Hoping
so it
that also
causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder, so we
And again, the reason I say that with Sarah is because Sarah has a history. I'm going off of what Sarah has said. Look, these are Sarah's words. We know from Sarah Boone's history that when she and George had issues where she was scared or upset, she would go to her ex-husband's house. So we know that she has a history and a pattern of if she feels like she needs to leave the house, she can leave the house and has somewhere to go. It's notable to me that that is established for her and she can do that. Not everyone can. She can do that. And this night didn't. For me, that is notable.
used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate,
Chat, no spoilers.
government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory, it can affect your reactions, it can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse
I
syndrome?
wonder if they asked the jury about
Depend on
their,
each individual again.
if they have
Generally
anyone in their
speaking,
life
it's
that has dealt with
important
alcohol
as an
abuse disorder.
evaluator
That'd
to
be
get
interesting
as
to
much
me.
information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, Did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about...
Judge, if we could approach the bench.
Yes.
She keeps saying at the jail. Also, it's hard for me after we've seen how thorough some of the examinations have been done in other cases, that a 2.5-hour interview, she's like, she didn't give me enough to say she has PTSD. It's quick, but she keeps saying at the jail. Though Sarah did say I've gained weight since incarcerated, so I don't know if that's going to be a big issue, but we'll see. Because Sarah did mention that she's been incarcerated. I don't know if the defense even caught that when she was, Owens is like, you've gained some weight since then. And she's like, yes, since I've been incarcerated, I've gained weight. She wasn't happy, but let's see. All right, they're up at sidebar. Looks like the attorney is coming back to talk to Sarah. Still at sidebar. All right. The camera angle changed. I thought we were back. Still at sidebar. Chat, this is my, this is Exhibit A for Zoom Room. So, James Randolph in the chat said they've had 4 years to evaluate her. They didn't until the defense, is going to run this defense.
Members of the jury, thank you so much for your patience.
They're not gonna spend
I have
money.
a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience.
This expert
We're going to
mentioning
excuse you
her
to the
being in
deliberation
the
room
jail
at this
might be
time.
an
Please
issue.
do not
I
conduct
guess
any
we'll see.
independent investigation or research as to the
Chat
person,
and spoilers.
places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things.
Your Honor, I
and we'll
love
bring
you,
back in as promptly as
but
possible. Mr. Owen, see if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Werner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Oh, not about the jail at all.
Judge, it applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line
To be fair, battered spouse is not a diagnosis.
17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes.
Expert opinions have to be disclosed to both parties.
Think about it, process it.
If that wasn't done, this is going to be a problem.
But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7 for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review.
So she was saying she needed more time to review all of her notes.
Because obviously I'm not going to want to take your deposition and you have other opinions
Right.
that are not going to be covered.
Right?
And then I asked, looks like Mr. J asked, what's your position? You say conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position.
Sounds like Mr.
He
J.
needs to issue a supplemental report, or if there has become a need for a second
The
deposition,
doctor's still on the
then we
stand.
can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said,
It's surprising to me he didn't bring this up when they said, are there any issues? They knew this was the next witness up.
but if that happens, I can bring that forward, and then you can add to your deposition at that point, if my opinions change after having reviewed further. And I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about to on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. And I
Okay.
respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis
Right.
or opinions. Mr. J responds on line 4. Okay.
Her not having PTSD is an opinion.
What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically.
Chad, I appreciate that you're asking what's going on. I don't know because they said it at sidebar what their issue is. This doctor said she does not think Sarah Boone has PTSD after her conversation with Sarah Boone at the jail. Then they excused the jury. Then they went to sidebar. And now Owens seems to be saying that that was not the opinion that she rendered at the time of the deposition. You can't give new opinions when you get on the stand. It has to be disclosed to the defense. So then he's reading from that transcript, and now the court's saying, you skipped a massive part because the judge has the transcript in front of him too.
Opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15.
So if this is a new opinion,
She's
it's a
saying
problem.
She has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the doctor, Werner, was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now, and that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on.
Right.
And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it.
The court's like, no, we're not reading this in
Seven, the
wrong.
witness, Dr. Werner says absolutely. And then you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript, I'm following along with you.
That was the general understanding.
So I want to know
that
the
we had
argument.
about all diagnoses, all opinions that she may have. And so
So that didn't
she
include
starts
PTSD.
talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, you know? That's how she answered.
I think that's clear.
She goes through a little bit of that.
Everyone is agreed on that. I think what Owens is getting at is that she did not disclose that she believed that the
And then,
defendant does not have PTSD. I think that's the
Paraphrasing, she
issue.
talks about the grandiose component or criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist.
This is a problem that doesn't need to happen.
And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
Judge, excuse me for interrupting, but can we lasso this back into?
I'm very, I understand that's what the depo reflects, but the non-objection which led.
The prosecutor, can we rein this shit in? He's just talking. All right, judge, I hope the judge will reframe what the fuck we're talking about.
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder.
Okay, good, we were right.
At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or a diagnosis of narcissism. The question pertains to PTSD.
all right, page 46, line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that.
That's what she said on the stand.
Line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her.
That's what she
talked
said.
about that.
She didn't give me enough
And
criteria.
she spoke about, having recollections, remembering abuse from George during the evaluation.
Is that not what she said on the stand?
13, line 13, on 46.
That
But
seems...
you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look.
What the fuck are we doing then? Do you think she suffers from PTSD? No. That's an opinion. That's what she... What are we... Why are we wasting time?
Back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why
Objection, Your Honor. This is bad for me, and I don't like what she's saying, and my client's mad.
you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question.
She said no.
Okay.
She said,
and
I want...
that's something you will let the lawyers know about if that changes. Answer, line 2 of page 47, yes.
That's why he's mad. She said no. She said, I don't have criteria. She said, I would want to review my notes.
Specific to the post-traumatic stress disorder.
And that's consistent with what she said on the stand for me. But I wasn't paying that close
At the time of this
attention.
deposition,
So I didn't think it was a problem.
I asked her specifically,
So what's the legal objection?
I cannot fucking love this judge anymore. Right. So your problem is one. I love this judge. He lets Owens be heard with all of the nonsense. This trial has moved along quickly, and the judge is like, right. And this is the judge's face right now.
So what's the legal objection?
I
What are the legal grounds of the objection?
will not
Grounds!
take that deposition, Judge. When she said, I have not had time sufficiently.
When the judge says, what are the legal grounds? He expects you to say legal words. And those words should be relevance. I didn't deal with depositions a lot. So whatever grounds it's going to be for not disclosing an undisclosed prior opinion discovery violation, he wants to know the specific magic legal words. And then Owens goes back into, but Your Honor.
To answer these questions, these diagnoses, these opinions. If this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
You took the case.
What are the
I'll be notified of
what are the
any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
There is a book.
I understand the backdrop.
That's all. There are books.
I don't know if there's a legal ground other than we had an agreement as attorneys and parties.
Sir, the rules of evidence. I don't know if there's a legal ground. Then why are you doing this? My God. Oh,
I understand the backdrop.
I don't know if there's a legal
I didn't mean to pause that.
ground other than we had an agreement as attorneys, as parties, that I would be notified
judge's
of
face.
change of opinion, and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making.
I don't
What
know
would
if there's
proffer
legal
with
grounds.
This witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well then, my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing, and once he was already secured in the suitcase, she became angry.
The
and
witness
then
is
did all
sitting on the
things
stand
that she
listening to
did.
all of this.
My expected answers from the doctor, based on a very brief conversation yesterday and this morning,
There's
was
not
that
enough criteria.
if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever
should.
delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was,
Yep.
and I may have to ask Madam Court Reporter to read it back.
Do it.
But my
Read it
memory
back.
of what the question was is, have you formulated an opinion?
Yes, it was.
With regard to
PTSD.
PTSD.
And my expected answer was, it doesn't matter because of what she said.
Well,
during
that's not what
the
she said.
evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The
I
answer was a
understand that, but that's
definitive
not
no.
the attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply.
Liz Tarr in the chat said I needed a big screaming goat. Hold on.
Opinion to the expert.
The Lawnard
But
sent me
that
this one.
doesn't mean that that's my opinion, that post-traumatic stress does not
Okay,
apply.
that's irrelevant for the purposes of this argument.
Their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the
Owens.
opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable, it doesn't matter, because of what she told me. That's unfortunately not the answer that was given.
I'm going to just remind you all that everyone's tired by this point in trial, myself included, and I'm not even doing the trial. Everyone's tired by this point in trial. Everyone is not well enough hydrated. They have not had enough sleep, and they probably haven't eaten well. So everyone's a little cranky. So when you see stuff starting to fire up like this, keep in mind that everyone's a bit heightened anyway, which makes things spicy. And yes, the doctor is still sitting on the stand listening to all of this. If this was a civilian witness, they would have excused them. But with law enforcement or experts, they don't always excuse them while the argument's about them. And the judge might need to clarify things or direct this witness one way or the other. So Owens is saying, look, the witness did not disclose that she was going to give an opinion on PTSD. The state said, we didn't think she was going to give an opinion other than she didn't have enough info. I think the court's going to have to ask the court reporter to read it back, because I think she said, I didn't have enough information. She didn't give me the criteria of PTSD, something in that realm. So we'll see.
So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What?
What other opinions, Mr. J, if any, are going to be offered by Dr. Werner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor?
So when he says proffer, he's like, I'm just going to ask the doc. Notice that Owens is like, we want to know what she's going to say. We've done this with experts. You've seen this done with experts in other cases. Fine. You want a proffer of the testimony? You want to know what she's going to say? Fine. So what a proffer means is I'm going to ask the witness what's coming up. It's a preview of the testimony. What are you going to say next? And the doctor's sitting right there. All right, doc, what are you going to say next?
Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse
Proffer
syndrome or
begins.
PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on
Material
what she told
by
you about what
L'Oreal.
happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
Well, you didn't say that when you had no objection.
What is the legal opinion?
Somebody passed him a sticky note that said, it's a discovery violation.
That post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
Ding.
I would like to have known that, and that was going to be her opinion before today.
You did. You read it.
That's not a change in testimony. That's
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
Give me a minute.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At
And you
no
didn't.
point in time did the defense say, look at this, look at this, look at this, in her deposition when we had that hearing.
Uh-huh.
So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66,
I didn't see the
20.
screen name fast enough in the chat for somebody who called him Massachusetts. Can't unsee it.
let me know when you're there, Judge.
Owens, the audacity, sir.
Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you
This
intend
isn't
to do
relevant.
on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question.
I will say we were due for some sassiness. There has been very limited sassiness, and now we get to see the judge kind of putting the gavel down on the sassiness, and the jury's not there. So I'm not mad about it at this point. I'm like, this is a waste of time. But Owens clearly is concerned about this expert. And you can tell he's concerned about this expert. If he wasn't concerned, he would just be like, okay, fine. Because it doesn't seem that this is a change of testimony to me at this point, unless Owens grabs something else out of that transcript. But he seems concerned.
Then I go into pleas.
But I'm not mad.
Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones
Fuck
you've
is double
expressed here
dog
today.
sure?
Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion.
We might have to name the pickle double dog. I was thinking muffin, but
I believe it's a discovery violation because I should have been notified if there was going to be a change in
there's no change.
opinions here today. And
Where's the change?
We had an agreement that I was going to be allowed
Is
to
the change with
take the
us?
deposition and not be ambushed in the middle of the trial.
Is the change in the transcript?
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's
Finally. It's all I've
Madam
wanted.
Clerk, or Madam Court Reporter, are you able to reread
all
the
I've wanted.
portion of the proffer as to what Mr. J asked of the witness? Absolutely.
She has to control F it.
Of course.
The doctor is sitting on the stand like the fuck. She's just blinking. Just sitting there, eyes cast down, blinking. I appreciate that she's not just staring down Mr. Owens because he's vigorously representing his client. I'm going to zoom while the court reporter is looking for that. Zoom, zoom.
Well, court's going to step off for a moment while Madam Court Reporter is able to provide that reading. Just
The court's like, call me. And now the court's going to step off the bench for a moment and we are going to zoom, zoom. This is why we leave ourselves zoom, zoom room. Oh my God, the court's off the bench for a minute. All right, let's get back to the court coming back onto the bench as we continue to argue over Owens's non-objection over she changed her mind. God, I love having zoom, zoom room. Sitting there through that would have been painful.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Kevin Beck on behalf of Ms. Boone.
Chelsea Marie
Ms.
said the
Boone is
changes
seated
of
at
friends
counsel's
we made
table in
along the
same voting
way.
from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
Wait, not the proffer. I don't think we. Wait, not the proffer. I thought. not the proffer. I thought we were going to read back what was said in testimony. I thought we were doing read back of what happened in trial in front of the jury.
Question?
Oh, he asked for the proffer?
Present for all of this hearing, yes, doctor?
I missed it.
Yes. Question? Am I misrepresenting any of our conversations?
He did say proffer.
Answer,
I didn't
no.
want the proffer. I wanted the
Question?
trial testimony.
All right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as a defendant relayed them to you, what would be your answer? Question? That it's not related to the incident as she reported it. Question? Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question. If you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question? All right, that's it.
I don't think that's the very beginning, before I objected.
Owens is saying now, I don't think that's before I objected, right? That's the proffer that just happened, not the question that was proffered in court. And this is the confusion, because what I think Owen said is, I need to know what was proffered in court, but there was also then a proffer hearing. And so now there's confusion, and Owens wants the read back from the question in front of the jury.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response.
Before the objection. I thought he was too.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's
I understand where Owens is at.
the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not
she didn't.
apply. In her opinion, that was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
Oh boy. Dixie Whiskey asks, so did this witness mess up? No. Owens is saying that her opinions changed and he wasn't notified. The prosecution is saying, no, she answered a bit differently than I thought, but that's, the opinions are different than I thought, but that's not a problem. It's not in conflict. It wasn't a discovery violation. It wasn't not disclosed. It's not in conflict with what she said. She just answered it a bit differently than the way it was answered in depo.
Page 46.
And Owens is still fighting.
Line 13 was the question, but you don't believe that
Without
she
legal
suffers
grounds.
from post-traumatic stress disorder in your opinion?
She said
Line
no.
15, the answer is no. I would have to look back
The answer is no.
through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about
He's just-
if that changes.
Owens is rehashing the same thing. I don't think it's different, but I would want to hear exactly what she said in front of the jury, but I don't think it's different. It might have been worded slightly differently, but I don't think it's like different. It's not as if at one point she said, yes, Sarah has PTSD, and came in at trial and was like, no, what are you talking about? Sarah doesn't have PTSD. It's not that.
That's on page 47.
Owens is trying though.
On 2, yes. That's fundamentally, substantially, materially different
No,
from what
it's
she's
not.
testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not
You continue to
Ms.
read that
Boone
correctly,
suffers
Your
from it.
Honor.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back.
Go read it back.
It was first going on when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question
Yes,
was,
please.
what the response was, because it did. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent with
you asked to approach, and then you explained that the question was
Oh, the judge is spilling the tea on the sidebar. Thanks, Your Honor. You objected, and then we approached. Tell us everything, Judge.
was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
Criminal courts often don't have live transcribing, which is why they are reading it back, because everyone needs to know precisely what was said. The judge is like, we're not fucking around with this. They also have time. They qualified the jury for 3 weeks. The judge is like, we're clearing this up. But everyone needs to know exactly what was said. We are in court where words matter. So everyone needs the exact words, but they don't have live transcription in front of them. There's nothing to look at. So they're going to have the court reporter. You saw everybody bust out their notepads. You're going to have the reporter read it again. Everyone's going to write it down, and then they can continue talking about it.
Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
So that was the proffer. Somebody sighed. That was the proffer. And now he's asking her to go back to the question that was said in front of the jury before the objection. Tina T in the chat, thank you very much. Tina T said, soup to nuts is an American English idiom, conveys the meaning of from beginning to end, derived from the description of a full course dinner. Thank you. I had no idea where that idiom came from. I always understood it meant beginning to end. But did we used to eat nuts at the end of a meal? Like, was that a final course of a meal? I don't know. Can we go soup to cake? Can we just change? It? So the court reporter is going back. Thank you, Tina T, for explaining. Lots of people were asking about the idiom. So next time I do a Lumi ad, I'll say soup to nuts, so we know that it covers all your bits and pieces. I will too. All right, I'm going to zoom as the court reporter's looking for this.
Pay no attention to me.
Oh,
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Octo said motion for soup to Carajillos. Motion granted.
My opinion was that she did not give me enough.
Okay. I think we are getting to the point before the objection with the court reporter. So.
Answer. My opinion.
Did she read the question?
And the answer right before Mr. Owens asked to approach.
Question. What was your opinion? Answer. My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
That's what she said in the
Both
depo.
the question and the answer.
Question. What was your opinion? Answer. My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
They should back up to the, yeah, they should back up to the previous question. That's what I would ask too. I would want the previous question.
And in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer.
That is a very clear question from the prosecution. And that prosecution question is very in line with what they anticipated the answer to be, that the two would not, don't correlate in this case. I'm going to back that up. I'm sure they're going to read it one more time. That is a very precise question from the prosecutor. It is not as Owens represented it, and he is not asking or eliciting, the prosecution's not asking or eliciting for a new opinion. That is incredibly precise, and it's in line with what the depo said.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer. I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
He was asking about the relationship. She started with, my opinion is I didn't have enough information for PTSD, and then there was an objection, so she didn't get to continue and say something like she proffered, which, and it wouldn't matter because I do not think it's connected based on what Sarah told me about the evening. She didn't get to finish her answer.
Mr. Owens?
Withdrawn? Are you going to just say withdrawn?
Number one,
My bad?
that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement
Where?
we had, I should have noticed.
Where's it different?
Two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end.
Zealous advocacy sometimes can feel annoying. Owens is trying to do the best for his client, and or he actually really is not on the same page as the rest of us, because humans all process information different. I think he is trying to do the best for his client. However, at this point, you might need to stop digging the hole, Owens.
In general, if you have any new opinions, or anything new that differs from what you've said here today, please notify the lawyers, or words to that effect. So it's an evidentiary issue.
He's like, this is new, and the court's going to be like, where?
A right to be prepared for the trial.
Do you have the ability?
To know what the witnesses are going to opine. And this is a discovery violation
Snarking.
based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my
He asked to strike the entire witness. That's what he wants. He wants the witness to be yeeted. Your Honor, strike the entire witness. They violated discovery. This witness can't testify, and strike everything this witness has said. That's what the defense wants. I don't think that's going to happen here. If it does, I'll be shocked. I need to see something more than this. But let's keep going.
my original question, the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore,
You didn't let her finish.
battered spouse syndrome doesn't apply in this case.
Owens, you didn't let her even finish the answer. However, it's appropriate when you think the answer coming in is going to be something that's objectionable and shouldn't be heard in front of the jury because you can't put the shit back in the horse. But Owens didn't let her finish her answer. And so I'm not surprised that the prosecutor is saying Owens doesn't even understand what the rest of the answer is.
I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was
It doesn't matter.
irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67
Read it.
of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me?
The judge literally just looked at Owens and said, I said receipts, screenshots, fucking everything. And Owens said, but Your Honor, it's a discovery violation, I swear, vibes. And the judge is like, I asked for receipts, screenshots, photos. And Owens is not giving it because it does not exist. And the judge is just, I don't think in this trial we have seen him get to the point where he's like, we're done. Owens cutting him off is going to push his buttons. You do not cut off the judge. You do not cut off the judge. Rowans, ruh-roh, buddy. This is not the judge. This is not the judge to make mad, because he has said, if you need time, I'll give you time. If you need to do this, I'll give you this. He has been incredibly patient. But he didn't give Owens that continuance he wanted when Owens chose to take this case, and Owens is seeing the consequence of that. You picked this, Owens. You knew.
Justice order. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us.
There is no situation. He doesn't
If there
have
are
legal
specific
grounds.
portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already
Per
identified.
my last email,
The ones that I expressed, and that just, the understanding that we had, that she,
I said,
in the pages that I have talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had, in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as
Denied.
read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in a court.
who had the audacity to leave their legal pad up on the bench? Was it Owens? Because somebody's legal pad is sitting up there and it's not the fucking judge's. I had to say it. We can move on.
Accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court, in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
Nope.
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay.
This is procedural.
All right, the court, again, reviewing the proffer and the opinion,
I know.
finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the
What?
opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense.
What?
As it relates to the third category, the effect on the defendant to properly prepare for trial.
What?
Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being
I'm
currently
surprised.
offered, I do find that it had some impact on the ability for the defendant to properly
Really?
prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens.
Oh, he's giving Owens a chance.
Because my question is, do you want it struck?
I think that's fine. Strike it. I'm surprised by that. Because that's not how I interpreted all of that. I am actually surprised by the court's ruling.
We'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going
What?
to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right.
All of that, and Owen's response is, we're gonna get into it anyway? All of that. We went through all of that, and Owen's response is, I'm gonna ask her about it on cross anyway. So it's fine, send it. Are you fucking kidding me? The judge is like, I do find it's a violation based on the question. I'm sad, of course, the state can't pause. I'm sad the state didn't say the reason the answer is a problem is because Owens cut it off and it didn't get to finish. The court said, do you want me to strike the answer? The jury's not going to remember any of this. They've been on break so long. Do you want me to strike any of the answer? And Owens said, send it, because I'm going to get into it on cross-examination anyway. The judge is like, so we did all of this for you to say it doesn't matter? What a waste of time.
Ms. Boone?
What a waste of time.
Have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
What the
Thank you.
fuck?
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions,
Proffer
the court will oversee a deposition now,
Proffer it.
and you may proceed.
Right now?
Yes.
Yeah, right the fuck now.
With regard to the proffered opinions.
You said, I want more time for a depo, and the court said, good, we'll do it now then. I am surprised by that ruling. That said, the judge, I think, has gone out of his way to protect this case. He's giving the defense what they ask for when they ask. He is going out of his way to make sure the defense is giving legal grounds for what they're doing. And even when they don't, he is still finding in their favor. And now Owens is like, what? Wait, what? You're going to give me what I want? Wait, what did we ask for again? Dead, I'm dead. I'm dead.
And I believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time.
Okay, Your Honor.
You may proceed.
Owens is getting everything he asked for.
Yes, sir. Good morning.
Owens is getting what he asked for. The judge, I think, has gone out of his way to protect the defense in this case and is now allowing Owens to do a deposition of this expert. So he gets to do like a first bite at the apple cross-examination. Wild.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
The court found a discovery
And
violation.
how
here.
long was the phone conversation?
Inadvertent, but substantial.
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
That's
Did y'all
typical.
discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as
Which
to
is
whether or
what
not
she
she
said.
suffered from post-traumatic stress disorder?
Which is what she
Correct,
said.
that my opinion hadn't changed.
Which is what
I'm
she
sorry?
said.
Yes, that my opinion hadn't changed, that I didn't have enough information.
Right, that's what she said.
Okay.
That's what she said.
And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the
Event.
the the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
I
You
did.
didn't ask me about that, sir.
Do you remember me asking you any other?
You didn't ask me about that. I thought it was consistent with what she said.
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're
Well,
saying you
that's a bit
formed that
picky.
opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact,
After the deposition?
Oh, that's worse.
after the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you
getting
may
worse, not
express at
better.
trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's
Ma'am.
why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions
That's
you want me
worse.
to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Let her finish.
is relating to a central issue in this case.
Correct?
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked.
Ma'am,
of
you're
me.
not
I have
new
a
at
number of
this.
opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's
all
not
the
good.
questions
This has gotten progressively
Mr. J,
worse,
anything
actually.
else?
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with.
I don't think Owens processed what just happened, because that got a lot worse for this expert, and I don't think Owens has clocked it yet. Again, it's like watching Survivor. You know, you're watching it at home going, oh my God, why can't they fit the puzzle together or whatever it is, because they're operating under duress, stress, lack of food, lack of sleep, all the things. That's a little bit of what we're seeing from Owens at the moment, is that the witness looks bad. She's like, well, you asked me for all my opinions. I have a lot of opinions that I didn't tell you, which goes to Owen saying she has to create, or she has to tell us all her opinions. Then she says, well, I told the state's attorney about this as we walked out of the jail. So the state's attorney knew that before they went into the deposition. And then Owens went and sat down and was like, yeah, I don't have anything else. And the judge is like, you don't? This is one shot, one opportunity. This is your moment. The judge is like, are we sure we're sitting back down? Because the judge clocked it. I clocked it. Y'all clocked it. And Owens is sitting there like, okay. Okay.
With regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Werner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases, and
Yeah.
now I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not
Right, which puts him in a
that
tough
would change
spot
her opinion.
because he doesn't get to rebut the
It
rebuttal.
just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision.
Owens isn't wrong that this puts him in a tough spot. And I think he started off rough, and Owens is like, the judge is signaling to me, like, I'm taking the context clues that I should keep going. And he does that a lot where he talks himself into being on the right track. But what Owens is saying is that how these things work with the battle of the experts is that everyone gives their opinion in advance. And then you go back to your expert and it's like, okay, help me formulate the argument about this expert. And the state does the same thing. So Owens is like, hey, but now I'm at odds because he couldn't preemptively have his expert testify about this. So Owens is on the back foot. And I think this has gotten worse for this expert where she's like, you didn't ask me specifically. I think that's a bit of fuckery because this expert's not new. And he said, do you have any other opinions we need to know? And so, yeah, you have more opinions you need to know. I wonder if well, we'll see what happens, but he has not asked for a mistrial. I don't know if the judge would do it. He didn't ask to strike the testimony, which is the fix here that the judge offered, just strike the last line, which the jury's going to forget about because they got ushered out so quickly. But Owens didn't ask for that. And I think he thinks he's winning and he doesn't want to have to do this trial again. But I think striking the answer is the best. And the judge said, fine, you don't want it stricken. You want to cross about it. Here's your preview of cross-examination. And if Owens wants time to call his expert and prepare, he'll probably give it to him. But he hasn't asked for that yet.
It's not in order. I'm just saying that this is the opportunity
One
to
shot.
cure that Richardson
One
issue.
opportunity.
You asked previously to strike the expert. I am disinclined to do that. The case law
I think
says that
that's
is an
right.
extraordinary remedy, one which
that's
I
right.
am not going to permit.
But I'll strike the
Dr.
testimony.
Werner, you realize you're in a courtroom.
Yes, sir.
And we're waiting on the
Owens, do you realize we're waiting on the jury?
jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you intend to express
She said, ask me
here
specifically.
today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific
questions.
Anytime you ask a question like that of an expert, the expert's always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle.
Owen should say, regarding PTSD and Sarah Boone, what do you think? Regarding PTSD and battered spouse, what do you think? Regarding battered spouse, what do you think? Regarding depressive disorder, what do you think? Just go line by line.
of a trial. She's fixing to testify.
You're not allowed to fish.
She's had conversations with the state attorney. She knows what she's going to be asked in terms of opinions that she's going to express. That's why she's here.
And so
to
do you.
help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here? In the middle of a trial.
I disagree.
I don't think they're
that
playing
there's
hide the
any
ball.
hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant.
Owens is going to start sounding like Sarah Boone saying it's not fair. But Owens, you have all the time in the world. Go thing by thing and ask. Go thing by thing that your expert gave an opinion on and ask. And again, the state said, No expert's going to answer a question like that. Any opinion? No, I don't know. I have lots of opinions. I don't like your tie. Like, I get where the state's coming from. I get why Owens is frustrated. And the judge is like, I'm giving you every single chance.
That
The
is
jury's not
the
here.
opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
He literally keeps telling you to. For those of you saying the judge seems unbiased, agreed, all judges should be. I think the judge has gone out of his way to protect the defense in this case. He did not give them a continuance. I think he has extended them every courtesy. A lot of rulings in their favor. I think the court has gone out of their way to give latitude to the defense here.
Dr. Werner, do you recall expressing that you
It's a bad question.
wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask
She didn't give me information regarding reactivity is interesting.
her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of.
Isn't that the questions Owens just asked you, though? Sarah Boone's like, I'd be happy to answer your questions if you ask me specifically. Isn't that the question you just refused to answer? I asked her if there was any other information she should give me. I mean, I'm not going to tell you that when you ask if there's any other information from me, but I expect it from Sarah Boone. Oh boy. Oh boy. I was not expecting that.
Information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Like Owens just
Were there
asked
any
you.
other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
Not that she intends to
So-
express. Owens, leave that. Don't ask.
Narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Now he's going line by line. Now he's going line by line.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have,
Differential.
I'm leaning towards the adjustment disorder secondary to her legal situation.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
This expert is not thrilled with this defense attorney, and he is not thrilled with her. Well, this morning got off the rails.
In your opinion, does she suffer from any form of psychosis?
No.
Did anyone even ask about that prior?
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is he just opening the DSM and going through it?
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that, yes.
So you agree she suffers from battered spouse syndrome?
This cross is going to be interesting. I don't think that's what the state expected at all. Owens is finding his way into making this work for him. On the fly.
I believe we've covered
That's not
anxiety
good for the
disorder,
state.
narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
Owens worked his way back into making this much better for him, which he's done a couple times in this case. He's found his way back round.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has
Wow.
conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so based on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition.
I think that was an
Anything
abundance
else,
of
sir?
caution.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can...
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
Does it need to be on the record, or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have not.
asked Mr. Henderson if you guys were
And now they're mad about the exclusionary rule. The judge is like, great.
Need to be on the record, or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have not.
asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
And we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They are under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. Y'all.
The defense is like, but we might need a SIR rebuttal, which I doubt they're going to need. We might need a SIR rebuttal, and the lead detectives in the courtroom, generally there's an exception to the exclusionary rule for the IO in a case. This isn't an issue, but the court is just like, okay. So the defense is trying to make a record of who's sitting present in court.
Stay where you are. What's the basis for your SIR rebuttal?
We don't know because I don't know what the state's going to place in a rebuttal. But if
That doesn't
in
answer my question. What's the legal basis of a SIR rebuttal?
How can you do that?
Judicial discretion as to the fairness of the proceeding that the defendant.
Judges like grounds.
Okay.
Grounds.
Anything else, Mr. Cacciatore?
Grounds.
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about
If I was the state, I would be like, why are we excluding the IO? She's the IO.
testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
He asked the defense for legal grounds. They don't give it, and he's like, well, you struck out on that, but I'm still going
Anything
to do
else,
it.
Mr. Owens, we need to address?
No, sir.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury.
And the state
You can
said
continue your inquiry, sir.
nothing about it. And the state said nothing about it. All right, the jury's coming back in. What a wild ride this morning. We've got some super chats that have come in that are incredibly generous. Lizzie Beth 74, thank you very much. Jamie McWay said, Mom Spaghetti. Owen's Mom Spaghetti. I feel like at some point we're going to have to just start singing Eminem. Which, by the way, my breath control is not good enough. I run out of air. I can't even karaoke it. Alyssa, thank you so much for the super chats at Hey EDB and Leonard Babe. Licensed counselor here. That was probably Elle Woods in another life question. Can people like me do court reporting part-time? I think it would be so much fun. Much love. I don't see why you couldn't. If you're talking about in-court transcription, yes, but also as a licensed counselor, you can be an expert depending on the case. Much love to everyone, including Runkle Rob, Peter, and Natalie Lawyer Chick. Thank you for being you, EDB. Thank you for being, wait, I didn't mean to do that. Thank you for being you. Thank you for the super chat. And yes, if you wanted to be a transcribing court reporter, I don't see where the conflict would be unless there's an internal conflict in your field. But you can be a court reporter for depositions, for certain type of cases, for civil cases. There's a lot of avenues for court reporting, and there is a massive court reporter shortage in most states. And some of the states, I know LA County is doing this. I think most counties in California are. There is a waiver of tuition for court reporting school because they need them so much. And there are some signing bonuses.
I thank y'all. You can.
There is waivers of tuition, and there are signing bonuses for court reporters because there is such an incredible shortage of people that can do transcription. And I know people think, oh, the machines will just do it. The machines can help, but the machines are not just going to do it. So if anyone's like, hey, that might be interesting, look into what your state has going on because of the shortage. And then you can choose where you go into court reporting. Not an easy job, but you don't have to do it in court like this. There are ways to do it at depositions, at qualified exams, at things like that. So it is a hugely, hugely needed skill, but it is a physically and mentally demanding job. But I think rewarding and interesting.
Members of the jury, thank you again for your patience. We had some issues I had to address with
Also, court reporters are the most fun to go to lunch with. Just saying.
counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that.
That was wild, by the way. We'll get to a summary. This witness is still on the stand. The jury is now back in. They've done hearings. The court found a discovery violation, which I think was out of an abundance of caution. The court's not going to strike the witness or the testimony because Owens didn't want it. They would have stricken that one last question, but Owens said, no, I want to get into it and cross. And if Owens crosses like he did in that, I think he can go a long way to make it look like this expert is hiding the ball from him. And I think that is going to be interesting to see if Owens can make that cross as good as he did it in the depo that the court allowed him to. The court is doing everything they can to give the defense all of the opportunities and did that here. I was actually surprised that the court found there was a discovery violation. I think that her testimony in court and what she said in the transcript was in line with each other. So I'm surprised, but again, I think the court has really gone a long way out of their way to give the defense a tremendous amount of grace. So
That you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
they put their
Statement
hands in
moved
the
to strike
air.
the last response as non-responsive.
What?
Approach.
You gotta be fucking joking me, counsel. Mr. J, you did that entire hearing, and then you get up and then you ask the court to strike the last question as non-responsive. Are you kidding me? What are we doing? Ow, why couldn't you have done that before the jury came back in? Couldn't you have given them a heads up? Mr. J coming in with, can we strike that last answer as non-responsive? Why? So they can't get into it and cross because now you've seen the smoke that they're bringing? I'm shook. Mr. J's like, can we strike it as non-responsive?
Bruh.
Also to the law nerd that sent me the big goat, thank you. It is a continuous scream, by the way. This goat does just. That's the XL goat scream.
Your objection's overruled.
All right. Here,
Owens objected. They struck it anyway.
irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or
God.
BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's been asked and answered.
Overruled.
The answer was the answer wasn't stricken on the
And
record. He didn't
what
say.
particular part of her
He might have stricken it at sidebar, but he didn't tell the jury. He didn't tell the jury, please disregard the last answer. So even though he overruled the objection, I wonder if he overruled the request to strike because he didn't tell the jury the last question was stricken, but he did move to strike the answer. But the court didn't say on the record in front of the jury if it was stricken or not. And then he said asked and answered, and now we're getting back into it. I don't know what's happening because I don't know
statements
what happened at
about the
sidebar.
incident is that
The whole part where she's
Hold on,
describing.
I've made this terribly disjointed. Let me back up. I am stunned. I am stunned at this morning. What the fuck?
PTSD or BSS.
No, we got to back up a little more. Emily, stop it. Back up.
Opinion.
No. I can't even operate my keyboard. I'm just pushing buttons.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's been asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek
This
and
is
that
so
they were having a
clunky.
good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we proceed back?
Yes.
Oh my God, this is so clunky for the jury. I'm trying to take notes as fast as I can. She's pinpointing with Sarah the things that she thinks are not consistent with PTSD and BSS. The witness's face to the jury. Did you guys see it? She was like, "Meh." Oh my God. Well, on day 5, this trial's just popped all the way off with these attorneys. Sarah Boone has sat there and done nothing but say she's pleased with her attorneys, other than her testimony, which was sometimes wild in the things she said, but restrained. It was not melodramatic. It was not. It was restrained. And now everything is popping off with this witness, which I think only leaves the impression to the jury that either this is important or something is going wrong. And I wonder if they feel like either the defense is trying to hide something or the prosecution's trying to pull one over. You never know how the jury feels when stuff like this is going down, but there is a risk that the jury starts to feel like, what is the state up to? But they could also feel like, what is the defense up to? Because something is being hidden from them. And it's going on and on and on. Because now we've got another extended sidebar while this witness is on the stand. Yikes. An extended sidebar.
Counsel, outside of y'all's presence. Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence.
No!
Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Jury out. Chat, I grant your request for code red. I grant your request. Request granted. Request granted for code red. For those of you that are new to the chat, code red is our DEFCON level, what the fuckery. And the bumper for code red is beloved, but it is flashy. It has music. The flashy will end when the music ends. If any of you are sensitive to that, just know that it is flashy. And the flash ends when the music ends. We're going to code red. We have no option. We have no choice. We are compelled. The power of court compels us to go to code red. So DEFCON what the fuck incoming. In 3, 2, 1. I mean, or once my Wi-Fi connects to my lights, because my my tech is not working, and neither is my Stream Deck. Don't worry, I'll turn the lights red the second that my light system decides to come back online. Just in your mind, we're red. It's synonymous. I use red and pink synonymously.
Madam Court Reporter, when you're ready.
It was less dramatic than I would have liked. They're doing read back again. There we go. Madam Court Reporter, when you're ready. The jury's not going to remember this testimony because it is so clunky. And I don't know if that's Owen's strategy, but it's not smooth testimony, and it's going to make it hard to remember what's going on. Oh my goodness. I know. The one dude from Trial Ad that showed up today is having the best day in court ever. We're doing read back again. Zoom, zoom, zoom. I'm so glad we can zoom. The court reporter, it seems like, is clarifying where we're reading back.
Just read it from the question, answer.
The judge
question,
has his
objection. Just
glasses
have
down on his nose.
We can buttress it.
We're in serious judge mode.
Go ahead.
At sidebar, they must have asked for readback. They are again trying to clarify who the fuck knows what. Maybe the readback will help us clarify.
My Mr. J question, all right? Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or BSS have any relation? Mr. Owen's objection asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
So this is readback of everything from the time the jury returned a minute ago.
It's the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat. It is a question for the jury. This expert can express opinions on science, on medicine. but
Now
not
he's
on
got a
the
good
ultimate
argument.
Issue of fact, and explain to the jury that this defense doesn't qualify. That you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
Response.
Owens is making, finally, he got there eventually, a very important argument to the defense, which is the expert cannot render an opinion of the jury. So he's saying the expert is invading the providence of the jury or rendering a legal conclusion, that the expert can't say, hey, jury, this defense doesn't apply, you should ignore it. She's allowed to give an opinion about Sarah Boone's state of mind because the defense has experts giving opinions about Sarah Boone's state of mind. Her opinion, it seems, is that she doesn't think PTSD or battered spouse comes into play here because Sarah's own words indicate that Sarah was not in fear, and that's what she's getting towards. But he's saying, no, that is ultimately a question for the jury. So the more he objects, the more he gets closer to a legal basis. We'll see what the state says. But it's also absolutely chopped up this testimony so much that I don't even think the jury's going to remember what this expert said. And that can be effective as well. Owens is throwing it all against the wall. This is why you need an attorney, because Sarah Boone would not have accomplished these arguments herself by any stretch. Let's see what the state says.
Not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called battered spouse syndrome, to kind of help explain
To negate the
a
defense.
portion of the justifiable use of deadly force or non-deadly force instructions.
Which is
He's
what
not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time despite his mental illness because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, you know, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
So what the state is saying, look, the self-defense goes to, was she objectively, not subjectively, objectively in fear when she zipped George into the suitcase? Because her defense is, I was in fear, so I did what I did out of self-defense. The defense brought in experts to say she was in fear because of PTSD, because of the IPV, and that is why, though others might not see that as her being objectively in fear, it makes sense she's objectively in fear because of this. Changing the lens you look at the self-defense through. And the state is saying, yes. And we get to rebut that and say, if they get to say she was objectively in fear because of this, we get to come in and say, right, but that doesn't apply here. She was not objectively in fear because of this. So the state is saying this is a battle of the experts. This is not taking a question out of the jury's hands. This is rebutting the affirmative defense. All right.
It's totally wrong.
Owens just said it's totally wrong. Did he stomp his foot at the same time?
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper?
The expert is saying she doesn't believe that Sarah perceived a risk of harm based on Sarah's own words. He is splitting hairs in a way that is clever.
Proper legal opinion under 90.703.
And the judge is like, how is this an improper legal opinion?
Everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense.
The judge also just gave him the objection. Did you hear it? It's under this code section that it's improper legal opinion. The judge just put it right in there because he was getting there, but the judge is like, let's define the statute.
And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant.
The judge is now trying to shut this down so Owens doesn't keep doing this. The judge is like, okay, I've heard you. We're shutting this down now, and here is all of the law.
Case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer.
The prosecutor's like, where are we?
Okay, thank you.
What are we doing?
He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
What?
Basis.
What?
It was asked and answered.
What?
Overruled. There was.
What?
Bruh.
And the state was like, I'm going to have the court reporter read back the last question and answer, and then I have no further questions. Owens objected and said it was asked and answered. The jury doesn't even know what the fuck happened with this witness because it's been so choppy. And the state is like, that's all. Shocking. State, you have to have other questions. You have to have other questions. Okay.
There's a pending objection. I'm gonna allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with after the
Owen's
state
just trying to buy
advises the
time
jury
right
in
now.
open court. There are no more questions. Let's go ahead and bring back in our panel.
Oh my God. The judge is just like, no, you're starting your cross. He's finishing his direct. He's what? The prosecution's asked, what, 4 questions? Does the jury even know what this expert has said? Do we remember what the expert has said? And then Owens is like, can I get lunch at least before cross-examination? And the court's like, no, you're going to fucking start. All right, I'm going to zoom till the jury comes back in, and then the state has
The jury, again, if you could
one
raise those
question?
hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
I can't believe they're not going to ask a handful more questions.
Question by Mr. J. All right. Irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or ESS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and ESS have any relation? Mr. Owen's objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that?
Oh, she's reading back the whole thing.
The whole part where she's describing the part of about playing hide and seek. They were having a good time. They were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
There
Any
was-
cross-examination?
There
You may
wasn't
proceed.
even an answer to that one. Why? What is the state doing? The state's just like, yeah, we're good. I think the state is misreading this entirely. I think the yeah, we're good is overconfident. Wow.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview.
I need a
of,
nap.
The defendant. I had a.
That's the 2-hour interrogation with Detective Lowen and Detective Copson?
It was an interview. Yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony
preferable.
before expressing opinions here today?
Overruled.
It's preferable.
I did not have time to do that.
That's the
Did not
reality.
have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
She's like, the state pays me
You
for
said you
4 hours.
considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
What? That calls for legal conclusion. That calls for a legal conclusion. What is happening? That actually calls for a legal conclusion about relevance. This doctor is like, great. So if you're sitting on the jury right now, what are you thinking about how this is going? Oh my God. And I'm not surprised she didn't watch the testimony because she couldn't come and sit in court and do it because of all the other work she has. That's
That you were provided.
That's generally done in civil cases when there is more money for the experts. I've not seen most state experts have the time to do that, by the way. That's not unusual or uncommon.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
Another question, sorry.
So then the state inquired and asked if the text related to her opinion in the case.
Did
She
it
said no.
apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024.
That's what she said.
22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
She
You're
already
going to
did.
express some opinions about narcissism, whether or not she had...
Yes.
I feel stressed. Judy, you got this? That's amazing. I have not done that yet. Judy is talking about Midas Merge, who is a sponsor of the channel and a game that a lot of the Law Nerds are now playing. Would I say competitively? Collaboratively. This is wild. So I'm beginning to wonder if the state cut off their direct to cut off the defense's cross, but I don't know if it's going to work well here. Generally, they are, with experts, a little bit more latitude, even if it's not within the scope of direct. But she didn't give a ton of opinions. She said that PTSD and battered spouse didn't apply here based on Sarah Boone's statement. That's really it. I don't even know if the jury's taken that away yet. So it's wild to see now that we're getting the objections saying, no, Owens can't elicit those opinions from her. And Owens wants to, because in that Proffer and Depo, she said she thinks that Sarah Boone has BSS, and the state did not elicit that, I think intentionally, because I think Owens took away a W on the Depo of this expert. And I think the state is trying to put a tourniquet on it. Oh my goodness, this is a long sidebar. Like a long, long sidebar. Okay, well, I'm gonna have to zoom a little bit more.
Like the
All right,
text Boone on...
back up. There we go. It's a long sidebar.
Ma'am, is it fair to say,
Oh, jeez.
in your evaluation of Sarah Boone on October the 2nd of 2024, that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent.
She didn't know who sent each text. So the state is going to try this outside the scope, and the defense is going to get latitude on this because it's the state's expert. So if that's the game the state's trying to play, it's not going to work well.
The text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition. You
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes, that's
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it, if you just refer me to the page.
Just a moment.
We know those texts are coming in later. That's why he's going down this route.
You got it?
I do.
Page 14. My question is at line 3. Your answer begins at line 5.
So she's saying they weren't relevant to her because she wasn't sure who was sending what or saying what because she didn't see
Correct.
whose hand it was.
And you agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
This is such a mess. I don't know if the jury's going to be able to take away anything, and that might be Owens's game plan here, and it might actually work. Or the jury might be hyper focused on this witness because this is the most fighting over testimony we've seen. Not all jurors tune in, but when somebody wants you to not hear something, aren't you just like, excuse me, there's tea. There's tea. What is it? And why do you not want me to have it? Like, do they tune in more or do they tune out? You let me know how you're feeling. Are you more focused or less focused because there's so much fighting over this?
Dr. Werner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to voir dire?
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14. My question
Wow.
is at line 21. Your answer is at line 25.
What's in the text messages? Chat, don't tell me I'm not asking for spoilers. Does it feel like the defense is trying to get ahead of the text messages to try to tell the jury, hey, these text messages aren't relevant to this doctor. They shouldn't be relevant to you. Is he trying to get ahead of how bad the texts are going to be when they come in later today?
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I
talk.
can read my
First, you
complete
said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Werner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when
I'm
I
gonna
asked
let you
you
finish.
if there was anything in the text messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time,
Just looking at the jury being like, this
Dr.
shit.
Werner, at the same time, you expressed that they had a volatile relationship.
This Owens has not shown up for the entire trial. And at this point, Owens is like, ma'am, back with me. Owens feels like Owens is feeling himself.
That is not the totality of.
All right, I'm going to back up and I'm going to try to stop pausing because I want to hear it all fully too, but I'm shook.
But that is not
All
my
right.
complete
Now,
answer.
at the same time, Dr. Werner, Dr. Werner, at the same time, you expressed that they had a volatile relationship.
Oh,
That's not
trying.
the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
He's like, I'm gonna get there.
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship, and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Isn't this
Right.
experts are allowed to rely on hearsay. I think this is bad for the defendant, but experts are allowed to rely on hearsay, but you generally can't elicit that hearsay into the record. So Owens is now, the prosecution hasn't objected, but Owens is now asking her to read the transcript of statements that Sarah Boone gave to her that she relayed in deposition, which is hearsay not offered by a party opponent, which shouldn't be coming in, but whatever, because it seems that we've entered the land of whatever. And so now they're talking about Sarah Boone cursing at the victim and calling him a fucking idiot, which is probably why the state didn't object, because they're reading it going, I don't know, that's good for you. And it's going to come in later.
Or either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship, and that she text messaged calling him an idiot, a fucking idiot, for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse
She
syndrome?
didn't say that. She didn't.
We object. We need to approach.
That states facts not in evidence. She didn't say that. She said that out of the presence of the jury, but she did not say that in the presence of the jury. That opinion was not elicited within the presence of the jury. So now we've got the reverse problem from earlier where the defense said she's running an opinion that we don't know about. Now the state's like, you're eliciting questions about something that's not in evidence. Oh boy. I wish we could see them at sidebar so we could see them come back. It would make it much easier to zoom. Okay, I see the outline of Owens's jacket. This is a wildly long sidebar. How long before? How's long?
Given you throughout.
I was just about to say, how's long before they just kicked the jury out? Now, apparently.
I'm going to give you a similar instruction that I've given you throughout the last couple of days.
Oh, shit. Ladies and gentlemen of the jury, we're going to take this up over lunch.
All right, members of the jury, it is 11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up.
Oh my God. And yes, we're like a half hour behind. I keep pausing. We'll get caught up. We're going to start
Jurors,
right
you
on
must
time.
not conduct any investigation
After
on your
lunch.
own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
So an hour and still an hour from now. So they're taking a lunch for an hour from now. They've had 5 minutes of testimony today. I mean, that's hyperbolic. Maybe it's been 15. They've had like 15 minutes of actual testimony today if you go back and clock it. This is so fucking wild. I imagine they're going to do more work
Y'all
on the
may be
record.
seated.
Yeah, y'all sit the fuck
State,
down.
anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
My head hurts. We're gonna resume this fuckery after lunch, I guess. So the court's on lunch break. I'm going to do my best to summarize, and then I will be back right at 12:30 Central, an hour from now. So it'll be 1:30 local time Eastern, 12:30 Central. So for those of you who are like, what is that in my time zone? Whatever time it is where you are, an hour from now. So I'm going to try to summarize. I'm going to answer some of our questions, catch up on super chats, and then we're all going to take lunch. I'm going to feed my Snorlax. Yes, I play Pokemon Sleep, and I'm just dying. So if any of you need to go rewatch that smoothly, I will also link the court feed down below if you would like it. So we can link the one that we've been using from WKMG News 6 Orlando. If you want to go grab that, because it has closed captioning, it doesn't have things ticking across the bottom that make me dizzy. That was wild. That was wild. Jamie McWay said, and as someone who grew up Catholic, I get it. Jamie McWay said this jury is starting to feel like they're at Catholic Mass. They have not been asked to kneel yet, but there is quite a lot of up and down. So they've just been like, sit down, get up, get out, get in. They've gotten their steps in today in this courthouse. And the jurors are probably looking at each other because they can't talk about the case. The jurors can't even look at each other and go, what is happening? They can't talk about this until the end. Wait, can we just watch the judge smiling? It's nice to see that he doesn't feel like he's dying inside. Can we just go back? Can we go back to the judge looking happy? I don't know what's happening. This has been a wild morning. It is a lot to keep up with. I'm going to have to rewatch this at some point. It's hard for the attorneys in real time, but again, in real time, they're zeroed in. But this is a lot to take in. It's why the judge has taken periodic pauses saying, pause, I'm going to go and review the case law. I think the court has been incredibly considerate of the defense here. The court has given the defense some cues when they're like, the legal grounds are this. I think even when the defense doesn't hit the nail on the head with the objection they're making, Owens does not state legal grounds for his objections, which annoys the court. But even when Owens is not stating legal grounds, we're still seeing the court, if there are legal grounds, give them the ruling, which is appropriate. It's frustrating at times because it's like, Owens, come on. But the judge, I think, is protecting this case because at the end of the day, whatever happens, I think the judge wants this case to be done once and for all, whenever it goes to appeal. But let's try to summarize. And I don't remember well what the actual testimony was because it was so chopped up. And I imagine for the jury, it feels a little bit that way too. And they're just more, I would be more distracted by what's going on at the sidebars and everything than I would be by the testimony. Oh boy. Do we need lip gloss? I don't even know what I need at this point. A snack and a nap. Well, I think I said when I started stream today on day 5, October 24th, 2024, that this trial had gone smoothly till now that the attorneys have worked well together, that things had been moving right along, and I jinxed it. Because the second we got into the state's rebuttal, all of the wheels came off. More time was spent today with the jury out of the courtroom than the jury in the courtroom. There were so many sidebars. I think that the witness on the stand, the state's expert, gave maybe 10 contiguous minutes of testimony, maybe a little bit more. It was difficult to follow because of the amount of objections. The defense is fighting everything this witness says. And it's because it seems that what the state's witness is testifying to, and I say seems because between all of the sidebars, arguments, and everything else that happened, it is hard to piece together what this expert actually testified to. This is my best guess, even after multiple readbacks, is that the expert from the state is testifying that based on Sarah Boone's recitation of the events to the expert in the evaluation, that it is the expert's opinion that PTSD and battered spouse did not come into play here because nothing triggered Sarah Boone that day. I don't think the expert even said it that clearly. But that Sarah Boone's testimony about what was going on that day, not her testimony in court, her statements to the expert in the evaluation indicated that there was no triggering event that day. And so PTSD and BSS don't come into play. But again, with all of the interruptions, I don't even think it was that clear. So I think what the state elicited was that she does not believe that Sarah Boone suffered from battered spouse. She said no, because she didn't have enough. No, it was PTSD. She didn't think that Sarah Boone gave her enough information to determine whether or not PTSD was at play here. And she did not believe that PTSD and battered spouse were at play for this incident based on the way Sarah Boone described it in her evaluation. There was a ton of off the record, well, outside the presence of the jury conversation, not off the record, where Owens is fighting to keep this expert's opinions limited and out. And then he's just opening up all the doors on cross, which he just started before the lunch break. We pinged. Thanks, guys. Thanks for subscribing to the channel. Appreciate it. We're moving towards 800,000. Thank you for doing the YouTube-y things. I never ask. You guys do it on your own. You're so amazing. So thank you. At the longest argument outside the presence of the jury, Owens was arguing that there was a discovery violation, and we ended up having a discovery violation hearing and a deposition of the expert and a proffer of the expert's testimony. The defense is arguing that the expert rendered an opinion in court that was not given in deposition and was contradictory to what was given in deposition. The state said, no, this is in line with what she said at deposition, but she didn't answer my question specifically. So I was expecting her answer to be this, which she said in depo, and this answer was slightly different. The court found that there was a discovery violation, which surprised me, and found that it was inadvertent, but that it was not, that it was inadvertent, but that it was substantial, and there needed to be a remedy. The defense asked at one point to strike the entire expert. And the court's like, that's a draconian remedy. I'm not going to do that. But would you like me to strike the answer? So do you want me to strike the answer that the jury's already forgotten because they've been out of the courtroom for so long? Do you want me to strike the answer that you don't think, that the expert doesn't think that PTSD was at play here, or that there was enough information for her to determine whether or not Sarah Boone was suffering from the effects of PTSD? And Owen said, no, because I'm going to get into it at cross. So there was like an hour of them going back and forth on the record. The court found a discovery violation for the state because the answer was different. The state, it found it was inadvertent because the state was like, we thought she was going to answer this way. It was slightly different. And then the court said, the remedy is we can strike the answer. And Owen said, no, I don't want you to strike the answer. And the court's like, okay, then I will allow you to depose the expert. Go ahead. Ask the expert all the questions. So Owens asks her a handful of questions and then sits back down. The court's like, are you sure you're done? And then Owens gets up, and I thought his questioning of the expert went badly for the expert. Owens was like, well, what else did you not tell us? And she's like, if you answer a specific question, I'll give you a specific answer, but I'm not just going to answer a catch-all question. So Owens actually said, so you said you needed more information and you'd give us this testimony late, or give us this information later. And she said, well, I rendered that opinion after my interview with Sarah Boone, and I actually told the prosecutor as we were leaving the jail. But it seems that the prosecutor didn't retell that to the defense, which doesn't look good for the expert. So then They get back on the record. We get into cross-examination, and there is sidebar after sidebar after sidebar. This testimony might be completely worthless to the jury, or it might be the most fascinating thing that has happened to them in the last 5 days. It has been hard to file. It has been wild. It has been completely off the rails. We have seen the judge get frustrated. The expert witness has been sitting on the stand the entire time they're arguing about her. She looks frustrated. Occasionally she looks at the jury and is just like, he's doing it again. He's just doing it again. And I am just stunned as to everything that's going on here. I'm surprised that the judge is ruling about the discovery violation, because I think based on all of the readbacks they did, that it was in line with what she said in deposition. I think the court is, if the court is seeing a scintilla of a whiff of a LaCroix of indication he can grant the objection, he is. And I think the court fashioned a fair remedy to allow the defense to voir dire it or to depose it in court, allow him to ask the questions of the expert before cross-examination. And that's the remedy. And so now Owens can't say, I didn't have an opportunity. The opportunity is now. She is here. And then Owens tried to stall his cross-examination until after lunch to start to put it together. So now that we are at lunch after multiple sidebars and maybe a minute or two of testimony, we'll see what happens after lunch with this expert. I don't think Owens is done, because the state did not elicit that this expert does not think that, or does think that Sarah Boone's suffering from battered spouse or the impacts of battered spouse. The state didn't elicit that on direct. The defense was just trying to elicit it before lunch on cross. She said it in her deposition with the defense, and they haven't had a chance to get into it. These legal parties are going to be working so hard over the lunch break. Are they going to eat? Maybe not. When you ask why lawyers are so cranky, half the time they're dehydrated and hungry. So do I think they'll have time to eat over lunch? Not much. They're going to be working over lunch quite a lot, because this could go well for the defense, but this could go badly for the defense. So they've got an opportunity. We'll see what they do with it. I am wondering why there are moments where the state just seems to kind of give up. I don't know if they're overconfident in their case, but the state at times has just been like, okay, fine. And I'm stunned by it. Just stunned. But we'll see how it turns out in the end. This is why we watch it happen, right? You can look at the spread. We're going to get to questions in just a second. You can look at the spread and be like, yeah, I know Vanderbilt's in the SEC, but there's no way Vanderbilt's beating Alabama. And then Vanderbilt's fucking pulling down the goalpost and marching them down Broadway and hurling them into the Cumberland because they beat Alabama. Sometimes you just have to put it on the field, and that's what's happening with this trial. Sometimes you have to put it on the field because you never know what's going to happen at the end of a day. Sometimes Vanderbilt beats Alabama. And that's why we're here. So, with all of that, let's get to questions. I'm so tired. I deeply apologize to all of the Alabama fans in the chat. I'm sorry if we have pointed out pain or wounds. After lunch, I will go ahead and pick on Ohio, Michigan, and Georgia. Anyone else needs the smoke? USC probably needs the smoke. Well, does USC have a team this year? But we'll pull up some other college football team. The camera's still running in court, and we just are getting like the top of the judge's head. So while I'm letting the court feed run during the lunch break, I am so distracted by the court's head just bopping along on the bench while he is in court. That's absolutely hilarious to me. The judge is just kind of bopping along. We're going to answer some questions. So I will, don't worry, I'll slander the entire SEC at some point. I mean, except for Tennessee. I mean, I didn't go there, but Jacqueline in the chat said, does USC have a team this year? I'm so here for that. There will always be. And by USC, I am referring to the Trojans, not the Gamecocks, because USC. For the international audience, what is the SEC? It is a college football conference. Is it Southeast, technically? It is the Southeastern Football Conference. For those of you that do not follow college football, A, I understand. B, I moved to the South, and it is a huge part of conversation. Also, I love college athletics. It's a lot of fun. So when we're looking at college athletics, they have moved around all of the conferences because some of the teams wanted, I don't know, more airtime. The whole changing up of the NC2A with the name, image, and likeness has caused some wild outcropping, but you know, the Pac-12 teams have all moved around and they're like, hey, we're going to get into other conferences. Like Texas has moved conferences and they're like, we're UT, and Tennessee's like, lol, roll Rocky Top. You're not UT, we're UT. They all have the same colors. Apparently horns down is like allowed now. Didn't used to be allowed. The madness in college sports is Bravo drama for sports fans. So for sports ball fans, the drama within the NC2A feels akin to me to Bravo, fucking Bravo. There is so much drama. Mary Claire in the chat asked, I'm still learning and don't really understand what is meant by a proffer. I love these questions. We are here to make the law understandable. It's generally that they want to know what's coming. It's a preview, if you will. We want a preview of the testimony. Tell me what you're going to tell me outside the presence of the jury, so that if anything goes badly, when it's in front of the jury, in court, they will say you can't put the toothpaste back in the tube or you can't unring the bell. I say you can't put the shit back in the horse. There's a long story behind that. It's OG EDB lore, but you can't put the shit back in the horse. So if the jury hears it, there's no undoing it. And sometimes if the jury hears it, it is grounds for a mistrial. So instead of doing that in front of the jury, they ask those questions outside the presence of the jury so they can say, yeah, you can't fucking say that. And you can't say this. And you can't say that. So it allows them to ask those questions outside the presence of the jury. We see it with experts a lot. We saw it in Depp v. Heard with almost all the experts. They wanted to take the expert on voir dire and ask questions. Proffer is what's your testimony going to be. So it is a preview. I think that is the best way I can explain it. Goldie said, question, if it's Madam Court Reporter for a female, what would it be for a male? Gentleman Court Reporter? I think it would generally be Sir Court Reporter, but it depends on the judge. So not every judge imparts Sir or Madam. Sometimes it is just like our court reporter, but Sir or Madam or Mr. Generally. So it just depends on the court. It's just like ladies and gentlemen of the jury. Will we see that change? Maybe, maybe not. Crocker, thank you for the gifted memberships, but it is very much ladies and gentlemen of the jury and humans of the law nerd chat. So, question, is this case about to be Baldwined? I don't think so. I think the court's remedy here was good. Notice that the defense never asked for a mistrial. Never asked once. I think the defense, they know they can. I think the defense thinks it's better for them to get this to the the jury. Kedora, I brought this up again because I forgot I'd answered it, but yay. You got a lot of court reporting today. I saw a lot of questions, speaking of court reporters, a lot of questions in the chat asking when the court reporter does read back, who transcribes the read back. A lot of court reporters have a audio device on their devices, but oftentimes the transcript will just read back given from line to line, but sometimes they will use the audio and then transcribe their read back. So it just depends on the court. But any court reporters in the chat, you can chime in on how courts do it where you are. So my experience is limited to the courts that I've worked in. Let's see. Bat Rendler said, first ever super, don't like to have to super chat for a question. You don't have to. Anyway, is it cause for mistrial appeal when an expert, by now more than one, is not qualified as an expert by the court? You don't have to super chat for a question. We get to questions from the chat and from super chats back and forth, depending on what I see. If you put a question mark or at me so my name highlights, it's easier for me to catch. When we have 30,000 people in chat, I will not ever get to anything, including all super chats. Sometimes those go unanswered. Sometimes they get answered. But is it cause for mistrial appeal when the expert, now more than one, is not qualified as an expert by the court? I don't know the specific rules in Florida. I am sure that Peter over at Lawyer You Know, who is an attorney in Florida, has either addressed this or will be asked this a lot, or has probably talked about it on Twitter, where he's fairly active. I am not. But different courts have different procedures, and all of these experts have testified to things within their education, training, experience, but I haven't seen any of them be actually qualified as an expert, which is odd to me. Is it grounds for appeal? No. Well, I guess I should say maybe. It just depends on the court and what is allowed under Florida law. Courts are very specific. Chris K said, Emily, thanks for covering the trial. Can we do muffies instead of muffins? Are muffies mini muffins? I don't know. Doug says she reminds me of the hotel receptionist from the Home Alone Lost in New York. I don't remember that movie well enough. FYI, Chris Bowman said, FYI, the organization this witness works for has a negative reputation here in Gainesville. Not sure if it will matter. I don't know if it will matter either, because I think the jury's going to make up their own mind based on how this expert testifies. Some jurors, when she turns to them and smiles, might find it off-putting. Some of them might find it endearing. Sparkly Cupcake said, I listened to Sarah's testimony again and caught something new to me. Prosecutor asked if she had all the time in the world to call 911 while he was in the suitcase, and she answered, if I wanted to. Interesting. It's what picks up to the jury, but that is interesting. And she didn't want to call 911. I think that's, at least to me, that seems clear. Emily says, he keeps saying we need more time, but it's been 4 whole years. You might not have had 4 years, but you're a lawyer. No, 10 for her. It's, the defense on this case has not had 4 whole years. The defense attorneys have had like 45 days. So I understand they keep putting it out there and the judge keeps saying, well, you have right now. So, let's see. Diana said, I need to hear about Sarah Boone and George's first date. That was a wild description of their first date from yesterday. I was like, I think I just stood here going, what, wait, what? Michelle, thank you for the 5 gifted memberships. For everyone saying that my brain just exploded, yes. Bulldog Mom says, EDB watching on a 16-hour drive. Thank you for being you. You're welcome. We'll get you through that today because, yep. Cumulus Cloud said, Q Carrie Morrissey objection. I'm confused. I really want to know what the court thinks when we go through that entire fight and Owens is like, oh, well, I'm going to talk about it on cross. What? Sir, what? What are we doing this for then? What are we doing this for? Richard Huffman's Stealth Badger said, in a just universe, Emily beating her desk with the Federal Rules of Civil Procedure shouting there is a book would be on loop in a museum. No, it doesn't need to be. I don't have the Florida Rules of Civil Procedure, but Owens, what is the grounds for your objection? Sir, somebody passed him a notebook and was like, discovery violation, or a sticky. Most of the time in criminal law, you end up doing your cases by yourself. There's no one to pass you a sticky. It's just you. When you learn how to think on your feet, look, this is where I think ADHD can be a superpower for lawyers that operate in court. Death for lawyers who can't hyper-focus on like appellate law. Appellate law is a different type of neurospicy. But for trial work, the ability to process lots of incoming information and think on your feet is a huge advantage. Being on time and time blindness that also can come with being neurospicy, disadvantage. But that processing speed, the fact that our brains work fairly fast, is good. But the overstimulation, bad. So plus and minuses. But Owens was processing a little slower and then he picked up speed. And it was a lot. Like it was a lot. Mom28 said, I'm late to the party, but isn't this a defense witness? No, today was all the state. Severe expletive. That's the one you can't say on YouTube that starts with a C. I'm teasing. Did young Emily ever want to or aspire to be a judge? No. Notice how little judges talk. I mean, they read jury instructions and stuff. But no. Also, decision fatigue is real and judging is decision making all day long. Also, it's a ton of paperwork, like checkbox paperwork, like a ton. of really picky specific paperwork. And if you don't do the paperwork right, like shit gets really fucked up and has huge real world consequences. So the pay increase is a bonus, but the not being able to be an advocate is a negative. And then there's a lot you can't do as a judge, like a lot you can't do. So it very much changes your professional relationships and your personal relationships. And my face has subtitles. This judge is so great. I would be sitting there going, counsel what? No. My grandfather was like, Emily, I think you should be a judge. I'm like, look, man, I like doing this. I have run commentary on things like literally my entire life. My mother will tell you it was exhausting, that it was a constant stream of commentary. TV shows, movies, sporting events, you name it, there is commentary. I am quiet when bands are playing during band competitions, but even then I'm like, oh, I really like those swing flags. Wow, the costumes are good. Why are those costumes going with this music? How did they make the choice on this arrangement? Why are the snares a little bit like constant? So I've just leaned in. I've just leaned into that. Yes, I did have judges warn me that my face would be sanctioned for making faces. I do not control my face well. So I think being a commentator, I think being a broadcaster is probably what I always really wanted to do. And I just didn't think it was like an option for me. So I'm glad at this. Nash said, headed to downtown Nashville, driving from Florida, best barbecue suggestion. I hope to run into you, would make my trip for sure. Unfortunately, I don't know where I will be this weekend outside of band competition because I am exhausted and overstimulated. But Nash, here is my favorite night spot in Nashville. Cross-Eyed Critters is a speakeasy karaoke bar inside the Graduate Hotel. I absolutely love it. Best barbecue, because I am tomato allergic. I do not eat a ton of barbecue. I do like dry rub. It depends if you want hot or not, but I think you should, if you love barbecue, try them all. I do like peg leg porker. But you've also got Hattie B's. You've also got John's. You've also got Party Foul. So there are lots of options. I love going to watch competitive Nashville karaoke at Cross-Eyed Critters. It's a lot of fun. It's kind of a smaller bar. I don't love the big bars down on Broadway just because it's a bit overstimulating for me. There are some great kind of off the beaten path finds, including like winners and losers. So have a good time. Go to Frothy Monkey for breakfast. And if you, Warren will drop, Octonation will drop his Frothy Monkey suggestions in the chat because I love the Frothy Monkey. So have fun with that. There is lots to do. Dusty Cowgirl said, 40th birthday today. Can I go to Goat Scream? Can I get a what? Yep. Michelle L in the chat said, I'm leaning towards manslaughter because I don't think she intended to kill him. Second degree also means she didn't intend him to kill him, if that helps. Also, an ongoing dynamic of trauma isn't the same as situational PTSD trigger. I will do, as we get towards the end of the day, I will read you guys, we'll go back through the law on both PTSD and manslaughter. I think that'll be helpful. For now, I'm going to take lunch real quick. Ari said, how dare you? Tennessee orange is superior, clearly. The Texan fans are going to say their orange is superior. The orange that I wear is Tennessee orange, so we'll go with that. But I went to UMass Amherst, and we were maroon, and I quite liked it. I need to get some more UMass Amherst swag. I don't know where my OG UMass sweatshirt went. I wore that thing like my entire senior year in high school. Like, where's Emily? The one in the maroon UMass sweatshirt rolling around somewhere. Thank you guys for the super chats. Let's see. Kelly, this is a great question, and then we're going to go to lunch on this. Kelly said, if they find battered spouse, are they compelled to acquit? No, they are not. They can find battered spouse and still find in this day, in this moment, it did not negate or call for self-defense. If they find self-defense, it gives them ground to acquit. But they can also take that into consideration and say, you know what, this might be manslaughter. They might decide to compromise on the second degree. Or they might say, yes, this exists. Yes, these things happened to her. But on this day, I believe her first story where she said, everything was great. Everything was fun and games. We were laughing. We were joking. And then I zipped him in and he said something and I got mad. And based on that mad, she zipped him into the suitcase and was like, you know what? Fuck you. Stay there. And went up and went to bed. And if they find that, that can either be a manslaughter or a second degree murder. It's going to depend on how the jury feels about it. The manslaughter is going to be that lesser included. So if the jury has empathy for her, they might say both fit, we'll go with the manslaughter. It feels a little heavy-handed. And Sarah Boone said in her testimony, and if believed, she said she didn't perceive that it was dangerous. The second-degree murder requires that she's not just negligent. Negligence is the manslaughter. It requires that she perceived zipping him in the suitcase as dangerous and then intentionally left him there. And him saying, I can't breathe, seems to indicate that she should have at that point perceived that it was dangerous. So it depends on if they believe that she perceived it was dangerous. If the jury is like, they were both drunk, they were messing around, I think she was drunk, I think she got mad, and I think she walked away, but I don't think she thought he would actually die. I think she thought she would be like, see, fucker, that's what. If they think that, then I can see where they would get to a manslaughter. So we'll just have to see what they think. I think everyone was incredibly drunk. However, voluntary intoxication, I think I paused that weird. Voluntary intoxication is not a defense. But did she perceive the danger? We'll see. And I'm interested to see what the closing is. I'm interested to see what the text messages have. The defense is fighting about those. And what's the body cam going to show? We're not going to get done with the state's case today based on how choppy this has been, I don't think. So we'll see what happens after lunch. We've got about a half an hour left now that I've rambled. I'm going to go get some food, use the restroom, get some water. We're going to take a little stretchy stretch and a snacky snack. And I think you guys should do that too. Tammy said, can witnesses speak to the prosecutor during lunch? They can. And the defense can ask, did you speak to the prosecutor over lunch? So all of you are the greatest. The chat will be open. We will be at lunch for a half hour. When court is back, you bet your ass I'll be back. I will be back. I will be back. I will be back. I want to see this pop off in real time. We'll have Zoom time because I'll pause, but I want to see this pop off in real time. So chat, go enjoy 30 minutes. We will send you a text notification, not a text. We will send you an app notification when we are back. So for those of you that are not yet in the Law & Order app, we have a free app to let you know what's going on in trial. If you are enjoying this case and you want to be kept in the loop as we get into verdict watch, which is probably going to happen tomorrow, you need the Law & Order app, free on iOS and Android. You can change your notifications as you like. If you want to be notified at every turn of this case, go ahead and get the Law & Order app. And then as we cover other cases, because a lot's going on in the law outside of this case, when those things are covered on QuickBits and on the podcast, I'll also keep you in the loop. And if you never want to miss a stream again, lawandordapp.com. All right, guess what? The break's also going to tell you about that. So I'll see you guys in just a minute.
Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Law Nerd, court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during Verdict Watch. The Law Nerd app has all of your live court notifications to keep you in the loop. LawNerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? Don't worry, I've got you covered. Daily trial summaries are dropping on the Quick Bits YouTube channel and on your favorite podcast player on the Emily Show audio feed. Court is still on break, but don't forget to download the Law Nerd app so you know exactly when we're back from break. The Law Nerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days.
On the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state. Defense.
And we are back from lunch. The court is just coming onto the record. So we are
Ms.
just
Boone is seated at
scooting
council's table wearing the same
as
clothing from
we
this
get
morning.
back from lunch.
Are we prepared to bring back in our jury
No.
at this time, state?
Yes, Your Honor.
Defense?
No, sir.
Yes, sir.
Yeah, no, they're not.
I want to make another motion.
Of course you do.
Judge, I've had a chance to read this transcript.
Now that the defense has had a chance to read the transcript, they want to make another motion. So sorry for the jump scare for being back from lunch, but we are back. And yeah, of course, the defense wants to make another motion. I'm not surprised. They said they've reread the transcript. We're going to be in real time. We're just going to let it roll and see. But I am not surprised. The defense is like, well, we've had some time to think about it. Let's see what they want.
Transcript, and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October 4th, 2024 deposition.
Oh, the time for that has passed.
Werner.
Okay.
I thought he was going to be talking about lunch, but he's like, Your Honor, this morning you asked me to cite specific points in the transcript, and now I want to go back and argue it again. This is like the fourth time he's making the same argument. So he is now going back to what he was arguing this morning. The court said, hey, I want you to cite me to specific places and then let me know. And now we're into the cross-examination of the expert and the damage is done. I don't know what he wants.
Yes, sir. I have it in front of me.
May I sit?
Yes, sir.
All right, for Owens to be heard, the court might be a little loud.
Page 38 at the very bottom, line 21. Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you were aware yesterday, so I had to prepare for those and go through that. So
He said this already.
I had not had time to process through all of my notes prior to this deposition today. Page 39. Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge set for October 7th for jury selection. Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know. Maybe we could discontinue your deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and then you have other opinions that are not going to be covered. Then at 13, Mr. J says, what is your position? And at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental
Again,
report, or if there
nothing new
becomes a
yet.
need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury.
Facts.
The jury is sworn in jeopardy attaches.
Facts.
Line 23, Mr. Owens, well, you obviously understand my position.
This is exactly what he read earlier. He has also not stated the grounds for his new motion. Your Honor, I'd like to make a motion. The next thing should be 4. What are you asking the court for? What do you want?
I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward and then you can add to your deposition at that point. If my opinions change
I'm
after
waiting for
having
what's new.
reviewed further. Line 8, Mr. Owens. Mr. J? Line 9, Mr. J, I think you need to plow ahead. This is our time where the court reporter is prepared to give us a transcript by the end of the weekend, and if something needs to be amended, then she can A, issue a report, and then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J.
I want to see
I'm
the judge's
suggesting
face.
that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue. relating to a diagnosis.
He thinks you're
of an
confused.
adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and
Oop, that was me,
formulate
sorry.
any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely.
And, yes, he read this
That
earlier
was
today.
our understanding. I've been ambushed by a new opinion
What's your motion for?
that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William
Over
J.
this.
I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I move for a total dismissal for prosecutorial misconduct.
Denied.
Oh, oh, shit.
And here's the other reason it's
So I make a motion. What he should have said is, I make a motion for prosecutorial misconduct. I want the case dismissed. That's what he should have said first. The court barely took a pause to say denied. And this is why. I've never heard the court speak so fast.
Imminent threat, the ultimate issue of fact. I move for a total dismissal for prosecutorial misconduct.
denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So, from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues. Anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see...
Judge read this shit over lunch, Owens. Don't go toe-to-toe to him. He's got the receipts, man. The judge was like, you know what the fuck I did over lunch? I read 87 pages of this transcript again. And he's like, no, sir, you are misrepresenting it on this record, and the judge is not going to let the record be inaccurate. He has given this defense a lot of leeway. But what he's not going to do is let the record be unclear on this point.
See what she's doing, that she's saying, hey, I got jammed up, I had a deposition yesterday, I didn't really have time between the evaluation and the deposition 2 days later, so you had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
That's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder.
Yeah, no.
That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously.
Yeah, no.
Give me a moment.
The judge knows this case so well.
On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question, well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her case, I guess. Other opinions, do you believe?
The feed stuttered a little bit, which is frustrating, but the feed stuttered for a bit.
With regard to her case, I guess. Other opinions, do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which are in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about Jorge Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished
Because the court ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know if he was going to ambush me at trial. I should have known beforehand.
You've not been ambushed.
That Dr. Werner was going to express, especially related to battered spouse, post-traumatic stress, and whether or not there was an imminent threat at the time of this event.
And the court's addressed that. Court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing. Analyzed the 3 factors as required by Florida law with regard to those and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily. States that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result.
We know that.
Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination, and I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Because now the prosecution's been accused of misconduct, and they are going to want to make sure the record is clear, because prosecutorial misconduct shouldn't just be thrown around. The court also found that it was inadvertent because the witness's answer was, I think, slightly varied at best from what was said in the deposition. So now the prosecutor's like, now you've thrown out prosecutorial misconduct, and we can't just let the record stay silent to that, so we need to be heard. The jury's not in the courtroom.
This deposition did not end on page 40 or 41 or 42.
Thanks for going to the
Owens
podium.
Took a direct examination of this deponent for 68 pages. and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that, starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place.
That's what she said.
As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42, where it's acting like it's concluding and, is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Werner claims that Sarah said he put his two fingers out and I hit them with a bat. So there was rule of completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd, 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay.
Again?
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1, Charles W. Earhart.
Let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here, it's
The judge has given this defense team so much leeway. And now I think he has given them enough rope that it's going to become a problem for them. Like he's giving them too much room and now. So now we've got another motion.
let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that and redirect. Is that clear?
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements, and you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the
She
problem,
better be
as the state
subpoenaed.
pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination.
Well, now we know what happened at the sidebar.
I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed.
So
I'm going
that's-
to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress
Oh, we're not done.
was,
I'm taking care of it, Counselor. Give me a moment.
There is audio coming in from somewhere. The court said he's taking care of it. The jury is not in the courtroom. I'm going to turn that down while the court's fixing it. The jury's not in the courtroom.
Yes, sir.
They are still doing motions before the jury comes back.
Earhart's treatise, section 9.
Same witness is on the stand or will be.
Issue. I'm on page 933.
Oh, he already ruled on this.
Testimony in the form of an opinion or inference otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of fact. And
This is a
in that
re-argument.
section 703.1, it talks about that opinion testimony is not inadmissible.
We've now gone through two different motions. We're on to a third. The third motion, and Owens doesn't say, I would like to move XYZ. He just kind of jumps into it. But Owens is moving now that the expert, I don't know if he's going to ask, I don't know what he's going to ask for, to strike certain testimony or whatever, but he's saying the expert can't testify to an ultimate issue. This happened before the lunch hour. They've argued this entire thing about whether or not this expert has an opinion regarding an ultimate issue in that the jury needs to decide. Experts are allowed to help jurors understand ultimate issues. And when we're running self-defense can go to an ultimate issue, and they have experts and the state has experts. So we are now re-arguing this same thing. Owens went and got the book and is now reading from the evidence book.
Solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony.
Right, that's what the judge said
of
before
expert
lunch.
or lay witnesses
Right.
and is not bound by their conclusions.
Right.
Merely because a witness expresses an opinion to an ultimate issue does not compel the jury to find that the facts to be true. The jury
Right.
will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves.
Right.
Then it goes on.
That's what the judge said before lunch about the ultimate issue. The jury can say, I agree with this expert or I don't. That's why you cross-examine experts with regard to bias and stuff. I mean, legal term and stuff. That was me breathing
The
out.
abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case.
She didn't do that.
Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant.
And they didn't do that.
And I'm on page 940.
He's like, skip some shit.
703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Werner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at council's table.
Yeah.
No, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner.
And that's
whether
not
the
what
sheriff's
she's
conduct
saying.
was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted
Not the
misapplication
same.
or concealment of funds. or the legal obligations of the parties to a contract. Whether the testimony of the expert is a permissible factual conclusion or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with the trial judge.
Sir, you're going to hurt yourself
For
in that
example,
stretch.
the admission of expert testimony that certain investments, it goes on.
Yelling. We couldn't hear you the whole trial, sir. Did you warm up before the reach or
However,
no?
the witness expresses an opinion about the intent of the accused. The opinion, this is the important, one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Werner did,
No.
the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor.
But if I could finish.
Respectfully, Counselor, the citations that you're referring to are not at issue.
My
Fluellen.
God. Oh my God. Oh my God. Respectfully, Counselor, he's just not going to let Owens keep going. I screamed.
But the citations, respectfully, Counselor.
But if I could finish.
No.
Respectfully, Counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting
Danger,
officer
Owens.
to testify that a quantity of cocaine
Danger.
possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble, officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent.
Dude, you're not going to fuck with this judge. You're not going to be able to fuck with this judge. He's like, I know the law. I know the case law. And everything that you're arguing is not analogous to what's happening here. So, judge, just let me finish. He's like, no, I'm not going to let you finish. I'm the judge.
Consistent with personal use and therefore intended for sale was inadmissible.
Which is an element.
644 Southern 2nd 1376 for Gamble and Fluellen 703 Southern 2nd 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines.
Yep.
Based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
No.
If you're just going to be reading from the treatise, I've already read it.
Okay, well,
Your client said this. The expert said, I looked at everything your client said, and based on the words out of her mouth, it is my opinion that she was not in fear. Given everything, it's my opinion. Your expert said she was, but the words out of her mouth is that she was mad. And he's like, if you're just going to keep reading to me, this is not a reading lesson. I read the fucking treatise. No one ate over lunch. They just did this.
I just want to make mention. 'cause
The
it's
judge just
talking
ate that, but
about
that's
does not permit a witness to testify about legal conclusions or
He's gonna
express
do it anyway.
opinions on questions of substantive law. And I was about to finish this section. This section.
The
When
judge
testimony,
is breathing.
this testimony, and I'm on page 947. This
He doesn't give a
testimony may
fuck.
also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force.
Uh-huh.
The testimony from Dr. Werner, and I wrote it down. She said based
Me
on
too.
what Sarah Boone told her, she was not facing imminent risk of harm.
Based on
That
her words.
invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
The judge
Your
disagrees.
objection's been made for the record. The court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains. Just because 9703 speaks for itself. So your objection is overruled as to that issue.
Whatever the
Anything else
objection
we need to
was.
address, Mr. Owens, before we bring back in our panel?
No, sir.
State?
Nothing, thank you, Judge.
Okay, let's bring back in our panel.
I don't believe him. I don't believe him. Chat, how fast? How fast till they're at sidebar? How many questions till they're at sidebar? 2? Mr. Owens, anything else? No. Liar. I don't believe you, Owens. Oh, I see you, chat. 3, 4, 2, 1, 5. All right. I'm going to zoom while the jury's coming in. Unbelievable.
As our jury.
Yes, Your Honor.
Defense, do you recognize our jury?
Unbelievable.
Thank you. All can be seated.
Jury's back.
Members of the jury, welcome back. Turn number 2,
Finally.
back row. He's already ready. You know what's coming. Y'all complied with the court's instructions, right? Thank you. Record reflect all hands have been raised. Mr. Owens, you may continue your cross-examination, sir.
Was the witness on the
Dr.
stand
Werner,
that whole time? She must have
Rehash
been.
it.
I didn't see the witness walk in. I think she probably walked back to the stand before it court panned down. The witness was on the stand the entire time that was going on. My God.
But just for the jury's sake, would it be fair to say that the text messages that you were forwarded by the state attorney for you to review, you did not deem to be relevant to your evaluation?
Right, they demonstrate.
Ma'am, it's a yes or no question.
Yes.
Now, from what I understand, when the state attorney sent you the information, they did not send you any videotapes.
Correct,
So you have not reviewed any videotapes
That's odd.
in this matter.
correct.
The suitcase videotapes, either one of those you have not reviewed.
I have not seen them.
What?
Or any body cam videotapes you have not reviewed.
They're described in the police report.
She didn't watch the interview. That's odd.
My question is, have you viewed any of the body cam videotapes relating to this incident?
I have not seen them, correct.
Prior incidences between the two of them, have you reviewed any videotapes, body cam videotapes of any prior incidents?
I have not.
Have you reviewed the audio tapes related to some of the questioning of Sarah Boone?
I have not.
Have you reviewed the autopsy report?
It's described in the incident report, but I did not see the actual autopsy report.
Now, you're
That's
aware
so
that we have called two experts, Dr. Michael Brannon and Dr. Julie Harper. Is that correct?
Yes.
And you're aware that they are forensic psychologists,
That's correct.
and you are a forensic psychiatrist.
That's correct.
So they didn't go to medical school and you did.
That's correct.
And they don't understand medical issues, so to speak.
I don't have an understanding of what they understand medically.
Do you recall telling me that they don't understand medical issues, so to speak?
They haven't been to medical school, but I wouldn't understand their medical knowledge.
If you would look on page 22 of your deposition.
It's going to be a long day.
Objection collateral.
Approach.
How many questions was it? Who won? Who won? Was that 3? 2? I wasn't counting. Damn it. I don't understand what they do or do not understand. Oh my goodness. I think that was 2 questions.
Objection's overruled.
Dr. Werner, have you had a chance to review your deposition on page 22, starting at line 7?
Yes.
Could you read down through line 11 your answer?
Yes, I'm talking about psychologists in general, not with regard specifically to your experts, which is what you were just asking me about.
Okay, but you would agree, your opinion is psychologists typically do therapy, but they don't prescribe medication or understand medical issues, so to speak.
Correct.
Overruled.
Correct. But I wasn't specifically talking about your experts, which you were just asking me about your experts.
Right. She's like, I don't know what your experts know.
I said I didn't understand, I didn't know what their specific medical.
Right, that's what you said under oath October 4th of this year.
Sustained.
Asked and answered is the objection. Sustained is the proper ruling.
Now, is it fair to say that the majority of your work
This
is
gonna
in the
be-
field of competency to proceed and guardianship evaluations?
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week,
Yes, sir.
so as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the
It's not what you
field
said.
of competency to proceed and guardianship evaluations.
As a forensic psychiatrist, correct. As a psychiatrist, I work 7 days a week on the crisis stabilization unit.
And where is that unit?
It's located in Lake City, Florida.
She
You
definitely
work
wanted
there
to tell
7
him
days a
that.
week.
Yes, sir.
And then you also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluations.
That's part of the, what comes under the umbrella of my forensic work, yes.
That's the majority of your forensic work.
Yes, that's the majority of that's the most common cases that we're asked to,
And then next in line would be sanity at the time of the crime.
yes.
Comes up a lot more
So you would
often than
make a
this.
determination and submit a report to the court as to whether or not a defendant, an accused,
I mean, it comes up a lot
is
more often than this does.
legally sane or not at the time of the offense.
Yes, that's correct.
And Owens, are you
Is it
just
fair to say that you also testify weekly as a treating physician through Baker Act Court?
Yes, that's correct. Every Thursday, we have Baker Act hearings with regards to our individuals who are being held in our crisis stabilization unit.
Is that in Gainesville or Lake City?
No, sir, that's in Lake City.
Now, Lake City from here is north of Gainesville?
Yes, sir, it's approximately 40 minutes north of Gainesville.
and?
Now, I believe you said you've testified in battering spouse situations in court approximately 5 to 10 times?
Yes.
Is that correct?
Yes.
And you often refer to that as intimate violence cases?
Yes.
Now, my understanding that after you had a chance to evaluate my client, Sarah Boone, and I believe you evaluated her 2 days before the deposition, so it would have been October the 2nd of 2024.
Correct.
As to your diagnosis as it relates to her, do you believe that she suffers from a generalized anxiety disorder?
No, sir.
Now, you're aware that she was previously diagnosed.
I think she
prior
said
to-
no, she didn't.
Prior to you evaluating her, she was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed with that.
Did you attempt to secure any other records to us?
Sustained.
Did you diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or physicians come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the symptoms.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or an adjustment disorder?
I had not made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder?
It was probably within the next week when I was reviewing all of the, going through all of the documents in her.
Did you tell anybody that though?
Interview
The issue.
more thoroughly.
Dr. Werner, did you agree you did not notify me?
Judge, may we approach?
Yes.
Right as I put food in my mouth, I thought we had a minute. I thought we had some runway. A week after the depo, she made a decision, and it sounds like she didn't disclose it, but they already did a full hearing on this. So they already did a full hearing on whether or not there was a discovery violation. So now they've approached again. Well, I thought we'd be to closing tomorrow morning. I'm less confident. The state still has like 3 hours of video that they want to get into. Well, video and text messages.
Dr. Werner, you agree that when I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder.
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here today.
Sustained.
Is this the first time you've
The objection
let the
wasn't
parties
proper.
know that this is your opinion?
Boy.
That I believe that she has generalized anxiety disorder?
No.
Or that I believe that she has
Adjustment disorder.
Adjustment disorder, yes.
Now, from your evaluation, you determined that she had a personality trait,
That's correct.
and you felt like that she had a grandiosity issue,
Yes, she has a narcissistic personality disorder trait.
a trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes,
Okay. A lot of people have a grandiosity trait
that's correct.
that are not narcissists.
But I never said that she's a narcissist.
Your expert actually said she had 4 traits. So, or 3 or 4. Owen, she might start diagnosing you. I'm being facetious. He's not. I thought his cross was better at this point during the depo.
Is it your opinion that Sarah Boone has alcohol use disorder?
Yes, that's correct.
And are you forming that opinion based on Sarah Boone's admission to you that she was an alcoholic?
She admitted that to somebody?
She has a history of being diagnosed with that.
With documentation, it sounds like.
She also acknowledged to me that her use had been problematic.
So you formed the opinion that she suffered from alcohol use disorder based on the history that she presented to you.
Counsel, this point is not at issue. with anyone.
At this evaluation?
It was based on the totality of the information that I was provided, so the medical records demonstrating that she had been diagnosed with it in the past. Her ex-husband, in his interview in the police report, described her as an alcoholic, and in her description of herself having a problem with alcohol.
Do you acquire a tolerance over time if you drink on the regular?
That's one of the criteria.
Do people also have a genetic tolerance for alcohol?
They may.
Is he going to try to argue like Sarah Boone wasn't drunk? It's the
Now,
first
as it
time.
relates to battered spouse
That is the first time in court they've talked about the ex-husband describing her as an alcoholic.
syndrome, would you agree that that is a recognized syndrome in the psychiatric community?
Yes.
And you have heard no criticisms of that syndrome?
No.
And you would agree that's a subset of post-traumatic stress disorder?
Yes.
And
At
you
least
would
they got her
agree
water.
that Lenore Walker first developed the theory of post-traumatic stress syndrome?
Yes.
Who cares at this
I think at
point?
the time of this deposition, you were not sure you knew Lenore Walker.
I don't recall that.
All right, look at page 54.
Her face is like, doesn't matter. They're going to approach. I think he's trying to go to whether she is the most experty expert in the world or not. But it's, you didn't even know who Lenore Walker is. Like you didn't know. I'm going to zoom through this sidebar yet again. I'm sorry, you guys. I make full YouTuber apology. At the beginning of the day, I said this trial had gone incredibly smoothly. And here we are. But I guess you can't get through a trial without at least some speed bumps. So,
Dr. Warner, do you recognize Lenore E.A. Walker's book, The Battered Woman Syndrome, as an authoritative treatise on battered spouse syndrome?
I do not, because I have not read everything. I haven't read it, and so I can't say that I agree with everything in it.
she's like, no, I can't say it's authoritative on everything. It's a very expert answer. It's like, I can't. Why don't you ask me what I know? And he's like, nah, I'm not going to do that.
Is it clear to you that Sarah Boone was involved in a violent relationship with Jorge Torres?
Yes.
Do you agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with Jorge Torres?
It's been described that way, yes.
Would you describe it that way?
It's been described that way to me, yes.
Do you have an opinion?
Sustain.
The objection was vague and sustained because he's like, do you have an opinion? She's like, at the moment, I have many. Her face is giving, at the moment, I have all of the opinions. Counsel, all of the opinions. But which one are you going to want? Because if it's my opinion of you, her face is saying, then maybe that's not what you're asking for. Here's the thing that doesn't make sense to me. And this is a criticism of Owen's a bit in this trial, is that he's been a little scattered. I wish we would either get to, are you going to discredit this expert or are you going to use this expert to bolster your case? Her face. Case. Bolster your case. And if you're going to use her to bolster your case, lean into, you're double board certified, you're a doctor, you're this, you're that, you've worked in these areas, you've done all of these things, and you agree that she has battered spouse. Either use her to build up your case or be like, you're just a hired gun of the state, right? Like you didn't even watch the videos. So How can the jury believe you? You didn't even see the videos. So how are we listening to you? Pick a lane, but you can't do both because you try to discredit her and then try to build your case and it doesn't work well.
Sustained.
So you have an opinion that that was a violent cycle between Sarah Boone and George Torres?
It's been described that way, yes.
Do you agree that George Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Well, Owens, you sure stepped into that one. Owens set himself up for that. Do you think that he's not asked his experts that? Do you agree that Sarah Boone was the victim and George Torres was the aggressor or the abuser? Counsel, you stepped right into that question. And the thing is, he had the opportunity before lunch to do a deposition and ask her all of this, and he chose to do it in front of the jury. And this might blow up in his face. We have not heard from Brian Boone again. The state didn't say they were calling Brian Boone this afternoon, and now they might.
The abuser and Sarah Boone.
I'm going to back that up one more time. Wow.
Sustained.
Do you agree?
You have an opinion that that was a violent cycle between Sarah Boone and George Torres?
It's been described that way, yes.
Do you agree that George Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Okay, I'm going to show you what's been identified as Defense Exhibit I. Have you
She
ever
was
seen
like-
this photograph?
I have not.
You see the injuries on Sarah Boone?
I do.
I don't know if this is going to go the way
Show you
he thinks it's going to.
identification H. You see this photograph?
I do.
Have you ever seen it before?
I have not.
Do you agree that's Sarah Boone?
I do.
Look
Are
at
you
this
aware that George
photograph.
Torres
Sustained.
It's not in evidence how those injuries were caused. That's why the objection.
I'm going to show you
Well,
this identification G.
the jury's heard it now.
Have you ever seen this photograph?
I have not.
Did you ever read anything about George Torres using a curtain rod as a weapon against Sarah Boone?
I don't recall that specifically.
You could have asked all this earlier.
Identification F. Have you ever seen this photograph?
No.
So now he's going to go back to discrediting her. She didn't even see the photos. She only saw the police reports.
Identification E. Have you ever seen this photograph?
No.
I guess so. If I'm the state, I'm texting Brian Boone right now and being like, hey, buddy, you free this afternoon or tomorrow?
No.
Have you ever seen the videotape relating to this photograph?
No.
I'm still shocked she didn't watch at least the suitcase video.
Identification A. Have you ever seen this photograph?
No.
Now, I believe at the time of the deposition, you had spent I think on October the 2nd of 2024, you had spent 2.5 hours evaluating Sarah Boone, and about half of that time was giving her a test?
No. The mental status examination takes approximately 5 minutes.
Okay. Did you go through her entire history of abuse over the 3.5-year period within the 2 hours and 20 minutes that you had?
No.
Now, I understand that you indicated you may take a couple more hours
This
to
is
go
more
through
relevant.
your file and your notes and to come up with your conclusions. Did you do that?
Yes.
Have you spent any more time on the case other than that 2 hours?
I re-reviewed the documents.
Have you
Went to
made
the
any other
depot.
attempts to go see Sarah Boone anymore?
Objection. Proffer.
Sustained.
The prosecutor tried to head this off yesterday, asking the other experts. You understand state-appointed experts get a limited amount of time and funds. The prosecutor tried to head it off. Counsel shut it down. Now counsel's trying to ask about it, and the prosecutor shut it down. So.
You agree that your opinions are subjective, not based on authority?
They're based on my
I'm the authority.
education, training, and years of experience.
And you would agree they're your subjective opinion?
Correct.
Would you agree that
Your
Sarah
client's
Boone suffers from battered spouse syndrome?
I do.
Would you agree that battered women's experiences of
So it's entirely subjective, yes. And you think that she suffers from battered spouse, yes, subjectively.
affect their perception of imminent danger?
They can.
Would you agree that victims of repeat violence may fear death in a situation others would not?
They may.
Because someone suffers from battered spouse syndrome, they have a heightened sensitivity to danger.
They may.
She's like, so people are different. It can happen. But if you want to ask me about your client, I'll answer. She is so over him. There are moments I'm over her too, so I get it. But she is over him. But
You
also,
agree that people suffering from depression and anxiety are predisposed to getting into a relationship with a partner who may be violent?
They may. Each individual is different.
Are they more susceptible to getting in a relationship if they suffer from depression and anxiety with a violent, intimate partner?
They may be.
Do you agree that
Probably
the DSM,
not.
I think you have it there with you,
Yes, sir.
directs that the clinician should consider post-traumatic stress disorder if there was exposure to extreme stress? Do you agree with that?
Yes.
Did you do any testing to measure whether or not Sarah Boone had post-traumatic stress disorder?
No.
Is it your opinion that Sarah Boone suffers from post-traumatic stress disorder?
Again, she did not give me enough information to formulate an opinion with regards to that.
all of that fighting before lunch to keep that out, and he goes ahead and is like, let's just do it. Fuck it, let's just go. Fuck it, let's just go there. Let's just go there. All of the fighting before lunch was about that. All of it. And now he's like, do you think she had PTSD? What, Owens? Oh my goodness.
You agree that an intimate partner who commits acts of violence, physical violence, against the victim that could cause extreme stress in that individual?
It may.
Owens, buddy, where are we going with this?
You agree if that is the cause, the violence is the cause of extreme stress, that a diagnosis of post-traumatic stress disorder should be considered?
If they meet the criteria. They have to meet the diagnostic criteria.
You agree that there is a sense of learned helplessness when someone suffers from battered spouse syndrome?
Yes, that's part of the syndrome.
Do you agree that these women, these battered women, have learned the probability of receiving a beating, and they recognize specific predictive cues emitting from the batterers?
Yes, but it's not just women.
I understand, but you would agree the vast majority of intimate partner violence, battered spouse syndrome victims are women.
Yes, intimate partner violence, yes.
Excuse me?
Intimate partner violence, yes.
The vast majority, the lion's share, are women.
Yes.
And these battered women have learned the probability of receiving a beating by recognizing specific predictive cues emitted by the batterers.
Correct.
And many times, these predictive cues result in a high level of anxiety.
Yes.
And in that situation, the battered women may attempt to reduce through several different means, one of which is to avoid delaying the beating.
Yes, we talked about that with the cycle.
What is a basal instinct?
A basal instinct? I have no idea.
Basil?
Primal fear?
Primal fear is just being afraid.
Chad, I see a lot of you are over Owens calling it battered women syndrome. He's not going to stop. The experts are going to correct him. He's not going to stop referring to this being specifically to women because it is part of his advocacy for his client. He is choosing that because he wants to connect in the jury's mind through saying it over and over again that Sarah Boone is the victim here. So he's not going to change that because he is trying to, in everything he says, connect his client to being the victim here. So that is his advocacy in court for his client. And that is why the experts keep correcting him. And then when you see the prosecutor get up, the prosecutor tries to reiterate that it is not just women, that George can be a victim here and is the victim in this case. So he's going to continue to try to connect that in the eyes of the jury because his languaging is trying to make that connection. So hopefully that makes sense why he's using language the way he's using it. It's not that he doesn't know that the language has been updated. It's not that he doesn't agree that the language has been updated. It is that he is the defense attorney, and that is part of him trying his case. Hopefully that makes sense because court is its own space, and all Owens wants to do, it seems, is fight with this expert right now.
Is that a natural instinct that animals have?
Yes.
Fight or flight instinct?
Yes.
And now we got to primal
Don't even
fear.
think about it.
Correct.
Animal instincts, I don't think, is what the facts in this case show. I
Do you
don't
agree that victims of battered spouse
I don't think
or
that's where
battered
we're
woman
at.
syndrome suffer from self-isolation, suicidal thoughts, and oftentimes substance abuse?
They may. Each individual is different, so they may.
And they may show signs of physical injury and illness, such as bruising and chronic fatigue.
Yes, those can be signs.
Chronic bruising.
The syndrome, battered woman syndrome, is the psychological effects of living with an intimate partner violence.
Yes,
They may have intrusive memories,
they may.
or they re-experience past traumatic events in their mind.
Yes.
The prosecution's just going to go through
They
each
have
one of these
high
points
levels of anxiety.
and say, did Sarah have that?
Hypervigilant, when something doesn't seem right.
They may.
It leads to this fight or flight response that we spoke about.
Yes.
They have problems with sleep.
They may.
They often go into denial,
They may.
minimizing what is happening to them,
They may.
numbing their emotions,
Some of them.
Disassociation. A battered woman may often develop a defense mechanism of being able to psychologically detach from their body during the traumatic experience.
Facts not evidence.
Sustained.
The objection was facts, not in evidence about disassociation. He's tried that
Panic
with every
attacks,
witness.
severe depression, very low self-esteem, poor body image, disassociation, learned helplessness.
I think
All
he's
these
probably
are
just reading out of the DSM.
symptoms of a battered woman syndrome.
Objection compound, some facts not evidence.
Sustained.
Do you agree
Objection
panic
compound.
attacks is one of the symptoms of battered woman syndrome?
Objection fact not evidence.
Sustained.
What are the symptoms of a battered spouse syndrome?
They can be numerous symptoms, from anxiety symptoms, mood symptoms. They can have psychotic symptoms. It can be any vast majority of symptoms. Substance abuse symptoms, any vast majority.
Do you agree fear is a symptom?
Yes.
Somebody in a constant state of fear.
Maybe, yes.
In terms of the abusive partner, do you agree that they would hit the victim,
Some of them, yes.
kick the victim?
The redirect here might end up being better than the state's direct examination of this witness, because the state can go line by line with all of them and say, do you have an opinion about that with regard to Sarah Boone? They can try. So we'll see what happens on redirect, because he's going through a lot of specifics.
They may,
Punch the victim,
they may.
Choke.
Abuse takes all different forms.
choke,
They may,
burn,
they may,
destroy their belongings,
they may,
use weapons to hurt them,
they may,
threaten to hurt them, their children, or their pets,
they may,
take their car keys,
they may,
take their debit card,
they may,
take their vehicle,
they may,
control where they go and who they see,
yes, they may,
force them to have sex when they don't want to.
yes, they may.
She's like, right, all of these things can happen. His depo of her in court before the jury came back was so much more pointed and direct and impactful. And I feel like now we are wandering lost in the wilderness with a broken compass and not enough water, and nightfall's approaching.
Dr. Werner,
She's like, uh-huh.
I know you spent a short amount of time with her, and you're saying you didn't get some of the answers as to whether or not.
Facts. Stating facts.
Objection sustained.
If you'd have spent more time with Sarah Boone, could you have uncovered as to whether or not she suffered from battered spouse syndrome?
I agree that she met the criteria, or that she had battered spouse.
How about post-traumatic stress disorder?
It's possible.
Thank you.
Any redirect examination?
Yes.
Oh,
You may
yes.
proceed.
I'm surprised that he just, all of that, and there was no like point to the cross at the end. It was like, if you had spent more time, do you agree that she has battered spouse? She's like, I did agree. He's like, what about PTSD? She's like, anything's possible? Well, today has been a lot of people dropping the balls. That him eliciting from this expert that the ex-husband says that Sarah is the one who's the aggressor, I think is what a lot will be taken away from this cross-examination, because it's the first time we've heard of it's like, oh, her ex-husband said what though? I'm interested to see where the state goes with this.
In your decades
I'm not
of
optimistic.
experience, have you ever treated patients that suffer from trauma disorders?
Yes.
How frequently would you say you do that?
I have patients on my unit right now that I'm treating on a regular daily basis who have suffered from trauma.
How about patients that meet the criteria for battered spouse syndrome?
Yes.
How many would you say over the course of your career?
Probably 5 to 6 a month on my inpatient unit.
And that's a lot of months.
Yes.
How long have you been doing this?
Since 1998, when I began my career at the University of Florida on faculty.
Now, on cross-examination, you were asked about some diagnoses, correct?
Yes.
Right. Any of these things that you talked about, narcissistic personality disorder, adjustment disorder, anxiety, battered spouse syndrome, any stress or trauma-related disorder. If the state wanted to ask you those opinions, would you have been receptive to more materials before making any opinions about those topics?
Yes.
And is it your testimony today that you don't have enough
I'm surprised defense didn't
information to
object to that.
necessarily make a complete and proper diagnosis on any of those things since you have not been provided those materials?
Correct.
Now, you've testified that she does meet the criteria for battered spouse syndrome.
Yes.
But you would be receptive to any evidence that you were provided, right?
Correct.
Going back to what you testified to on direct when the state asked you your opinion about this case, everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No, not at all.
And why is that?
Because again, she just.
Objection, Judge.
Grounds? Owens is like, she can't testify to this. The court has said, yes, she can. So they're going back. This is the same argument they keep having. With everything that Mr. Owens asked you about, does that change your opinion about how battered spouse applies in this case to these facts?
Your conversation.
Owens does not want this opinion on the record. He keeps breaking up the testimony as it's coming in. And I wonder what the jury thinks about that.
Objection's overruled.
Let's try this again.
Based on your conversation with Mr. Owens, you've indicated that your opinion did not change, and now would you answer why?
Yes. So based on my interview with her, the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
And I'm showing you what has been marked for identification purposes by the defendant as I. Does this photograph...
What's frustrating to me is that if that is her opinion, that is the entirety of her opinion. She said there were no triggers. She relayed that there was no trauma. She said in the interview they were laughing, blah, 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 blah. The experts for Owens said, right, but there's reasons people lie. So Owens could have gone the entire direction of this expert didn't spend the time with her. Our expert did spend the time with her. This expert didn't build rapport from her. She came in there and stared at her with her face and said, tell me about your life. We have TikTok 90 minutes. And the other expert said the more time you spend, the more rapport you build, the more you will get to the truth. So Owens could have absolutely gone the direction of you didn't spend time with her and she lied to you too because she didn't trust you, because she thought you were out to get her. So why should we believe anything you say? Okay, you're basing that on what she said. Fine. Our expert doesn't say that and just rely on their own expert. That's it.
Photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
And now we're getting into, on all of these pictures, does this say what happened? Does this say who did it? And this is going to bolster, I think, the state's bringing in of the body cam video.
Marked for identification purposes by the defendant as I. Does this photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it inform you as to who the aggressor was?
No.
Same questions for G.
None of this would have come in if that wasn't their cross.
F.
No.
E,
No.
D,
No.
and A.
No.
If those specifics as to what happened and who was the aggressor is dependent upon the credibility of somebody, would you want to take into account all the things that can make a person credible or less than credible?
Yes, you would want to take that into account.
And you talked about alcohol use disorder. Would you take that into account if somebody is under the influence of alcohol or had been consuming alcohol when they relay a history as to things that happened?
Owen said, I'm going to object. Okay. Based on, so now he's getting in, prosecutor is trying to ask about alcohol use disorder. I'm going to zoom through yet another sidebar. The camera's going back to Sarah Boone's face.
Would you consider
Overruled.
Objections overruled.
Would you consider somebody's alcohol use and level of intoxication in evaluating the credibility of them as a historian?
They didn't ask this question. I don't think it's been asked much, but would you consider their alcohol use disorder in connection with their reliability as a historian, as who is accurately retelling the events?
And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Again, that doesn't change your opinion that you gave when talking with me on direct examination.
Object, asked and answered.
Overruled.
Specifically about this question about the testing that you did not perform. Did this lack of testing have any change or effect on your opinion as to whether or not battered spouse syndrome applied to the facts of this case?
No.
I want Owens to lean in. I want him to be like, Your Honor, can I ask one question? So no matter what your testing was, you were going to come in here and say that these things, that Sarah's history and abuse and her having battered spouse syndrome, it doesn't apply at all. That was always going to be what you said, no matter what, right? Right? Okay, and then just leave it at that. I don't know if he'll do that.
You were
Just
questioned
let it
about
go.
insanity on cross-examination. Do you recall that?
Yes.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct. The two aren't equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct. That's not. They wouldn't be equal.
So even if you do
Barely
have
hear
battered
her.
spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
No other questions?
I'm surprised there was no objection to that.
State, can this witness be released?
Yes, sir.
Defense.
Just if we got a phone number, we can reach out to them.
Okay. All right, ma'am, you're released, potentially subject to recall. Thank you.
Just because somebody has suffered in a violent relationship or has battered spouse does not mean everything they do is justified. I can't believe Owens didn't object to that.
State, you can call your next witness.
Judge, at this time, the state would move P for identification and evidence.
Is this a videotape or an audio tape?
I think these are probably the body cam footage. because we did hear the state say they wanted 2 hours of video. Imagine that's what this is.
Statements P for identification and evidence.
Got it. Okay. Any objection to what was pre-marked as P?
That's an annoying pause.
Counselor? Any objection to what was pre-marked as P?
Permission of public,
No, he's offering into evidence. Any objection?
no objection.
All right, what was pre-marked as P will be received into evidence without objection as states 21.
Owen is like, wait, what? One of my mentors used to say, if you lose your place in trial, if your brain has gone somewhere else, happens. If you lose your place, if you, God forbid, fall asleep, which as a prosecutor, I don't think we ever are still long enough to fall asleep in trial. The first thing out of your mouth should just be objection. So I was waiting for Owens to just be like, what? Objection. When I told you the attorneys are tired, the attorneys are tired. All right, so this is getting moved into evidence. I imagine they'll just start playing it. Hopefully the audio doesn't suck.
V for identification, B as in Victor.
Any objections?
No objection.
What was pre-marked as V will be received into evidence without objection as states 22.
May we approach?
Yes.
The state needs to let the defense know what they're bringing in. All right, let's.
So we're going to go ahead and take our afternoon. It may take a little bit of time based on the length. Some videos. It was
All right.
2:52.
Hold on, I'm going to back up. It's 2:52 in the afternoon.
Members of the jury, it is 2:52 in the afternoon. The next part of the state's presentation are going to be some videos and other things that we read to you that may take a little bit of time based on the length of them. So we're going to go ahead and take our afternoon break at this point in time. Similar instruction I've given to you over the last couple of days. Please do not conduct any independent investigation or research if the person, places, things, or charge involved, and do not have any discussions with anyone or amongst yourselves about those things, and we'll bring in 5 after. Thank you.
Stretch break. It's time to take a stretch break. Take a comfort break if you need it. The jury is out. Oh, man, that was painful.
State, anything we need to talk about? Defense? All right.
Holy shit.
We'll be in recess till 5 after. Thank you.
They're in recess for 3 more minutes. Oh, Lord, that was a lot. I don't know. Did Owens step on his own case with that cross? It looks like they are coming back to court a bit because the seal is not up. So I'm going to put this on 1.25 while we talk. What do you guys think? Did Owen step on his own case on that, in that cross? Did he just walk into a pile of shit that he can't undo? Especially as it goes to who was the aggressor. Why ask that question? Why ask that question of not a friendly? Like, your experts that you pay for are friendlies. Why take the hit of not a friendly? I mean, I saw some of you saying he tripped over his own tail. I have a less artful analogy. I don't think it's arrogant. I think it's tired. I really think it's tired, and it's the words came out of his mouth, and I think they shouldn't have, but we'll see. So, shall we try to give a summary? Yelena, let me see if we can. Katie in the chat asked, "Are you going to cover the Menendez news?" I don't cover breaking news, so if anything happened today, no. But I've been covering it on Quick Bits and in the podcast. So the last updates I gave on that was yesterday on the Emily Show, which is on audio and this channel under the VOD tab, not the live tab, but also that's not what I wanted. But also, if you have the Lawnerd app, I can tell you what we are doing. So if you have the Lawnerd app, all those things will be in there. I do Quick Bits on Monday, which does summaries of like the ongoing cases, quicker summaries. And then we dive into the longer kind of breakdowns of cases on live streams and on Wednesday. So if there's breaking news today, I have no idea. But if there's stuff going on that happens this week, I'll cover it on the podcast. There's a lot that's on the hopper for the podcast next week because a lot's been going on. So it just really depends. But Quick Bits and the pod, and if you are members or if you're new members, because this community is incredibly generous with gifted memberships, then you can always join us for the behind the scenes recordings. I put those out in just the app. We give a little like, hey, we're going to be recording. And then in your members tab here on YouTube or in the Lawnerd Lounge, you can grab the link and hop in while I record the pod in real time, which hopefully y'all find entertaining sometimes. You can see what it is like to try to do things in real time. So should we try to do a summary? All right, let's try to do a summary real quick. You guys are telling me there's a press conference. Okay, well, if there is a press conference, then we won't be covering it until later. So thank you for no breaking news. And if we have to block the name in the chat, then we'll do that because I can't focus on too much. And I know people might want to tune into it later. So if people want to tune in later, then we don't want to spoil that for them either. We're going to stay on topic. It's hard for me to process multiple topics at once. So we'll see what happens. And if I need to do a quick summary of it later, we'll do that. Okay, let's try to do a summary of this and then this, because we're in this. So let's try to do this and then get back to court with video. Well, after a longer day than I anticipated, and we are only at the afternoon break, the prosecution's expert witness is finally off the stand. There was so much arguing about what this testimony would be. And at the end of the day, the thing that I remember most is that Attorney Owens asked the expert, do you agree that George Torres was the aggressor and Sarah Boone was the victim? And she said, well, in reports, Sarah Boone's ex-husband, Brian Boone, said that she was the aggressor. And that is, I think, a wild error for the defense to elicit that testimony. Do you know what else Owens elicited after all of the fighting? After all of the fighting today, he said, so do you think Sarah Boone has PTSD? And she said, Sarah Boone did not give me enough criteria to make that determination. That's what the entire fight was over this morning. And then he elicited it. And then it allowed the prosecution to get into rebuttal. And when the prosecution got into their rebuttal, I think it was actually more informative than their direct examination. On their rebuttal, they were able to ask about, again, do you think that Sarah Boone, or do you think that battered spouse syndrome applies in this case on these facts? And the expert was essentially able to say no, because Sarah Boone said that they were laughing. She didn't say that there were any triggers. She didn't give any information that would have put this into the category of her acting out of that trauma or duress. And that testimony came in again. And then, because the defense pulled out all their blow-ups of their photos, the prosecution went photo by photo. Does this tell you what happened or who was the aggressor? No. Does this tell you what happened or who was the aggressor? No. And it kept going. So I think the prosecution had a better redirect than they did direct examination. And I think the defense made some points early on in the cross and then stepped in it at the end of cross. We'll see if it gets undone, but now they are getting ready to show hours of video. So get your snacks. The substitute teacher is wheeled in the video cart, and we are going to, just roll the tape, I think, as we get back to court. So hopefully that gets everybody caught up to speed. Let's get back to court and see where we're at. Everybody's
Ms. Boone is seated at counsel's
putting their
table. We're in the same
appearances back on the
courtroom from this
record.
morning. It's 3:05. We're ready to bring back in our jury, Mr. J.
Yes, Your Honor.
Defense. All right, let's go ahead and stand and bring back in our panel.
All right, we're just going to run these through. Now's probably a good time. I have not seen these videos. We're watching trial in this case. I don't know what they will show. There's going to be body cams of instances of domestic violence. So for the replay crew, there will be timestamps down below. For anyone who wants to see what happens when the videos aren't being played, when the videos are all over, videos and photos, we will go ahead and send out an app notification. If anyone wants to nope out of body cam footage between the two of them, we will let you know in the app. This might be the rest of today, given what time it is locally. A juror early today said they could not stay past 5:30. So there's not a lot of time left in the day. I don't think they'll get to arguing jury instructions today. I think we're going to push closing probably till later in the morning tomorrow, if not the afternoon tomorrow, because there's a lot left to be done today, and I don't think we'll get to it. So let's zoom.
Just during our break. Reflect all hands have been raised. Thank you very much. State, you may proceed with the balance of your evidence presentation.
So they're going to dim the lights and play the video. Hopefully those videos say what date and time they're from and everything, because otherwise just watching the video can be confusing. This is odd to me, the way they present it. I'm used to seeing a witness on the stand like a detective and saying, hey, detective, is this the body cam footage from this day, this time, this incident, this
Permission
address?
to publish what has been entered into evidence as 22, previously V as in Victor for identification.
You may
It's
proceed.
just different. They're just rolling it.
This exhibit 22 has 5 folders on it. It is a DVD. Going into the first folder, OCSO 18-067501.
Counselor, are these audio or video files?
This first one, Your Honor, is going to be a video file.
Okay, let's go dim the lights, please. Thank you.
And for record purposes, its file name ends with 0154-2.
You may proceed, sir.
Okay. Remember, the first minute of video has no audio, as we heard earlier in this trial. I'm going to move me out of the way as best I can.
And he's going through a whole bunch of shit. Pardon me saying that. No, pardon me saying that. But like, oh man, he let loose on my ass tonight, and I'm not having it. Okay. I got kicked in the face. Okay. Kicked in the face.
That you know if there's no guns
No,
or anything?
no.
The date on this is 7/25/2018. This seems to be going to the incident where Sarah said she was kicked in the face. She's saying she's not having it, or she said stomped in the face on direct. So this is this is the body cam from that instance.
I know, baby. You guys are doing your job.
Stay right here.
Yeah, let's go get him. I swear to God, this is nothing. You guys stay right now.
What's his name?
George.
George, all right.
There's nothing. You guys stay right now. I swear to God, I'm done with that too. You beat the fuck out of me tonight. And I'm done with it. I have to go to work tomorrow.
What's up, George? You want to talk to us? What's up? Talk to you inside.
For the record, this was redacted.
Are the videos in States 22 redacted videos?
Some.
Okay.
You see my eyes?
I do see your eye.
They've redacted out the victim's statements. So it will show any injury to him, but not his statements. And the judge didn't read the redacted instruction. He might in between videos.
Okay, tell me how it all went down from beginning to.
Here's my love.
Okay.
Okay, so we were having a really good day, and we went across the street from Boone, and everything was feeling fine and dandy, and the guy talked to another guy because he left. Came in there and I got so mad. Because I asked for a cigarette from another guy because he took my license, my debit card, and everything. Cigarettes, everything. Took everything.
Okay.
So I asked someone for a cigarette, and it happened to be a guy. So he walked in and got super pissed because I asked for a cigarette from another guy. I came home. Mind you, my car is across the street still.
Okay. So you get home, you go inside.
And let loose.
Okay, elaborate. So you open the door, what happens from there?
I'm a whore.
He starts calling your name? Okay.
When I say ragdoll, do you know what that is?
I know what a ragdoll is.
Oh man, I was ragdoll.
Okay, but I need you. Okay, I need you to elaborate. Like, you walk into the house. Did you start arguing? He started calling your name. He said he was.
No, I walked out. I walked in and I walked to the back. I just wanted to smoke a cigarette and just go to sleep. I just literally wanted to smoke a cigarette. I'm gonna go to sleep.
And then as you're making your way to the back, what happened?
I got caught on the stairwell.
You got caught on the stairwell. So he caught you on the stairwell. And what did he get in front of you? Started confronting you, telling you anything? What happened?
It was bad.
Okay. Elaborate, Miss Sarah. I need you to tell me exactly what happened so I can help you.
My heart is like, I don't want him to get in trouble, but fuck, I'm tired of being beaten up.
Okay. I understand. I'm trying to help you out. But
I know you are.
I need you to elaborate a little bit. So, in the stairwell?
Dragged me downstairs. I went upstairs, tried to get into bed. I just want to go to sleep. I just wanted to go to sleep. I didn't make it to bed. He caught me in the upstairs.
Like in the hallway?
Beating the fuck up. That's all he said.
Okay, what do you mean? Like, I see your eye. You said he kicked you in the eye.
That's what I see it. That's what
Were you on the floor when he kicked you?
Yes, ma'am.
Okay, how did you get to the floor? Did he push you? Did he pull you? How?
Normally what I do is, because he does it so often, I just go to the floor. So I'm pretty sure I don't really recollect. I went to the ground.
Okay. And then that's when he...
I'm so sorry.
No, that's fine. I don't mind. So you went down to the ground.
Yes, that's what I do.
Did he kicked you with what? Do you recall which foot?
Right.
Right foot, okay.
Heel.
His heel. Okay. And you say you've been together for...
Because I asked for a cigarette. Because he left my ass in my car across the street.
Okay. You said you've been together for about a year?
And a half.
A year and a half.
Yes.
Okay. You live together, obviously.
Yes.
Okay.
I just recently went for a divorce. He's been there with me. He knows all the story, blah, blah, blah. But...
I know. I'm just trying to...
This sucks. And I could have worked for him.
Do you want the fire department to come out check your eye? No? Okay. Do you want to press charges? You can smoke a cigarette if you want.
Can I talk to you though?
You're talking to me or myself?
I don't want to speak to you. Please put the finger up the police.
So you don't want to press charges? Okay. Do you want to fill out any paperwork? Do a statement? No? Okay. Smoke a cigarette, sit down, smoke a cigarette.
I don't want to be in trouble.
I know.
That's actually been out of life now. Look at this shit. Look at this my shit all the time.
Did this happen today?
Yes.
Okay. Alright. Yeah, see it. It's ripped and I'm done out of it.
I just bought this yesterday.
Go get it. Sit down. Smoke a cigarette. Do you think? No, fine. Do you have an ID with you? Is it in the house? Okay, we'll go find it.
I know my number if you want it.
Oh, that's perfect. Proffer.
Vide 500-791-77870-0.
870-0. Okay. First name spelled S-A-R-A-H. Do you have a middle name?
Catherine. K-A-T-H-R-Y-N.
K-A-T-H-R-Y-N. R-Y-N. What's your last name?
B-O-O-N-E.
Date of birth?
10-10-7-7.
I get it. So you cannot stay down anymore. Do you have a telephone number?
407.
407? 716?
8684.
8684? Email address?
SKP.
SKP underscore? There you go. That's one.
Sorry.
No, that's cool. Right there. Okay. Sit down, smoke a cigarette, try to relax a little bit. I'm gonna take pictures of you in a little bit. All right? No problem.
This video is not sped up. It is just the way she is responding to the officer's questions.
Turning now to folder OCSO 19-054.
Can the parties approach just for a moment?
And the judge is having the parties approach.
First thing that will be within this folder, the first thing that will be published is a file that's an audio file, 911 call _R1.
911, what is the location of your emergency? 4748 France Court, apartment 3. 4748, what was the street name? I didn't hear you. 4748 France Court, apartment 3. Okay. Ain't nothing that I would call, but I did. And you can beat the fuck out of me. You said France Lane? That's what it comes up as always. Okay, and then what was the apartment? 3. Okay, and what happened then? He just beat the fuck out of me. Who is he? Jorge Torres. Is he still there? Yes. Okay, where's he at? I'm in the bed. I'm outside. Okay. I did not fight back. Okay. Do you need any medical attention? No. I just have a lump on my head and I just got beat the fuck up. That's all. Okay, what's your name? Sarah. With an H. Okay, and George, you black understand? He's Hispanic. What are you wearing today? Oh gosh. Just color shirt pants, that's all I need. I don't even recognize because he just showed up. Okay. Do you have his date of birth? February 13th, 78. 2/13/78. And I swear, I'm just going inside because he's not on leave and he's not supposed to be here. But he's here. How long ago did this happen? About how many 12 minutes ago. Okay. I'm done. Yes, ma'am. I can't do this anymore. Okay. And I just need a description of you so that I can identify you when they get there. I'm white. I have 30 blonde hair and blue eyes. What color is your pants you wearing? Am I? Yes. Black. Black shirt, black pants? Pink shorts. Pink shorts? And you're outside? Please don't get me in trouble. There's no way that I can get in trouble for this. No, just stay where you're safe. You said you're outside, right? Yes. Okay, does he have any weapons that you know of? No. Okay. And did he hurt you with anything, or was it only his hand? Fist. Just his fist? Okay. And you don't need any medical attention? No, I always get over it, but this time I'm not getting over it. Understood. Okay. Okay. We're gonna go ahead and send some help to you, okay? Anything you can just give us a call back, okay? Wait, can I sit out front though? Yes. Definitely sit out front. Stay out front. I'm sorry I said that. I'm gonna walk around the house. Okay. Okay. Thank you. Yes, bye-bye. Goodbye.
Now publishing a video labeled 19-054-917_BAT_DV.
All right, it looks like this is incident date June 15th, 2019. You guys are asking me, how does it help? Well, it's what happened, so we will see. But she called the police before. She was worried she would get in trouble too. She told the police that. She actually did get arrested that day. So this is the full picture of what happened, it seems. But it was also redacted, so the redacted version of what happened. Oh, the wind is always so hard on body cams. It's so loud.
What's going on? What's going on?
Really, Marco?
Hey, get out of here. What's going on? You called?
I did.
Okay. Do you want to tell me what's going on?
How do you say? Beat the fuck out.
Oh. We'll beat you up. Alright, is she still in there?
He's awfully, I actually got him off of the police because I don't want him here. And he shows this ugly mug over the wall all the time. He comes over and looks for me and
Do you want to press charges?
what charges are you today?
Well, what's your relationship to him?
I guess boyfriend and girlfriend.
Okay, how long have you guys been dating for?
Like 2.5 years.
Okay. And that's a current relationship?
No, it's on and off.
No.
I can't deal with this shit.
Okay.
I'm tired of it.
When's the last time he stayed the night at your house?
2 weeks ago.
2 weeks ago?
And he's been figured out.
Okay. So why is he over here today?
Because he wants to win me over. Is what he told me.
Okay. So
I'm not allowed to leave him.
you're not like that.
Tell me, well, fuck no.
Okay.
He's mad because I went out with my girlfriend.
Okay.
And she introduced me to another gentleman.
Mm-hmm.
He's not a gentleman. He's not a gentleman. And he got pissed.
Okay. So he came over today, you let him in because you're going to talk, right?
Yes.
Okay, then what happened?
He got really pissed. Really pissed.
Okay, so you guys start arguing and then
No,
what?
I didn't argue. I can't argue. I was just taking down his speaker.
Okay, so when you say taking down beating, just like describe it for me, so I know. What did he do to you? Did he push you? Was he slapping you? Was he punching you?
All of the above.
Okay, you have to kind of explain to me what happened. You have to tell me like
He's
step
the
by
closet
step.
doors.
Okay, so he threw you into the closet doors?
That's it.
Okay, you're upstairs, you threw you into the closet doors. Did anything break when you threw you in there?
My head? No.
Okay, but you said you don't need the fire department?
No. I just have really bad luck. It'll go away because I'm used to it. It'll go away.
Okay, let me see. Where is it?
Right here.
Can you just put your head back a little bit?
There's a lump. Right here. Like you can feel it.
Yep, I see it. Do you have any other injuries?
No. I just, because he's not on the lease anymore, I know that he can't, I got him off the lease to not come over here anymore. And I'm trying to get him out of here. And he'll be here every day. And I have a guy who's going to come home.
Okay, so there's another exit to this apartment, so he could be gone?
There's the back to my store and I had a feeling that he said that I should call the police, which I had done 4 times. You're the 4th one.
Okay.
He's gonna hop along, but I have a feeling he's upstairs now. Go get him.
Well, I'm going to, but I'm going to have to try to get somebody else here. What's his name?
George.
George?
I'm sitting here.
Okay. And I have to ask this too. When's the last time you guys slept together?
Had sex?
Mm-hmm.
3 weeks ago.
Okay. So, but you guys are kind of on and get off again. And you're saying as of right now you're off. But
I've been off.
Okay, but within like the last 2 or 3 weeks you guys were dating.
I would say no.
Okay. But at least there are some
I knew who he
expectation.
was.
There's an expectation of intimacy when he came over.
Oh, no.
But you guys, you said
Oh,
you
no. We were going to try and figure it out.
Okay.
Oh,
But you want to press charges on us?
what charges can I pass?
Right now, what he said he just hit you with hands and feet and pushed you?
I got a heel on my face.
Okay. You keep getting upset with me, but you're not really giving me the information I need. I'm asking you to kind of walk me through what happened, okay, because I don't know, I wasn't there.
I know.
Okay?
Yes.
Okay, so all you said, you guys were upstairs. Right. But that means lots of different things. So that's why I need to know what
This
you
is
did.
why I have all of this over here, is because he continuously stops me, and he strangled me multiple times.
Today?
Yes.
Okay. Did you start to lose consciousness or anything while you were strangling you?
I couldn't breathe.
Did you feel yourself losing consciousness?
No, I didn't lose. I just couldn't breathe.
Okay. But for how long was he strangling you for?
Till I got him off of me.
Okay.
Look, can I tell you something before you call him whatever?
Mm-hmm.
I've been arrested before because I fought back. Look, I didn't fight back. I didn't fight back. So whatever he has or whatever it is, it's not me.
Did he hit you with any, like an object or anything?
No.
Okay.
The wind is so bad.
Today? I'm talking about today. Did you pick up a baseball bat and threaten you? Okay. Tell me about that. How far away were you when he had the bat?
I was in the bedroom.
And where was he?
In the bedroom.
Okay. Was there anything in between you guys at the time?
My dog.
Just a dog? And how close was it to you? Couple feet? 3 feet?
3 feet.
Okay. And how was he holding the bat?
Threatening.
Like, what do you mean? Was it down by his side? Was it up like this? Like, how was it?
He's gonna swing.
So he had it up?
Yes.
Yes. Okay. Did he say anything to you while he was holding the bat?
I dare you.
Okay. And what do you mean by that?
Because I technically left him 2 weeks ago, which is why he's not here now. And it's not because I have friends. I have friends. And my friends want
He's mad
me to
because
get
I have
out
friends.
of my loony Jimmy bullshit. So they try to introduce you nice gentleman.
Okay.
Whom he is not.
Okay. So he's holding the baseball bat, and 3 feet, you guys are up in the bedroom, and he says, I dare you. Okay. And you were scared. Correct?
I'm so scared of social why I'm hiding behind my car.
Okay. I'm gonna go see if I can get him to come out. Alright, if not, is this your place, right?
He's not on the leave.
Okay. And we
Come to the party members. I had taken off the leave.
Okay. Alright, hold on.
Sir, what is your name now?
O'Neill.
Sir, what is your name? As he's walking away. What is your name? It is so hard to hear. She's yelling the door is open. She also said she took him off the lease. And she wants him
If there's
out.
anybody available, can I get 44?
Don't get me
Hey, George? Hey, George, Sheriff's Department, can you come on out? Just hold on. Hey, George, I can hear you. Come on out.
Part of the reason law enforcement asked when's the last time he slept there is to try to ascertain if he lives there or not. She said she took him off the lease and she wants him out. The wind was really difficult as she was explaining.
What's going on, man? Come on here, talk. What's going on? Talk to me. What's going on today? Do you speak English? Yes. Okay, so tell me what's going on. Why are you here right now? Because she called me. So tell me, you want to tell me what's going on? What? This is where you come? Where are these cuts on your neck? That's neither here nor there, no. Is she over there? Alright,
And a fucking plane?
Retort, do you want to talk to me about the cuts on your neck? Yeah, no, baby. Okay, do me a favor, turn around. Put your hands down. Wow. Why am I getting cuffed up? Come on, sir. Why am I getting cuffed up, sir? Kind of 424 Wednesday, Malskia. Why am I getting cuffed? Come on in. Yeah, why am I getting cuffed up? We'll talk to you about it in a sec, okay? Yeah, weapons on you? No, I don't. I see my hand. You been drinking today? Yeah. Okay. A lot or a little bit? Like, do you understand what's going on right now? Yeah.
I don't think he understands. He asked you a couple times.
Okay. I'm just going to use an answer yes or no after each time I ask you a question, okay? You have the right to remain silent. Do you understand that? Anything you say will be used in court as evidence against you. Do you understand that? You are entitled to talk to an attorney now and have him present now and at any time during the questioning. Do you understand that? Yes. If you cannot afford an attorney, one will be appointed to you without cost. Do you understand that? Yes. Okay. Do you desire to consult with an attorney first or have one during this interview? Yes or no? No. Okay. If at any time hereafter you wish to remain silent and have an attorney present, all questioning will be stopped. Do you understand? Yes. Okay. Has anyone at any time threatened, coerced, promised you anything in order to induce you to make a statement? No. Okay. Do you understand these rights as I read them to you? Yes. Okay. Do you wish to talk to me at this time? Yes. Okay. So.
Really?
Tell me what happened today. What is going on? She said that you hit her and you choked her. What? No, sir. No, sir. Okay, she's got a lump on her head. How did she get the lump on her head? I
I don't know. She just take me in. I don't know. Officer, I don't know.
Did you push her, hit her, anything like that?
No, not at all.
Okay, how did she get the lump on her head?
I don't know.
Okay, what brought you over here today?
I was trying to get my ID and my social and my birth certificate. And she's not trying to give me that.
Okay, but obviously you've been here for a little bit. I mean, your shirt's off, you've been drinking, so you didn't want to just come over here to get something. So, like, how long have you been here?
For a while.
Okay. So, so a while, like an hour or 2 hours? Okay. How long have you guys been dating?
Oh, man, we've been together for 2 years.
For 2 years? Okay. Are you guys still dating right now, or are you broken up? Okay.
And I work right there at Ace.
Okay, so you came over here today, so for about a while ago, an hour or two. What have you been doing since you've been here? Okay, so just spending time with her, and then all of a sudden she decides to run outside and call the cops? Why would she do that? You don't know?
She's nice, dude. She's nice.
Okay, that's fine. But
As you can hear her.
But what you gotta understand, what you're telling me isn't really adding up. Because she gave me her side of the story.
What she said?
And she's saying that you had it. That's all I need. It's Ma'am, I'm doing my job, okay? You just sit there and be quiet. I'll be over to talk to you when I can.
She's chipping in the background.
Every time you start yelling, you're interfering.
She's chipping in the background, and George said, can she hear? And she's yelling at the cop who doesn't have a partner there to keep them apart, which is why he's got George in the car with the door kind of closed so he can talk to him somewhat privately. And Sarah's yelling off in the background, which is why he's turning around and yelling back at Sarah, saying, can you just not?
She's the one that she just snatched out of nowhere. She's mad because she took me out of the lease. She took me out of the lease. And I told these guys of the lease, like, look, I can't cash my check. I can't cash my check without her. So please talk to her.
Okay, so you came over to talk to her about cashing your check?
Yes.
Okay, yeah, you've been here for a couple hours. Okay, so what happened to make her run outside and call police? Because I'm seeing cuts on you and I'm seeing bruises on her. But you're not telling me what happened. And you're the one sitting in the back of a cop car right now.
I don't even know what happened.
Did she hit you?
All the time.
Who hit who first?
She does all the time.
So she hit you first?
All the time.
But today. I'm talking about today. You don't know if she hit you today? Huh? Do you have an ID on it?
She has it.
She has it?
Yeah.
Okay.
So what I got from his story before they were talking about who hit who and when was Sarah's mad because Sarah took him off the lease, and the apartment's mad because they were waiting for money, and he can't cash his check because she has his ID and his birth certificate. So he can't go cash his check, so he can't pay for the apartment, and she took him off the lease. And he says that's what made her mad. She says he's mad because she went out with her girlfriends and her girlfriends introduced her to a gentleman, and he is not a gentleman. So the officer's like, she has a bump on her head and she has bruises and you have scratches on your neck or cuts on your neck. what is going on? You're not telling me what's going on. And then when he was asking about who was hitting who, you heard George say, she hits me all the time. She hits me first all the time. So the prosecution would have a hard time bringing this body cam in and not bringing in the other body cam from the other incident. They both come in or they don't come in. Bringing in this incident makes more sense now. This now makes more sense because you're not going to bring in one without the other. It makes more sense why they wanted this one in.
I don't have it.
He said it's in the house.
No, I threw it in the bushes.
Where in the bushes? Because I need it.
Well, there's the lake behind the house that we've heard about, the ducks. Do you have his ID? No, it's in the house. Let me back that up because the between the wind and the airplanes.
House.
No, I threw it in the bushes.
Where in the bushes? Because I need it.
Frank, love, whenever I call her, oh my gosh, the front door is open and I don't even know where my dogs are. Oh, yeah, find the duck.
What?
I don't have his ID.
You said you threw it in the bushes. Where in the bushes did you throw it? Could you please go look over there?
She said she threw it in the bushes.
So what's happening?
It's in the back of the cop car. You said he hit you, he beat you, you have a bump. Okay?
I don't have it. You can look up here.
I need to watch that again.
Oh my gosh, the front door is open and I don't even know where my dogs are. Oh, yeah, find the duck. I don't have his ID.
You said you threw it in the bushes. Where in the bushes did you throw it? Could you please go look over there?
So what's happening?
It's in the back of the cop car. You said he hit you, he beat you, you have a bump. Okay?
I don't have it. You can look up here.
She was looking for him.
Publishing portions of 19-054, or pardon, 054917_BAT_DV-2. For the record, it is 47 minutes 20 seconds long. State will publish 000 to 2 minutes and 19 minutes to 22 minutes, and all evidence will go back to the jury with a scrub computer.
So they're going to play parts of this next video, but this video is quite long. This is the same day, 6/15/2019. So the jury will get the whole video, but they're only going to put some of it in. We now have multiple cop cars out on scene. Cam T in the chat said this is sad. It's incredibly sad. Roxy asked a question that I don't think we can answer in the chat without YouTube losing its mind. UrbanDictionary.com might be your friend on that one.
Where were you?
His brother and his ranting mother came over here, so it's.
And his mother. His ranting mother? Is that what? Those bushes.
Where were you?
His brother and his ranting mother came over here, so it should be somewhere in here if they didn't find it. I don't have it.
Good luck.
No, I'm needed because it makes getting his information a lot easier if I don't have to keep asking him questions and I can just get it out there.
I'm not making more difficult than I could, friends. I'm not. I better look through here.
Okay.
It's here. Good luck.
Listen, she said that she threw it in the bushes. I'm trying to find it.
We're giving her some time to find it. Some of this is redacted or not redacted and they skipped. Not redacted. They're getting the full, the jury's getting the full video. We are not getting the full thing. So the officer got in the car with George, I think, in the back seat, and then we went from there. They skipped forward.
If you're looking at you want to be leaving right now.
You told me I'm not going to get one. I love you. I don't know what it is that you're asking me for.
Okay, maybe he didn't get to it yet. That's why I'm looking to see it. Oh, yeah. It was the backside of this. If you get any more bruises that show up that you didn't see while we were here.
Can I show you all the other pictures that I have that I have documented?
I mean, he's going to jail for this, so the rest of that can't really do anything about. But if anything else shows up, you can go take that paper down.
And then it... Did they fast forward it or did the feed jump? The feed jumped. What in the world? I'm gonna back up and hopefully it won't jump again, but that was the feed. This is the prosecution fast forwarding. And then I think the feed jumps.
If you're looking at you want to be leaving right now.
You told me I'm not going to get one. I love you. I don't know what it is that you're asking me for.
Okay, maybe he didn't get to it yet. That's why I'm looking to see it. Oh, yeah. It was the backside of this. If you get any more bruises that show up that you didn't see while we were here.
Can I show you all the other pictures that I have that I have documented?
I mean, he's going to jail for this, so the rest of that can't really do anything about. But if anything else shows up, you can go take that paper down to headquarters.
It's not going to do anything else because you're taking him down.
I
Put
mean,
him under the jail.
He's going.
Under the jail.
Okay. We're all set then.
What else do you, I could show you bloody fingers and bloody faces and black eyes and...
I know, it sounds like you guys need to probably not hang out with each other anymore.
Hello.
I know.
That's
I know,
why I
but
left him 3 weeks ago.
But this also isn't the first time, so, with both you guys, with the cops out here.
No.
Okay?
I've had to lie to you guys 3 times.
And you shouldn't have to do that, so let's make this maybe the last time.
Now I'm not lying.
And I appreciate that, okay? And you go.
Now I'm not lying?
Okay?
They're going to come and tell me.
Who's that?
Just like I told the other sheriff, they're going to come and tell me.
Okay. If you...
I want you to know that. Look.
If you're in fear, are you talking about
Yes.
family?
Yes.
Okay. So
I want you to know I am full blown. They're going to come and tell me.
go down to the courthouse, okay, and get an injunction against them. Did you get the pamphlet for the victim's rights pamphlet?
Yes.
Okay, so you know that there's a place where you can
They're
go tonight?
going to come and tell me.
Okay, so you got the victim's rights pamphlet, you know there's a place you can go tonight then? It's in the bed?
Domestic. I'm going to go sleep over her house.
Perfect.
Neighbors.
Okay. You have any more questions?
Can I get drunk?
This one. I'm working. I get in trouble for that. Okay? Have a good day. Okay, that's good enough. I know. Thank you. Okay.
I love it.
This one. Okay. Have a good day,
Look,
miss.
and whatever the fuck he says,
Okay,
tell him
yes,
to
okay.
be a dick. Hey,
What?
if y'all
Oh my.
Okay, have a good night.
I think she tried to cuddle the cop.
Thank you. Okay, have a good day.
Oh, and tried to pull him back in. What?
Publishing video file axon_flex_2_video. It's the only one that starts with that name in this folder.
Chat, motion granted. Y'all are like, can we rewind? Sure. Motion granted? Oh, I have that gained down too low. Motion granted. We'll run that back again. Sometimes we just have to wait and let trial play out to see what is coming. And I was not anticipating her to pout and try to go in for the hug with the officer as George is being arrested, to go in for the fist bump, not accepting the fist bump, taking the handshake, and then pulling the officer back in. I think she's talking about being worried that George's family is, she's afraid that they are going to come after her. I think that's what she's saying here at the end. Oh, wild.
If you're looking here, you will be meeting right now.
You told me I'm not going to get one. I love you.
I don't know who she's talking to in that moment. I don't know if she's yelling generally towards George, if she's yelling towards one of the officers. I have no idea.
I don't know what it is that you're asking me for.
Okay, maybe he didn't get to it yet. So I'm looking to see it. Oh, yeah.
I don't know what you need. Can I show you everything on my
The
phone?
back side of this. If you get any more bruises that show up that you didn't see while we were here.
Can I show you all the other pictures that I have and I have documented?
I mean, he's going to jail for this, so the rest of that can't really do anything about. But if anything else shows up, you can go take that paper down to headquarters.
There's not going to be anything else because she's taking him down.
There's not going to be anything else because you see him now.
Under the jail.
He's going.
Under the jail.
Okay. We're all set then.
What else do you, I could show you bloody fingers and bloody faces and black eyes and...
I know, it sounds like you guys need to probably not hang out with each other anymore.
Hello.
I know.
That's
I know,
why I
but
left him 3 weeks ago.
But this also isn't the first time, so. With both you guys, with the cops out here.
No.
Okay?
I've had to lie to you guys 3 times.
And you shouldn't have to do
I've had to lie to you guys 3 times.
that. So let's make this maybe the last time.
Now I'm not lying.
And I appreciate that. Okay? And you going. Okay?
They're going to come and tell me.
Who's that?
Just like I told the other sheriff, they're going to come and tell me.
Okay. If you...
I want you to know that. Look.
If you're in fear, are you talking about
Yes.
family?
Yes.
Okay. So
I want you to know I am full blown. They're going to come and tell me.
go down to the courthouse, okay, and get an injunction against them. Did you get the pamphlet for the victim's rights pamphlet?
Yes.
Okay, so you know that there's a place for you to
They're
go tonight?
going to come and tell me.
Okay, so you got the victim's rights pamphlet, you know there's a place you can go tonight then? It's in the bed?
Domestic. I'm going to go sleep over her house.
Perfect.
Neighbors.
Okay. You have any more questions?
Can I get you on?
Can I give you a hug?
I'm working. I get in trouble for that.
He's
Okay.
like,
Have a good day. Okay. That's good
bye,
enough.
bye.
I know.
He's like, bye.
Thank you.
Okay.
That's it.
I love it.
That's fine. Okay. Have a good day,
Look,
miss.
and whatever the fuck he says,
Okay,
tell him
yes,
to
okay.
eat a dick.
And whatever the fuck he says, tell him to eat a dick. That's the part I had missed.
Okay. Have a good night. Good night. Thank you. Okay. Have a good day. Okay.
Tell him to eat.
Whew. That's a lot. Wow.
Publishing video file axon_flex_2_video. It's the only one that starts with that name.
Underscore flex? Oh, because of the program. All right. Another video, same day. That was a lot. These are different body cams from the same day, so different officers, different arrivals. So all around the same day, it's not multiple call outs. So hopefully that helps, chat. Well, today's been an adventure. Ugh. I hate the beeping.
So, why don't you come on over and give me a written statement about what happened? I have it over here by my car. Sure, just stay right there.
He's like, all right, stay over there. I think the beeping's the recorder, but I'm not 100% sure it's within their device.
Go and get your stuff done over there, and I'll get her started on all this. You want to sit down in here? So you can write? Okay.
Mom! Don't leave!
Come on, let me call you here. Let's get this done.
I think she's yelling at the neighbor.
I'm not getting
Don't
arrested.
leave.
No, I'm getting a statement from you. You're not being arrested. So,
Okay, look, I'll come over and see you like 5.
come on.
Thanks, buddies. They know.
Let's get this done.
They know.
Okay. Now, would you come in here so we can do your statement, please? And stop this. Sit down at the table and let's
Ma'am,
get your statement.
this is not your moment.
He didn't believe I would ever do it.
He didn't believe I would ever do it.
Sure.
Never thought I would do it.
Did you have...
No, sir. Yes. I'm not getting arrested.
No, you're not getting arrested. I've already told you that.
Yeah. If you don't count, don't count.
Need your ID, please?
Don't count.
No, ma'am. I just need your ID, please.
Okay, look, I can write back on the couch.
I will give you the statement to write. I need your ID, please. I don't need to sit on the couch to fill
He's
it
like, I
out.
need your ID. What you need is a toxicology
Just
report.
sit down all day, and I appreciate the offer.
Let's go get your breathalyzer, dude.
I just come out, I'm sorry. Thank you, God, he's gone. Oh, man. Oh, man, they're gonna come over here and try and kill me. I want you to know that. They're gonna come over here and try and kill me.
Who's that?
His brothers and his mother and his father. They're gonna come over here and try and kill me.
Don't open the door for him.
It doesn't matter. They all go up there and rant and bullshit and everything, and then they cause a commotion, and then I get complaints against me. Anyway, my name is Sarah.
Mm-hmm. Hi, Sarah. I'm showing this out just a minute.
What's your name?
Jeff, Deputy Brown.
Jeff. We're all gonna be like,
I'm disappointed he didn't say my name's Jeff.
did he get caught off?
He will be. Do you have a phone number, ma'am?
407-716-8684. I'm not getting arrested.
Nope, you're not. Did you do something you should be arrested for?
No.
Okay.
For the last time I fought back. Or 20 years.
Do you have an email address, ma'am?
S-U-Sam, K-as-in-Kate, P-as-in-Paul, _1800 @yahoo.com.
I sit down all day. I appreciate the offer, but want to get
He
this
said
done for you.
you should come sit down
It's a
over
little more
here.
comfortable for me to stand and do this.
I can't tell you how amazing.
This officer's like, I'm gonna need a partner. I'm gonna need somebody else. I'm gonna need some backup. I'm gonna need somebody else. I need somebody else in the room.
A little more comfortable for me to stand and do this.
Yeah, I bet it is.
I can't tell you how amazing it is. Oh, wait, I didn't mean to say that. Sorry.
Okay.
I'm sorry. Oh, crap, the card is still there.
Okay, come on in and sit down so you can get this filled out. And what I need you to do is just print your name right where that X is, and then I need you to just write the story about what happened today.
Print.
Yep, please.
I don't even know what trigger it is.
So is this a husband, boyfriend?
Yeah.
Are you guys married?
No.
How long have you been together?
2.5 years.
Was he drinking or anything today?
Yeah.
Both of you?
I had.
Okay.
Bless you.
Nothing wrong with that.
Here's my artwork thing. Look. Just like your artwork. Look.
Okay, I need you to fill us in. Very nice.
It's artwork.
Very nice.
I have a drink and years ago and do artwork.
No, nothing wrong with that.
Oh, it's hard. This one's hard to hear.
And who called the police? Did you call the police? Okay. Call 911?
Yes.
Very good. Has this happened before?
3 times. The last one that came up and they're like, oh yeah, we read your statement, so know kind of who you are and what's going on.
So 3 times the police have been here? Was there ever, were there reports written when they were here?
I'm not even sure about that. I didn't have to sign anything.
Okay.
I'm not really sure what he's saying. I'm about to like.
What does it say? Can you read it to me?
Flung me off the bed and being in the head and stuff. Am I supposed to write all that?
Yep, everything that happened.
I hate where this body camera is located.
I'm supposed to write all that?
Yep, everything that happened.
All that?
Yeah.
Let me see my neighbors out there, because they know their children are going to come at the house and they know who he is.
And what was your phone number again? 407?
716. 407 716 8664. I'm not getting arrested.
Nope.
Out in the car still.
County charge $25.
Okay.
Could you give me 424 case number, please?
Stopping publishing at 10 minutes, 0 seconds on that file. Proceeding to third folder, OCSO 19-055572. Publishing audio file 911 call, dash first.
Okay.
911, what is the location of the emergency? Well, I don't have an emergency here at my place, but my boyfriend was arrested, I think, last Thursday, and he has a no contact form, and he took it upon himself to come over to my house yesterday and took the bike that I bought for him, which is technically mine, and also my debit card. So, and okay, yeah, if he bought it, then it's a gift. He didn't. Okay, that's fine. I need my debit card though. Like I have my 8-year-old son coming over here, and I can't get my groceries for him. Okay, then what's your address card? My address is 4748 Branch, FRANTV, okay, Ward. So what's your apartment number? 3. Your apartment number? 3. Okay, just to make sure I heard you right. Sure. Okay.
The ma'am, it's a gift, is sending me.
Can you use anything else with that credit card? Yes, he bought beer and cigarettes. Yeah. Alright. Sorry, ma'am, what's your name? Sarah, S-A-R-A-H. Sorry, Sarah, your call back is 47716-8684? Yes, okay. And he's at his parents' house right now, so if you need the actual address over there or whatever, it should be done. I'm sorry, Sarah, what did you say? He's actually at his parents' house right now, so I don't know. Okay, well, we're going to come to you first to make a report, okay? Gotcha. All right, I'm going to get all this information in here, but consider it done to you. I need to send it to you, okay? All right, so when did this happen? Yesterday. So, ex-boyfriend? Yeah, I mean, technically he's my boyfriend, but yeah, at this point he's my ex. Alright, what's his name? George, J-O-R-G-E. Last name? Torres, C-O-R-R-E-S. Okay, by chance do you know how old he is? He's 41. 2/13/78. Okay. If that is correct, can I do, are you guys like or Hispanic? I'm white. So what color shirt pants are you wearing? Right now I'm wearing a blue shirt with white sweatpants. And there's a green pineapple on my door because it covers up the 3. Okay. Do you have any weapons on you or in your home? No.
Ma'am, the chat's going to have questions about the directionality of that
when I'm here
pineapple.
by myself, or me and my little 8-year-old. And you said the pineapple covering the 3? Yes, the green pineapple covering up the 3 that says welcome. And I have a little bird flag out front. Okay. All right, sir, we're going to the detective over the WT, okay? No worries. All right. Thank you very much for your help. You're very welcome. Bye-bye. Okay, bye.
Publishing audio file 911 call, dash second.
911, what is the location of your emergency? I don't necessarily have an emergency. It's 4748 Branch Court.
4748, what's the street name?
I'm sorry, what?
4748 and the name of the street.
Branch Court.
And what's going on there?
It's no contact thing.
Okay.
He's over here again.
Okay, is it
Branch? My fucking hands straight.
is it Branch Court or French Court?
FRANTV.
What's the appointment number?
3.
I couldn't hear the last part.
What's going on there?
He's over here again and then something. The jury should have a transcript of this.
Okay. What's going on? Oh my, I don't know what my dog, she's deaf. Hold on a second, please. I'm sorry, hold on. Come on. No, I gotta go on the way. I'm sorry, hold on one second. I'm so sorry to take your time. No, get out. Oh, ma'am, what's your name? Sarah. Okay.
I got the no contact order and he's over here again. Did she just say get out of here?
Okay. Get out of here! You picked my pantry. Hello? Hello, ma'am. Do you need a deputy? No. Excuse me? I'm sorry, what did you ask me? Do you need a deputy? No, not necessarily.
No,
I'm trying
not
to get my dog.
necessarily.
I have a blind dog and a deaf dog. I'm trying to...
We have a no contact thing. He's over here again. Ma'am, do you need a deputy? No, not necessarily. Ma'am, this is 911. What's your emergency? Like what? No, not necessarily. Okay, well, then what do you need?
Different man, not fire. You're dialing 911. Yes.
The dispatcher is giving me life. Ma'am, you called 911. Emily, keep listening. Ma'am, do you need a deputy? Not necessarily. Ma'am, you called 911. This is not a Wendy's.
Hello. Hello, ma'am. Do you need a deputy? No. Excuse me? I'm sorry, what did you ask me? Do you need a deputy? No, not necessarily. I'm trying to get my dog. I have a blind dog and a deaf dog. I'm trying to get them in. Not fire. You're
I'm trying to get my dogs.
Yes. Okay, and you don't need a deputy? He's here again. Take it. That's mine in full voucher. You're eating in my pantry.
You're in my pantry.
And who's this person to you? Oh, ma'am? Yes. Well, the first office, you're going to send somebody. So, I'm okay. Regardless. I know how it works.
I know how it works.
I'm okay.
Ma'am, what do you need?
That's not yours. Hello? I'm still here. Yes, ma'am. Thank you. Oh, thanks. Okay. Yeah, so... What do you want me to do? Put it back! Okay, you're just somebody you're over, so, like, do what it's gonna do. All right, have a good day.
Publishing the one video in this file that starts with file name Axon.
What's this? Okay. This is from June 18th, 2019. The last videos are from the 15th, so I imagine this is after that 911 call. Whew. 17:30. Oh, there's an officer already there.
What's up, bro?
It's the guys.
It is. So what happened? What's going on now? Did this just happen?
What? No.
I said earlier.
Oh, no, when I moved in, we dropped it.
So who called? So what's happening?
They're asking you, not me.
Yeah, you speak to him. I'll speak to you, man. Come here.
Sorry.
So I'm guessing you called for a reason, right?
Only 24 hours.
Yeah.
Okay.
Yeah, but you do realize he's here now, right? Have you been drinking?
I had a drink.
Okay.
It was raining.
I didn't drink. No, look at the door. I gotta keep an eye on my guy.
Okay, well.
Sir, I wouldn't hold the wall like that, officer. You have not yet perceived the danger, but I would put your arm down.
Yeah, after he's here. Yeah, you can stay right here. You can stay right here. He doesn't know. He doesn't know how to We left earlier. We respected your wish earlier. Yeah, we respected your wish earlier, okay? But he's here. Okay. That's the only reason. Yeah, I have to make it up. You can stay right here. He doesn't have to know. He doesn't have to know. He doesn't have to know. Oh, you can sit back and stop ringing. It's just sprinkling. It's okay.
Go in the corner if you want.
Yes, sir.
Hey, but I'm literally begging you, no.
Yeah, but you know he's gonna have to. Stay.
The deputy's like, ma'am, I'm gonna need you to stay outside. I'm gonna go inside and see what's going on.
I guess the physical or whatever, I don't know. I got taken out of here without no shirt, no shoes or whatever.
And then you went and saw the judge, right?
Yes.
And what did he say?
13 on count 2.
The judge was like...
Was it a female or male?
Female.
Female? Okay.
Yes.
What, you don't know what she said?
He was bad.
Ma'am, out! 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 They're trying to talk to George. Out! Stop coming in to listen to what they're saying. Out! Out! Go wait on the sidewalk. Let them talk to George. Out! I wonder how long she was creeping in the doorway for to hear what George was saying.
And what did he say?
13 on count 2.
The judge was like...
Was it a female or male?
Female.
Female? Okay.
Yes.
What, you don't know what she said?
He was bad.
Yes. My head hurts. So he's gonna fucking don't grab. That's a dog. I know. No, this is a thin blue line bracelet.
Green pineapple that says welcome. Green pineapple that says welcome. There we go. The green pineapple that says welcome is on the door. We have now clarified the pineapple.
Okay. And what was written on it? Stop.
I did not get it.
We're not gonna do it yet.
At all.
Did you get any form of paperwork?
I got paperwork, but I didn't get...
What was that paperwork for?
paperwork was,
Y'all, how is the jury sitting here with this? The jury is sitting here just being like, what are we watching?
And what does it say?
no.
With who? With who?
With her, but she never said anything like that. It was just the judge that put it.
The judge is the one that matters, right?
Is it?
Is she? I believe so. She's above us.
Is she above her?
She's the judge. She's the law. Okay?
Sir, the judge says you can't come over. You can't come over.
You guys don't want to take me in.
Is my other guy here?
Ma'am, get out of the doorway.
Okay. So here's the deal, man. Your paperwork says that you can't have any contact whatsoever with her. Okay. And if you do, it's a new charge. Okay. So.
That's her.
Have you been? Has she been drinking today? Have you been drinking? Okay. How long have you been here since?
Has she been drinking today? Sir.
I'm gonna be honest. You guys came here. She called me.
We know. Because we went to your work of employment. And they told, and they told us that you just left. Yep. And we knew that she called you. We knew that. We knew she called.
That's why this is coming in. She called me. Sir, it doesn't matter. If there is a no contact order, even if she calls you, you're the one that's going to catch a new charge. Even if she calls you, it does not matter if she calls you. The judge is the only one who can say it's okay.
Oh, it's just, she called me and said,
Yep.
coming.
You're correct. Okay, so you know what's gonna happen, right?
Yes.
Okay. Stand up. Stand up, Proffer. You can take one last puff.
Yep. Please?
Yeah, one last. Go ahead. Yeah, just put it out real quick.
Alright, wait, one more.
Wait, no, what?
Never make sure.
Come on, relax. 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 Okay? I want you to keep on doing it. I want you to know all around us.
I think she just yelled, babe, no, why? Because you called the police is why. Ah, that was me. That was user error. Hold on. Wait, nope, I backed up too far. Fail. Law nerds, I apologize. I have backed us up too far. Hold on.
You're correct.
All right.
Okay, so you know what's gonna happen, right?
I was trying to pause it.
Stand up. Stand up, Proffer. You can take one last puff.
Yep. Please?
Yeah, one last. Go ahead. Yeah, just put it out real quick.
Alright, wait, one more.
Wait, no, what?
Never make sure.
Come on, relax. 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 Okay? I want you to keep on doing it. I want you to know all around us.
Right, you promised.
I don't think they promised you that.
I think it was earlier.
Well, that was earlier. This is in transaction. Right?
I didn't call.
Yeah, you did.
See, I told you.
But you did you call him earlier?
See, I told you.
Because he just told us. And we know the store told us.
I told you. Wait, is there anything that you do?
You're good. You can stay right there.
No, is there anything that you not?
No, man, you know he has no contact order by the judge. He can't be here.
Okay. That's sometimes.
Yeah, but
You need help for anything?
no, we don't. We have our information already. So here's what's gonna happen, bud. You're gonna take the ride back down, and because it's almost 2 o'clock in the afternoon, you're gonna see a judge tomorrow morning. We'll see her today. Okay? It might be the same judge that gave me no contact order. Okay? That's it. From here on out, but until that case is resolved, you cannot come here. Okay? Or have contact with her, even if she invites you. Okay? She called us earlier, told us that you guys had a no contact order. Okay? She didn't want anything. Charge, nothing. So we told her because it's domestic. Send us over to ask you. Okay? So, alright, bud? Just make sure he's got nothing on him. Hey, you have anything on you, alright, bud? No, okay. We'll make it as cordial as can be. Okay? We promise, man, alright?
The wind!
What you say?
I love you, babe. Don't take it easy. You hear me? I love you. Call Private Love. Hello, get up.
The wind is killing me.
Sarah, call Private Love.
No.
It's all right, babe.
Just give me your mom's and your father's.
This is Sarah.
I don't know it. I don't know. Sarah?
What's the charges against?
So, the domestic battery charge that you guys did with last week or whatever it was, he was given a no contact order by the judge. Okay? Whether she invites him or not,
I know.
he knows he can't be here. So he was here this morning, and she called us this morning, okay? He's now back, and he knows by the disease that he can't get my contact. No, he gets a phone call when he's down there. Yeah, he gets one when he gets in. Well, if you got a piece of paper real quick, you can get it for me, and we'll give it to him.
You don't know your mother's number?
She had.
If you can get it real quick, we'll give it to him.
Can I get his mother's number?
Okay, make sure that.
I don't know who the guy in the blue shirt is. I would imagine
Publishing from folder
family,
OCSO
one of his family members.
19-078009. First item is a PDF of photographs.
He's like, it's a PDF. It's not a JPEG. It's not a GIF. It's a PDF. So these are all going to be entered. These are from the phone extraction.
Second item is the single video starting with Axon.
And another video from 8/29/2019. This is after that. The last one was 8/6/818, I think. And I know I've seen a lot of people in the chat asking why did they arrest him. He was there in violation of a no contact order. They have to. It's a new charge. It doesn't matter if she invited him over. It doesn't matter if she says she doesn't want him arrested. They have to arrest him because there are situations that can be very, very dangerous, and they can't know if this is going to be one of those situations. So they have to arrest him. He is there. He has a no contact. That there are no questions about that. I also don't doubt that she knows that, but We'll see. She called. She said, I don't necessarily need anybody to roll out. She knows they're going to. She told them there's a no contact. She told him he was there. They're going to have to arrest him. So let's keep going. He would have also known, by the way, he would have also been told when they gave him the no contact order, he would have been told in no uncertain terms by the court, you have a no contact order. You cannot have contact. You cannot go over there. You cannot have contact. It does not matter what she says. It does not matter until I remove the judge, the no contact order. You cannot have contact, period. So that would have been made clear to him as well. This is the 29th of August, 2019.
Oh, I have been here.
Yeah, I thought you looked familiar.
Because the last time I was here.
That's the officer saying, oh, I've been here.
You guys on the side of the bar. And you
No.
home like that.
No, we
Or
haven't.
he came home from a bar. Someone came home from a bar. Hey, who's that? Jorge George?
Yeah, what's up with the blind line? Is she there? She's dead. Okay, can you just pick it up? No problem.
What's going on, Ty?
You didn't think I'd call. Go, sis.
Okay, come on, George. Off couch.
Go up there. No, they're not staying on there.
Okay. I know you think this is time.
No, baby.
Sarah, are you serious?
Yeah, I don't want to be punched in the neck.
Are you serious?
Told you I will not hesitate.
No, it's okay.
This is it. This is like 12:25 p.m. It looked like he was asleep. Well, asleep under the influence on the couch.
Oh, he's nice enough to actually give you your shoes from last time.
Ma'am, you want to get Charlie for me?
Yes.
Sarah, are you serious now? Did you get a wallet you want to bring with you or a cell phone? No. Okay. Sarah, are you serious? Sarah, are you serious?
Punch me in the neck again.
Sarah, are you serious?
Am I allowed to shut my door to not?
Yeah, you can. I'll be right back with you.
We're going to go pop down here. Okay. Can you grab the paperwork?
Yeah.
We're going to sit right here in my truck. And how you going to go? Don't go nowhere, all right?
You sure you don't want me to watch him?
You can, come on. That'll work too.
She's the one that hit me, and I'm the one that just like her.
Well, let's just get down to the bottom of it, okay?
Alright. George, I want to talk to you. I want to ask some questions. I have you in handcuffs, so I've got to read you something real quick, okay? Do you understand? Yes. Alright. You have the right to remain silent. Anything you say will be used in a court as evidence against you. You are entitled to talk to an attorney now, have him present now, or at any time during questioning. If you cannot afford an attorney, will be appointed for you without cost. Do you understand these rights as I've read them to you? Okay. At any point hereafter you wish to remain silent, have an attorney present, all questioning will stop. Do you understand that? So even if you want to talk to me at first and you change your mind, just let me know. Okay? Alright. Has anyone at any time threatened, coerced, or promised you anything in order to induce you to make a statement? Have I promised you anything? Have I bribed you? Have I said, hey, if you tell me, give me a statement? Has any of that happened? No. Okay. Do you understand these rights as I've read them to you? Yes. All right. So, what were you two fighting about tonight?
We weren't fighting at all.
Okay. What are you fighting? I'm going to take that in there for that.
Let
me, I'll take the statement and get the statement done.
Oh, with him?
Huh?
From him?
No, for her. That way you can fill this out while you're 10-12 with him.
Sarah.
I'll get her information from her. Okay, listen. So why did you throw him in this? What up?
I don't.
Okay, can you explain the bruises she has? Those don't come from nowhere.
Really? Thank you.
I want your version of what happened. Okay, so you did hit her. Okay, so you get in the face and argue and get her to keep her away from you?
So that's her information that he's filling out. So he has all the info for reports. However, I don't know why we're playing this when
You did it all the time, but you're not. How does it usually happen to her? Because you know, you're going to defend, tell me. You just said it wasn't the defense. So, if you get hurt, you do it to set up, and you figured you could set it. Does that come? Okay. Sarah? No, you said that.
Oh, that's why. Because you can still hear him in the background.
I know, I've been on it before. If I was sorry, I'd let him know. I think you're fighting. Why happened?
Didn't know 22, 20 million, no means an hour ago. Today, 6 complainant, 3028 Riverdale, 3028 Riverdale, an hour ago via text message, code 32013.
Sorry about that. Sarah!
That's why they're playing it.
I know, but I'm not going to change things. I know why. Because you want to talk. What about and when I try to get the straight story, you don't want to give it to me. I'm sitting in the straight, please. You have the chance. All right. I've tried. All right. And now that you're going in the back of the car, you want to give me a story. It doesn't work that way. Okay. I do nothing but polite to you, trying to talk to you, trying to get straight answers, and you're beating around the bush. I'm not. Yes, ma'am. Do not start kicking and banging on things, okay?
Sorry, what's your phone number? What? What's your phone number? I don't know your phone number. Sarah, what's your phone number?
It's not him asking, it's us.
Who else is yelling?
You said, hey, what? Thank you.
This is Overruled 711 and 10601 R2C at Manslaughter, complainant versus business, reference to Richardson, as of 2017. Complainant female, pretty sure we need a very non-CRB.
Can you guys not put on music, please? Okay. Please.
Well, there's a lot going on audio-wise.
Fifth folder, OCSO 19-079759. First file is a PDF starting 48-2019.
PDFs of photos. These are the same photos the defense put into evidence as well. Or some of them are.
Second file is an audio file, 911 call, publishing.
It's not technically an emergency, just you've been there so many times before. I'm not there, but I'm just trying to go home. What is the address? 4748 France Court. What was the street name? France Court? France. F as in Frank, R-A-N-T-Z as in zebra. Oh, is it France? I don't know if it's there or not. I'm sorry? Ma'am, is it France Lane? I'm guessing so. It's France Court, but it always comes up as France Lane. Okay, what exactly is going on? I would like to go home, but I can't go home because he's there. Okay, do you have some sort of restraining order against him, or? He has a no contact. Is there an apartment number? 3. 1 second. I'm at my former husband's house right now because I can't go home. I don't even know if he's there or not. He was there earlier, but I can't go home. Okay, so do you want us to do a standby with you? What do you mean? Like, escort you to the residence, or I'm not understanding what you would like. If I could, please, can you guys go over there and just see if he's there? I'm pretty sure he locked me out earlier, so I think he's probably there still. I'm not going over there with him then. I'm not. Okay, does he live there? No. Okay, so how is he inside the residence then? He has a key that he took. Okay, so is he breaking into the apartment? He's not breaking, he's already in the apartment.
If he doesn't live there and he's in and he's not supposed to be, then yes, he's breaking in.
As far as I know, I don't know, like, if he's there or not. He knows where I hide my key.
Okay, what we can do is we can meet you a block away from the residence and go with you to the residence.
I don't know. I tried calling him to ask him to leave if he's not already. So I have my 8-year-old that I'm trying to watch out for right now. So I'm not really sure what I'm supposed to be doing. I just want to go home.
Okay, if you want to go home and you're not sure if he's there or not, we can meet you when you're about 5 minutes to a block away and go with you to make sure he's not there.
Okay, well, okay. I'm about to be honest with you, kicked out of my apartment because you guys get called so often, and like the brigade comes and this, that, and everything, and like the neighbors complain about everything. I'm trying to avoid that. I just want to go home.
Okay, regardless, the deputies are going to go to the apartment, whether it's with you, what I'm suggesting you do, or it's what you want to do. Just have them go to the apartment. So regardless, people are going to see that there's deputies going to that address.
Okay, so when I called you guys like a couple of days ago, and they didn't make like not a ruckus, but like they made it like incognito, which is what I need, because I'm going to get kicked out of my place.
Okay, when we do a standby, ma'am, all we're going to do is accompany you to the address and the deputy to make sure that he is not there, and then they will leave. If that's all that's going on in this situation right now that you're calling for, it's not going to be like a big deal.
And what happens when he is there?
If he is there and you don't want him there, you can have him trespass. They're going to make sure he can leave. I mean, if he does not live there like you're saying, and he should not be in there, you can trespass him. You already have a no contact order with him. They will remove him.
Okay, well, there was an altercation earlier, and I'll be honest with you. There was an altercation earlier. So that's when he came in, the altercation happened. So that's when I left. I fled. Barefoot. Now I'm at my former husband's house.
Okay, would you like the officers to meet you where you're at right now?
I don't want to get arrested. I don't, because I fought for myself, and I have my 8-year-old, and I just want to go home and sleep in my own bed right now. But I did fight back. I'm not going to lie. So.
Okay, well, I mean, if you're wanting us to meet with you or go to your house, I mean, I don't know what they're going to do. If they're either going to arrest anyone, arrest you, arrest him. That's all up to the deputy and what he concludes from the situation that's going on.
Yeah, you can't control what happens.
Right now, it's just up to what you want to do right now. If you want to do a standby, we'll accompany you to the residence. I mean, it's really just what you want to do.
I know. I have to take my time to go tomorrow.
Or what I can do is I can have the deputy call you about the matter. If you want to speak to a deputy directly, and if you want to do that first before having us respond out there.
Yes, please.
Okay.
I can have a deputy to call you. Yes, please.
Sarah?
1 second, Sarah.
Thank you for your help. Actually, more ways than one.
And is a good phone number for you 407-716-8684?
Yes, ma'am.
Okay. I'm going to set up a call for a deputy to call you over the phone, so you can talk to them directly and see what they say about the situation. And when they call you, it'll be from a blocked or restricted number. So if you get a call like that, just make sure you answer. It's going to be the deputy, okay?
Yes, ma'am.
All right. If anything changes or you decide you just want us to come out to give us a call back, okay?
Yes. And what was your name?
My name's Rachel.
Rachel, thank you so much for your help, and I've got the phone right here on the line.
Okay, perfect. Bye-bye.
Thank you. Bye.
Dispatch tries to help.
Publishing the one video in the folder starting.
I don't know how dispatchers have the patience that they do. I could put together a large list of things I'd be terrible at, but dispatch is one of them, because the amount of things that come in onto their lap that they have to deal with and sort out and figure out what people want to do is absolutely mind-boggling to me. But all of the dispatchers have been incredibly patient with her. Like, it's not an emergency, but this, it's like, ma'am, what do you need from, help me help you? What do you need?
With 1924.
And I imagine this is the rollout from that
41:30
911
to
call. So this would be the rollout from that call. Because that seems to be the pattern that the DA is going in. With the 911 call and then the rollout. Which I think is helpful, because on the time she's like, I didn't call. It's like, literally, we just listened to it. So this is September 5th, 2019. Well, that is a police knock if I've ever heard one.
I'll take this even here about it.
Yeah, both of these.
Sarah, can we go incognito? The police,
Is there a back door?
yeah, that's not how we do things.
No.
If you go 10-12, just let us know. Well, thought that was open for a second.
Yeah, put back in.
That's the back patio. Or looks like the back patio.
Locked. That's Tonia. Yeah, the back's locked.
Anyway, you want to call your ex-husband? You have a phone?
There's a charger. That's
It's not in the house.
Excuse me?
That's not to say that it's not in there, just because the doors are locked.
I don't understand. You think he's inside?
Yes.
Okay, well, we need a key so we can get inside, so he's inside. That's what I'm getting at.
And if your phone's gonna die, there's a charger in back on the back side of the porch.
Oh, yeah.
If he's in the house, he's not coming to the door, but I do have my spare key.
I don't have my spare
I
key.
can get in. If there's no other way of getting in my house. Unfortunately, can you please bring me my spare key?
Oh, can you bring me my spare key?
Yes,
I imagine she's calling Brian Boone.
The front door and back door. I have no way of getting it.
Where do you live at, man?
I'm sorry?
Is that you said that's your ex?
Last night, right on the street. He'll be here in like 2 minutes.
Perfect. Thank you so much.
No, thank you.
Is your this your three things here? Your ex-boyfriend? Is that correct?
This is my place.
Okay. But the boyfriend or ex-boyfriend?
I don't know what's going on.
Somebody related?
Pretty.
Okay.
Okay. Does he not have any weapons?
No.
Okay.
No.
He was arrested last week for bad TV.
You guys actually want to take a picture right here? You can see that.
Saw he was arrested before. Was that also like a month ago?
Last week.
Yeah. But that's why I called you. And again, I was sleeping. You waked it when I was sleeping.
How much did you have to drink tonight?
Only God knows.
How much did you have to drink tonight?
2 drinks. And that was what, 4
2
hours
drinks.
ago?
So what's the layout of the house? Is it both floors? Is this part here? Or is that something? So these 2 windows right there.
What kind of vehicle does he drive?
It's a bike. But I bought some.
See a little bit of movement on the side.
It's me about her, my dog. I had to define dog and a dead dog.
Oh, gotcha.
So I have a feeling it's probably text. Just the best one.
However, she was at
Does he have anywhere else to go? Or is this the only place he has?
She was at Brian Boone's house when she called the police. I presume the police picked her up there and brought her over to the house because that's what they were talking about doing on dispatch. I don't know why she didn't bring the key, but that's a lot of logicking. But then she called her ex to come bring her the key. He presumably has their kid. It's, you know, it looks 01:16. So what, 1:15 in the morning?
His parents' house.
Where's that at?
80-15 Boulevard.
I can imagine that the neighbors are like, that's loud.
Oh, gotcha.
Guys, can I say something now?
Sure.
If both doors are locked, he has to be in there.
Why is that? He can't lock it from the outside?
No.
Doesn't he have a key here for you though?
Unless he took my spare key, which I'm pretty sure he probably did, he has to be in there. Especially the back door.
Is the spare key, was the spare key in the house?
No, I hate outside because he locks me out all the time. So I'm going to say that then. If both doors are locked, he has to be in there. Y'all can have the key. Y'all can open the door.
Hey, you're gonna stay outside till we make sure nobody's inside.
Yeah, you're going to stay outside and we make sure nobody's inside. She's like, I'm not going to.
Hanging out here.
I am. I'm not going in there. There's no weapon.
George?
There's no weapon.
Ask for a minute. Ask for a minute.
That's Lucas.
Reference building search.
I know, but... Charlie, 124, Charlie.
Thanks, sir.
Can we get minimum traffic for a building search?
Everybody make an announcement?
Yeah.
You guys don't have to do that.
Man, we don't have a way to do things. Just let's do our thing, okay?
Hey, ma'am, we're adults. Ma'am, we're adults. Thanks for letting us do our job.
Sheriff's office, you in there, come on out.
Pull ladder. Sheriff's office. Yeeted, come on out. I got a dog. George! Hello. Yeah. We have a ton of plants on the right side.
That's when you get that stairwell, just fuck your, go right up, or don't pull up, that's when you got up. George! Please! If you're up there, let us know, because we're coming up anyway. Go ahead. Run, whenever you're comfortable.
Yeah. Open door right there.
I think that's the kid's bedroom.
Okay.
Yeah, I don't hear the dogs barking either.
I got it.
A lot of you have pointed it out. In any of these videos,
Someone come in.
never hear the dogs
Going that
bark.
way. Boy! Show your hand. Come on, hands
He's
up.
saying, I'm here.
George, step out with your hands up. Put your hands behind your head.
Hey, turn around, face away from me. Turn around. Walk back to me. Walk back, walk back. Just being the thing right now. I'm going to... Why didn't you tell us? Huh? Honestly, you didn't hear his reason you're sitting in the bathroom. That's what?
And once you're trying to go back to normal.
Hey guys, can I?
Before you go, we're not doing anything right now. Alright, we're not taking out a room. I'm gonna sit you down on the bed right here.
Okay. Okay.
Alright. Let me ask you a question.
Yeah.
What happened today? You got a light in here?
Yeah.
You just gotta pull the thing?
Yeah.
What happened?
I don't even know what the heck happened.
There's a reason you're hiding in the bathroom, so don't act like we're not up here for no reason.
No, I know that.
Okay, so
I'm hiding in the bathroom because we had a discussion and as usual, and I am in the wrong.
Okay. Why?
I am with what is it called? It's called
No contract for it?
no. But we
How long have you been here? How many days since you got released? When did you get released? Because you were arrested last week, right?
Yeah.
Alright, when did you get out?
Let's say 3 days ago or something like
It was
that.
on the weekend?
Yeah,
Because today's Wednesday, or was it Monday? Or was it this weekend or was it Monday?
the weekend.
Okay. After that, did you guys talk and come back here and yeah, this weekend? And everything was fine between you two? So tonight, what happened tonight?
I don't know what happened tonight.
George? 3 cops standing in front of you. You're hiding in the bathroom.
Yeah, I know that.
Okay. That's not for no reason. Right?
Wifey is nuts, and she always freaking starts stuff, and she.
So that's what I'm asking. I'm telling you. Tell me what happened.
She puts it on me
Okay. She puts it on you.
all the time.
Well, you're not. None of that gives me any insight as to what happened tonight.
Nothing.
Both are very big. She's very big. You're very big. Any more than big.
What is she being big about?
I can't
You're saying
discuss with
vague.
you. That we discussed to me. Right?
We just want to hear your side of things, but this.
Oh, everybody wants to hear my side
Yeah.
all the time.
George, I didn't know you. Okay. Because this isn't the first incident from you two.
No, I know
She's been
that.
arrested as well, hasn't she?
Yes.
Okay. So tell me what happened. You all drinking?
Yes.
Both of you?
Yes.
Okay. I can smell alcohol on her, so I know that's I already knew that, obviously. But,
we've been going through a lot. Right now, I work at Ace right here, across the street. We're going through a lot, and they're about to shut down and whatnot.
at Ace?
Yes.
Okay. Just tell her not to come back.
May I please have some water?
Just wait. There's a, you can't drink that for right now? Oh, you can't come in here for right now. Okay, you're gonna have to wait. Give us a couple minutes.
He's like, ma'am, give us a minute.
Are you injured in any way?
No.
No. She in fact, no. Did she injure you today? Did she hurt you? Mentally, maybe emotionally, or whatever? Any physical injuries? No?
I'm the one. I'm always the one.
You're the only one saying that. You're saying that.
I'm always the one.
But you're the only one saying that. Nobody here's saying that. But if you don't help me, how can I help you? If you don't tell me what happened, how can I help you?
That's my woman.
Okay. Sometimes that's what it is. Is that as much as you want to give me?
What's she saying?
George, I told you I can't tell you that. If you're not going to tell me what's happening, I can't. I'm not going to tell you what she told me just so you can know exactly what it is. I can't feed you information. Why don't you ever call us?
Why?
Why not?
Would you call you? Would you call?
Look, I've never been in enough depositions, so I can't say.
That is your beefcake.
It ain't like that. My girlfriend's mom, she's crazy, so.
I am, what am I going to say? I'm actually wrong right now.
You're wrong right now?
Yes.
No matter what way you're saying you're wrong, no matter what way you cut it?
No way, shape, or form, you know that I am.
I can respect the responsibility, because most guys won't even take responsibility.
You're going to take me in no matter what.
You're gonna take man no matter what.
I take girls in jail all the time, but that battery all the time.
No, you're going to take me in because I did the no contact.
You know what that no contact said?
Yeah, I'm fucked.
What did it say?
I am fucked.
What are you not supposed to do?
Oh, man. You're the one that took me to the start. How you?
I think it was better than all.
It wasn't me. I don't work this time.
But they're not, they're a little similar. They look a little.
Our hairstyle's the same.
Yeah. Yeah. It's not the same guy. I promise.
No, I promise you. I won't remember you. It's not me. But what did no contact order tell you? What did the judge tell you?
Was not certain.
You don't know.
You're in contact with her at all.
What about in relation to this place? Are you allowed to come back?
Oh, yeah, no. Yeah.
Let me ask you this. Do you just have no place to go?
No, I've got a place to go. But
Your mom's place?
yeah.
They still over there by Twisty Tree?
Yeah.
I do my homework.
But before you guys take me, can I get at least shoes?
What kind of shoes you want? You want some comfy ones, some fly ones?
Like those, no fly ones.
These, I like these leather ones.
Get the blue ones, please.
This one right here?
Yes.
Which shirt you want?
And that black one right there.
This black shirt?
Yes.
You want socks?
Yes, they're right there.
You got a wallet, phone?
My phone is upstairs.
That's it. Have a wallet.
Not that shirt.
There's another black shirt. This one? Maybe it's this one. Is that the other one? They're both inside out. I don't know.
The ace? Yeah.
You like the ace one?
Yes.
Alright, we'll do that one.
Can I, please, sir?
Please what? What do you need?
So I can put them on?
Oh yeah, we'll handle that in a second. Let's get the shoes on.
Okay.
Where do you say the socks were?
Top shelf, yes.
Is it black or white?
White ones.
Okay.
How many years been together?
3 years.
3 years, really. That's always behind us?
My phone's somewhere in the house. It don't really matter. I'll answer. Okay.
I can't tell if the feed jumped. I can't tell if the feed jumped or they edited the video, so I'm just going to back it up. No, it looks like it was cut from that point to that point. All right. Just wanted to double check. Because the feed did jump earlier.
How many years been together?
3 years.
3 years, really. That's always behind us?
My phone's somewhere in the house. It don't really matter. I'll answer. Okay.
Just step up right here for me, please. I just gotta get him to you. Are you okay? Oh, what? Oh, okay. Okay. Yeah, no, it's okay. Just a quick question. He's asking about his phone. Do you know where that'd be?
No, I don't know where his phone is.
Okay. You don't have it in your vehicle or anything?
I do not.
Okay.
I happen to find my phone. Wait. I need my car keys.
Okay. They're not on here. They're inside the house somewhere.
You seen them?
I haven't seen them, but they're in there somewhere. They're not on here because I had to search him before he got in the vehicle.
If it's news to ask, you can ask him where they are, please.
Okay.
I only have one, sir.
Okay. You don't know where his phone is? Okay. She's asking about her car keys. She said we asked him, should we ask him right now?
He doesn't have nothing in his pocket, so.
Okay.
Where is she?
She's up behind your vehicle.
Yeah, do you want to just take that or?
Okay, yeah. Hold on. Huh? No, he didn't have anything in his pocket. Can we take a picture real quick? You don't mind? We're gonna take one overall?
No, they are.
Man, do you mind? Stay right there. Actually, a little more this way, but so we don't get the police car in there.
I heard these places, if you don't mind.
You said what? You want me to shine a light on it? You close? No, actually, they can do it. Okay.
I need my car keys.
He didn't have anything in his pockets.
I'm gonna go on this side one.
Yeah.
Yeah, no, absolutely.
They're going to be coming this way, so if you want. Okay. Yeah.
One dog's sleeping downstairs and one's in your bedroom.
The dogs were not bothered by any of this ever.
You have any other questions?
I don't think we've heard a dog bark once.
I'm sure they're in there somewhere.
She's like, my car keys. They're like, I'm sure they're in the house. Bye.
That's it for that exhibit. The state is at the pleasure of the court and the jury if we want to proceed.
The
Can the
text
parties
messages.
approach for a moment?
Yeah, no, they're almost out of time for the court day, and they are going to have to talk about the court message, the text messages. So I will ask you guys as we wrap up if you thought the videos changed your opinion about the case or not.
Thank you so much.
Are they going to let the jury go for the day? I think they are.
All right, members of the jury, thank you so much for your attention this afternoon. The state still has some additional evidence to place into evidence. It's about an hour or so. Now, I know I got a note this morning, we can't stay past 5:30. So the question I have for y'all is, are you okay with staying until 5:30? Or do you want to go ahead and call it an evening?
Let's do it
At this
tomorrow.
point in time, I leave it to you.
Let's come back in the morning.
It's 5 o'clock. 5:03, exactly.
Let's just reconvene in the AM.
I say keep going. Does anyone reject?
If Lauren can stay.
Somebody's like, I said, let's keep going.
5:30, correct, though? That's my understanding.
5:30.
Okay, thank you, sir. All right,
This
state, you may
jury's like,
continue.
let's stay till
Commission
5:30.
published 21, which was P for identification.
Me, I'm like, let's call it. And the jury's like, we have till 5:30. We got a half an hour of our time. We got 30 more minutes.
You may proceed, sir. Are they audio or video?
It'll be video, thank you.
Are these redacted, counselor?
No.
Okay, thank you. All right, members of the jury, I have an instruction just to read to you with regard to States 21 that you just saw.
That was 22.
I'm sorry, States 22, forgive me. Members of the jury, you have viewed and listened to video and audio recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of this case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you viewed, listened to, and consider this evidence. Thank you. State, you may proceed.
States 21's DVD in its main folder is labeled a folder of attachments, and then there's a file labeled extraction.
There's a
Going
lot of you
into
in the
folder
chat saying, I think the
attachments.
jury's intrigued. I think they're in. Also, it's like, look, if we're done, we're done. Let's just keep going. Because they're getting close to closing. I think this is the last exhibit for the state. I don't expect any more witnesses for the state. So they'll be able to get to closing
First file
tomorrow.
being published.
Hopefully.
IMG_0665.mov. Date modified metadata indicates 12/3/2019, 2:05 p.m.
Whenever you leave the house, just let me know where you're going.
And you're gonna let me leave?
Yes. Just let me know where you're going.
And I get to leave the house?
Yes.
Exit?
Just let me know where you're going so at least I know where you're at.
Anything else you'd like to add?
I love you.
So it's not yank me back in the house and sit the fuck down and shut the fuck up?
No.
Yank.
No. Just let me know where you're going so I know where you're at. So if you don't come back, there's no certain time. You don't have to come home at a certain time because I'm not. You're grown up. I just want to know that if it does surpass a certain time, that's like shit. Where's she at? I know where you told me you were going to be at. So that way I can go and...
So I'm not allowed to have friends?
Yes, nobody said you can't have friends.
I need to go see Boo.
You can go see whoever. I just don't want you to go frolicking with male friends. By yourself because you know what's happened already. You understand what I'm saying?
So I get to go see Boo.
Do you get what I'm saying?
I get to go see Boo.
I don't care about Boo. You can go to see Boo. Do you understand what I'm saying, though?
Next video is a long file name that starts with 2A494, and it's the only one that will show up with that search. Date modified indicates 12/29/19, 12:26 p.m.
Hi. Fuck you.
I don't know what you talking about.
Let's just tell everybody you got crumpled on the bed.
Crumpled? Crumpled. The word you're using is crumpled? Alright. Alright, so this is my Jesus, you gotta put it all over my face, dude. I know you're trolling me, but you gotta put it all. What the fuck is that?
Did he say, I know you're trolling me?
Stop.
Bum rushed.
Yeah, you're bum.
I bum rushed you.
Yeah, whatever. Anyways.
What was the choice?
So, the choice was to beat your ass or get my ass beat or whatever.
No.
Huh?
Twas.
Huh?
Twas.
Twat?
Twas.
I like twat. I've been trying to get twat from this woman.
I didn't think I Like Twat would be coming into this trial.
I've been trying.
But there we are.
Pardon me. The phone. I've been trying to get some of that right there. She's on some other shit.
That's his phone.
What's going on? She's trying to film me, filming her, and blah, blah, blah.
I'm cooler than you.
No, yeah, you are. You are cooler than me. You are cooler than me.
Where did his phone end
She
up
is
going?
cooler than me. She is. Beyond cooler than me.
Oh, I want to get this on film tape. Did I take your cigarettes tonight?
No.
Did I take your cigarettes to the beach?
No.
Then who was blaming on?
You. I blame it on you. Sorry. I apologize. Can I walk around this way and actually film it better? I don't want darkness because you're not dark. Ah, ooh, there she goes. There she goes. What are you filming? You filming me filming you? You filming me filming you?
What's the thing you've done me wrong by?
Man.
He said, can I get up and film it over here?
And I watch porno.
I want to know where his phone went.
What's the thing you've done me wrong by?
Man, I watch porno. Hey. Wait. It stopped.
My husband.
What's up? I was watching porno. She don't like that. I'm not shrugging my shoulders or anything like that. Like it's not no big deal.
After you begged and pled and cried.
Yeah.
We trust you.
I know. I'm not shrugging my.
Say it. Beg.
Yeah.
Pled. Cried.
You begged?
I didn't. You did.
Well, whatever. Okay, yeah, I did.
Say it.
I begged and
Pled
pled
and cried
and cried
for me to trust you.
for you to trust me. But again, I'm not
Did
sure.
you?
Did I watch porno again? Yes, I did. But
Good.
I want to know what was on his phone.
Next is a video starting with 3BB0C. Metadata shows
And
date
where
modified
it went.
12/29, 12:36 p.m. of 2019.
Yeah. So you remember this. So you remember this. Are you drunk right now?
no, man,
How much alcohol did you drink?
enough to be drunk.
You're slurring your words. You're sleeping up against the door right now.
Yeah, because I want to be next to you.
Did I not tell you to not bother me?
Yes, ma'am.
So what is it you come up and do? What time is it right now? It's 1:20 a.m.
Okay.
He was asleep.
I haven't bothered you since then.
He was asleep. He was asleep.
But didn't I tell you before at 9:30 to not bother me at all?
Yes.
Because why?
Yeah, so good tomorrow.
Nope. Because I've been
He was asleep.
up since 4 a.m. since yesterday when you fucked with me.
Yes, ma'am.
Is he saying yes, ma'am?
I know how much vodka was in that bottle. And what's the bottle now?
Kind of to throw it out.
What does that mean?
One more drink.
The bottle's empty. I know how much vodka was in there. Enough for two people to have a really good time. And who drank it?
So sad.
I want it to be documented that I'm leaving you, which means that you're getting out. You're getting out. You're getting out.
Nobody's leaving nobody. Stop.
And the reason why you were even downstairs and weak enough to get drunk was because you don't give a shit about me. You don't listen to what I say. Special things that I keep on my front page of my phone so I remember to tell you about it because of how special and fun it is. I always bother you. I always bore you. You don't listen to me. Yesterday was my first day at work, remember? And I ended up 90% hearing about your day and 10% about mine.
You don't bother me or anything. So sometimes you just you overwhelm me. That's the problem. You overwhelm me.
By telling you about my first day at work?
No, dude, you just overwhelm me about every other thing too. Not just first day of work.
So I'm overwhelming you by telling you about the fourth highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So the reason why, so you fully admit now that you didn't care and you did brush me off in the car. Midway sentence. Because you're not into baseball.
No, I didn't do that. I'm just saying.
I want to go to sleep. Go downstairs.
Yeah. I know.
I'm leaving you, and I'm going to try and cancel plane tickets.
No.
Because I don't do special things for people like you that are doing it. It's like, to me, after I asked you at 1:21 in the morning,
I'm not doing it.
I wanted to be asleep. I wanted to stay asleep, which is why I got into bed at 8:30.
You woke him
I
up.
told you not to step foot in the bedroom. So what do? Nonetheless, you're drunk. The amount of alcohol, I know how much was alcohol, I know how much was in there. That's why I could smell you in the bed before you actually got me up. I can smell you from here. You're despicable.
How am I despicable? I'm not even doing anything.
Leave me alone.
Okay.
You're not gonna remember shit. Okay.
Yeah, okay. Well, I'm not doing nothing right now.
Get away from me.
What? What?
Get away from me.
He's in the fetal position against a wall, Sarah.
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
How is that?
Keep going. And I dare you. I dare you. I dare you. You get on your fucking little bike and go to fuck you work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out,
Get the fuck out of here.
I dare you. Yep, look at it. Wait, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder. Get away from me.
Dude, nobody's doing anything.
I'm gonna fucking hurt you.
Nobody's doing anything. And you're filming it.
Let me go.
Nobody's doing anything.
I'm asking you, George, to get away from me. Please get away from me. Get away from me.
Yeah, I am. That was your function, dude. Malfunction. No, your malfunction is you, dude.
Okay, whatever you say. Whatever you say. Holy shit, the whole hallway just reeks of you up here. First it's shit, now it's alcohol. Don't step foot in this bedroom. I can't even breathe. Like, it's disgusting. Like, it's disgusting.
Keep filming when it's fucking way. Good night, Sarah. Love you.
I don't love you. I don't like you. I don't want to be with you.
Well, I guess we know why the state didn't really cross-examine her much. Y'all were asking me, Emily, why didn't the state cross-examine Sarah Boone more? And I was like, I don't know what the state's doing. The state's like, we're just gonna play the video. You want me to cross-examine you? Don't care. You want me to object to that more? Don't care. You want me to do this? Nope. We're just gonna roll the videos. That's it. We're just gonna roll the videos in our rebuttal. She's gonna bring in battered spouse. If that's what she wants to do, we're gonna push play. And that's our case. So that, which is why I always say, keep an open mind till the end of the case, because you never know what evidence is going to come in. I don't think anyone's seen any of these videos. I know a lot has been out in this case, but I don't think any of this has. So when the state's like, yeah, we don't need you to lie to us more, we're just gonna see what you chose to record. that's why. And we haven't even gotten to the text messages yet. So
Next video starts 456. That's the only file that starts with
y'all,
that.
it's really hard to watch. I get
Date
it.
modified metadata, 12/29/2019, 4:04 p.m.
And I'm not gonna have no Hindenburg situation, no Titanic situation, okay? So it's gonna be a good day. Yes, I'm messing my mustache right now. And later on, everything's gonna go off. Truth, facts. Truth and facts. All of this is gonna be missing later on. We'll take another video again later on when it happens. Love y'all whoever watches this video.
No, that's not approved.
That's not approved?
The FDA says it's approved.
So it's gonna be a good day all day.
Yes, it is. Even when I
All day.
shave all of this
All
off.
day.
Yes. Even when I shave all of this off.
All day.
It's gonna be an amazing day.
It's what time right now?
Shaboing
I would
boing.
say 9:30. 10 o'clock maybe.
Shaboing boing. That's what we're doing later on. Shaboing boing. You can stop filming now.
Not good enough.
It's gonna be a great day. Today's a great day to have a great day. Boom. Cut. Somebody come in with the. Can somebody come in with the? Can you not?
Next file is image_093.mov. Metadata date modified 1/3/2020, 2:48 p.m.
It's 6:13 and I asked him not to play music. Because I told him that I'm just gonna go to shit.
Pretty proudly.
Is this the music that makes her mad? Maybe? Did we get a glimpse
Next
of the
file is
fractious music?
img_0975.mov. Metadata shows date modified January 19th, 2020, 2:58 p.m.
Time.
Sirens. 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 Sirens.
The wee-woos, sir?
Sirens and sirens and sirens. And this cop car.
How about you get an umbrella and call me Camille underneath it?
Yeah, how about we forget about that? No, we won't.
I'll never be.
No. How about we keep going on? Okay, how about this? When beautiful Lucas is here, we don't listen to none of that. I don't want to hear sirens. It's just beep, 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 all that, whatever. I want to listen to that. It's every single day. Beeping and we hear enough of it out here in reality.
Are you gonna be nice tonight?
Yes. Yes. I promise you, I used to choose
Go for a walk.
by myself.
Yes.
No.
Go for a walk.
No, I'm just gonna chill out. If that's the case, I'll just chill out. So much like this.
Don't ever be a woman.
How can I be a woman?
Don't ever.
I can't. But I can somewhat understand.
Don't ever.
I can somewhat understand somewhat understand. I can somewhat understand, yes, where you're coming from. But when you have a child and it's like right now, this is too much. But we had a blast with him. Amazing.
Then you got out of sorts and pushed me, and he stole my phone and called Brian.
Why is it that I got out of sorts?
You pushed me.
I pushed you. I didn't push you. How do I get out of sorts all of a sudden? I don't want to hear it.
You drink too much, and you're upset.
Drink too much.
Go get your fuck card shit.
What are you talking about?
Your retard paper.
Ma'am.
Don't hit women.
Have I hit you? No. So where are you going with this?
I'm turning this off.
Tell me whatever else you have off.
What is she talking about?
You can film me, take a picture of whatever you want.
You can tell you're on my phone.
I'm not doing.
Do I ever get a bus? No, I don't.
I'm not doing anything to you.
No, I
Sarah.
never do.
I'm not doing anything to you, Sarah.
That's my name. Don't wear it out.
Sarita.
What?
I'm not doing anything to you.
Yet.
It's not yet. I will not.
Mr. J.
It is 5:28, and we have 3 minutes and 49 seconds of videos if the jury is capable of staying.
I got a hot thumbs up from the jury. You may proceed, sir.
Got a hot thumbs up. The jury's like, roll it, sir. Don't stop now. We've got 3 minutes left. Be done. The
Next
jury's
image,
like, I need to
movie
go
is
take a bath.
IMG_10.
The jury probably needs it is very, very heavy stuff. And the jury has to be sitting there going, what has happened today? So when he's like, we've got 3 minutes left, they're like, please let us be done.
011.move. Metadata shows date modified 2/2/2020, 11:42 p.m.
Wow. And the jury hot thumbs up. I think they were like, 3 minutes, go.
This is what happens when you're going upstairs to ask for my car keys, alright? Because it takes you all the time. Where are my car keys? Where are my car keys? Where are my car keys?
Where are you with that? What are you talking about?
No, they're not. You took them.
Sarah, I didn't take your car keys. David,
Where are my car keys?
where they at? All the time. What in the world are you talking about? They're in the. They're there with
No, they're not.
Sarah. They're at the.
No, they're not. You took them. And why don't you walk away with them?
Why would I take your freaking car keys?
Oh, you're not gonna curse now?
What are you talking about?
You took my car keys.
I didn't take your car keys.
You did.
Wow.
Movie starting with file name B51, long file name. Metadata shows 12/29/2019, 4:04 p.m. modified.
I'm gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and it got out of hand. Isolated situation, it has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She
Especially her. So please, if you can,
dismiss
this case.
Close.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she'd be an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. I love you to death. And I hate that we're going through this right now.
It's not it.
What?
And they did.
You're good. I love you, baby. Wherever you want to. God will prevail, and it will take us out of this situation. Love you.
Wow.
That'll be it for today, Judge.
All right. Keep the lights back on.
Yep. That'll be it for today, Judge. That'll
Members
be
of the
it.
jury, it is 5:33 p.m. I thank you again for your time and your service in this matter. I'm going to give you another instruction before I discharge you for the evening.
I'm sorry.
Jurors,
did you give the prosecution a microphone to drop? He wanted to drop a mic. He wanted to drop a microphone. That'll be it for today, Judge. Thanks. We've had our moments, and that'll be all. Thank you, ladies and gentlemen. We've got some jury instructions we need to figure out.
Must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we'll see you again tomorrow morning here at 9 a.m. and 12 Alpha. Thank you so much.
Chat, you guys doing okay? That was a lot. That was a lot. His law clerk's like, why didn't she take the plea again, Your Honor? They offered her 15 years, right? Can we talk about that? Because she knew about the videos, right? I'm being sarcastic. She had the videos. Those were from her phone. She knew they had them, and she had all the evidence. She represented herself for a while and had all the evidence. Let's see what the scheduling looks like.
State, how much additional presentation do we anticipate tomorrow, sir?
It's just reading from the
He's like, we're good.
108-page PDF that was on that last exhibit. I haven't.
108 pages of text messages they are going to read into the record.
Practice reading it in front of the mirror, so I'm not too sure, but
108 pages is going to take you over an hour, buddy. And I read kind of fast when I read on the internet. It's going to a little bit more than an hour to read all that.
Not too long.
Okay.
40 minutes.
An hour, more
40?
than an hour.
Okay. All right. And then you'll be
it's
resting
text.
at that point in time, correct?
Yes, Your Honor.
All right. Defense, what, if any, positions do you have at this point in time?
There's your what if any for today.
Judge, I don't think we're going to put on a server bubble, but we'll think about it overnight.
I don't think we're going to put on a server rebuttal, but we think about it overnight. You know what the text messages are. And it is text, so it'll go faster than briefings.
I'll certainly let you stew on it this evening. I know it's been a long day for all of us.
Yep.
Where are we and how do we want to address the jury instructions? Because that is going to take some time.
I wish he would have told the jury to come back a little bit later. Like, hey, jury, be back at 11. We're going to do jury instructions. Or let them go early. But either way, I don't know if they're going to finish tomorrow.
I say,
let's hear what you have to
I
say.
was thinking we should have had the jury come in at 10.
Agree with you, Owen. I
Well,
agree.
the other alternative that I can suggest is I can be here at 8.
No.
I can get here at 8.
No, Your Honor, no. The lawyers are exhausted. Owens is like, what? We should have had the jury come in later. Yes, the judge. I can come in earlier, sir. Sir, no.
And we could start working on jury instructions at that point in time, at least so we can move forward through some of it. And then we could try to just move forward from there. I'm here for y'all. You tell me what you want.
State's fine with starting on the charge conference at 8.
I mean, my worry is it's going to take us some time. And if we start at 9:40, and it's going to take some time to work our way through these jury instructions. I don't want them sitting back there for 2+ hours just hanging out.
They should have come in
We can
late.
at least get ahead of that.
Could we let them know to come in later?
They're still here. I'm fine with that.
Yes.
State?
Yes. Yes, that. Yes, that.
You're gone.
That. No, that.
What I'm hearing is maybe closing arguments start at 1.
Owens and I are on exactly the same page. Emily is not an early riser. Everyone on the West Coast is like, no, please,
That's
God.
possible, if we can get through all the instructions. Mr. Henderson?
If I could compromise, how about 8:30, Judge?
I'm up at 5:30. It makes no difference to me.
Your Honor, ew.
All right. 8:30
Why?
it is. We'll see you all at 8:30 tomorrow morning, and we'll start to go through the instructions. Anything else, State, we need to address?
No, Your Honor.
State or defense? All right, thank you all very much. We'll see you tomorrow morning at 8:30. We're off the record.
Great. Well, we'll give ourselves some Zoom room tomorrow, but it looks like we'll be starting earlier than usual. So I'm going to need some sleep. It looks like we'll be starting earlier than usual tomorrow, but Chad, I'm going to try to summarize a little bit and then we're doing this tomorrow for everyone that also gets up at 5:30 in the morning, and those I know who are judges also get up at 5:30 in the morning. That's not my world. I have no judgment for you. I love it. But the thing that is very helpful at my household, my husband is a bit more of an early riser. I am a bit more of a later gator. So it works really nice. He's up early. I'm up late. So when our kids were little, he's like, I got the morning. I'm like, I got the evening. And it just, it worked out very well. And then when he's like, hey, I'm going to go, sit out and have a early morning cup of coffee on the deck. I'm like, you enjoy the quiet, sir. And I'm like, I'm going to finish, I don't know, reworking the layout of my office at 10 p.m. He's like, I'm going to bed. Have fun with that. But yeah, most of the people I know who are judges are also up around 5:30. I cannot. Okay. Let's try to do a summary. We're going to do some Q&A. Everybody, you doing okay? Just today was unexpected. Look, this is why we say keep an open mind. Just keep an open mind to court, because you never know what is going to happen in court. And you never know. It's hard. You never know what the evidence is going to show. You never know what the prosecution or the defense has in their case. We don't know. So it's hard to guess at strategy when you don't know the full picture. And I think now we've seen more of the full picture, haven't we? All right, let's try to do a summary. Well, at the end of day 5, we are almost at the end of the state's rebuttal. They have a 108-page document of text messages to get through. There was more going on with the expert from the state after the lunch break. However, it has been completely wiped from my mind due to the fact that we spent hours watching video of incidents where the police came out to the apartment, and we spent a little less than hours watching videos Sarah had taken on her phone of the victim, in this case, Jorge Torres. It looks like the prosecution is going to really close out their case with videos of the victim. Not only is it a little chilling because even in the arrest videos, you hear George saying Sarah the exact same way he does in the video of him in the suitcase, but you also hear Sarah saying things like, "That's my name. Don't wear it out." The videos I found to be incredibly impactful. You see Sarah coaching George about what to say to the court. When the police show up, you see George saying, literally hunched in on himself, cuffed behind him back, sitting on the edge of the bed saying, "It's just all my fault. It's just all my fault. It doesn't matter what I say to you. It's just all my fault. It doesn't matter. There's a stay away order. It doesn't matter what I say. It's just my fault. It doesn't matter." The videos are going to be this case. When I said originally that I thought the video was going to be this case, I thought it would be the suitcase video. I had no idea what videos the state would bring in the rebuttal case. And if Sarah Boone hadn't chosen to run a battered spouse defense, a lot of those videos wouldn't have come in. It was difficult to watch. It was incredibly sad, but I think it will be very informative to the jury. You see the demeanor between the two. You see the tone of voice between the two. And the other thing that's clear in this case is the alcohol use that is clear. It's just sad. I don't know if there's any, I probably have stronger words for it, but I'm kind of reeling from what we saw. So early on in this case, I was like, the prosecution's not really going after Sarah in cross-examination. They cross-examined her expert more than her. And now it makes a lot more sense why. Because at the end of the day, the prosecution was going to push play on this case in their rebuttal, and they knew exactly what those videos were going to show. And so they're not going to cross-examine her and give her a chance to explain. They're like, "Okay, you said what? All right. You didn't tell the police that before? Okay. Okay. What stuck out to me is that you saw from the defense expert a lot of testimony about how long it can take for victims to trust law enforcement or experts to disclose what had happened to them. And in all of those videos, you saw that from George. You saw Sarah saying, "This is everything that's going on." And then you saw her, I don't want to say gleeful, but it was gleeful. She was also inebriated when the police were arresting him and taking him away. But you also saw him not being willing to say anything. And the police are like, "You're not giving us a straight answer. You're not telling us what's going on." And he was sitting in the back of a police car crying. You're not telling us anything. You're being vague. She said all of this. So I wonder if how the experts testified will stick out in the jury's mind as they watch those videos, or if they'll watch those videos and just be like, "Well, that gives more context." So tomorrow the prosecution will be resting their case, it seems, with just the text messages coming in. The defense attorneys have said, "We don't think there's going to be a rebuttal." Sir, there's not going to be a rebuttal. We also learned more about the bike. We heard about that on a 911 call where Sarah calls 911 and said that George came back to her apartment. She had taken him off the lease, came back to her apartment and took the bike that she bought him. So it's basically still hers. The 911 dispatcher said, ma'am, that's a gift. That's his. And she was like, well, he came and took the bike and he came and took this and that. You heard George telling the police that he came over to the apartment because she was holding on to his license or his ID and his birth certificate, and that he couldn't cash his paycheck because she was holding on to his documentation to go get his paycheck cashed. And that's why he had gone over to the apartment, because he couldn't get it cashed and she had taken him off the lease. But it seemed that she was mad because she wanted money for the rent from him, but then held on to his documentation so he couldn't go and cash his check. So we can now see a little bit more why the prosecution was asking about taking things back, which was a mode of transportation, holding on to necessary paperwork because he couldn't cash his paycheck without it. And you start to see where the state was building their case. And it is difficult. So if you've been watching this trial with an open mind, I wonder if you feel a little bit of whiplash from the day, because it's like, wait, what? And that is why they always tell a jury to keep an open mind until all of the evidence is in. It's going to be real interesting to see what of those videos the prosecution brings up in closing, and it'll be interesting to see how Owens closes. I can also see why Owens was fighting the expert that said, though Sarah does have the traits of battered spouse syndrome, that doesn't apply here. Because that's really what the state's expert ended with. It doesn't apply here. And in fact, the defense opened the door. We never would have heard in this case that Brian Boone thinks Sarah is the aggressor in this case if the defense didn't ask that question. So that's what the jury heard today. And I wonder, after seeing those videos, if there's no doubt for them about that. We'll have to see. So I think we'll get to closing arguments maybe tomorrow afternoon. Don't forget to get the Law Nerd app, because then I'll let you know when we get to closing. And I will let Miguelina, will you let the app know that court ended today with the videos and that we will be back in the morning? Because I told those that were like, these are too hard to watch, that we would let them know. Let's just close the loop for them that this is done. For this day, that's enough work for this day. Tomorrow, I wonder if we will have a verdict, and I wonder how late he will let the jury work tomorrow. But also, openings weren't incredibly long, so I don't know if closings will be incredibly long. There's a caveat to that, though. There's going to be a lot of fighting over jury instructions, and the self-defense instruction can be confusing. So the jury instructions will take some time in closing to explain. And with that, we're going to get to questions. Don't forget to take care of yourselves. Court days are long days. This is difficult. So for everyone who is struggling watching these, it's really hard to watch. And that's where it is. Let's get some questions. We're gonna get to questions, but we're like, can we just we're gonna just stretch a minute. Emily needs to just I hated it. You guys are like, Emily, how you're doing? I'm like, not well. I just, so, yup, we're done. No, Miguelina, that's okay. Just, we do need the pickle. Bring the pickle, the chat says. Tonight's a night to just do something else that is not court. But I've got to go catch up on breaking news because my phone is quite busy at the moment. So, Law Nerds, thank you for no breaking news in the chat and staying on topic. You know it is difficult. This was difficult. I could not have attended to both well, but I think we're just naming the pickle muffins at this point. So. All right, for those of you that have only been with us for this trial, we've not done a lot of pickle cleansing this trial. because it all went so smoothly up until today. And I know I saw a number of you say, Emily, you apologized for jinxing it, but then didn't use a ukulele. Unfortunately, my ukulele is in the other room. I did not have it in my office with me today. I tomorrow will bring the ukulele so I can apologize again for saying this has all gone so smoothly. For any of you that watched the day that the Baldwin case got dismissed, you can watch throughout that live stream as I go from, the defense is throwing everything at the wall, let's see what sticks, to what the fuck, holy shit, what's happening? That was what today was like. Today took us all on a journey. Court is exhausting. I wasn't even in court today, and I think at one point my heart rate was just like, whoop. Anybody else sweating? Thankfully, I'm not stinky because I'm wearing my Lumi, but stinky, not stinky. Sweating. I can tell. I'm just like, it's all of the things. Have we banged? Oh, yes. I think we're at 797. So yes, we have. We are on the road to 800,000. I'm going to try to parse through some questions. I will do my best. I will do my best. You can see that my brain has kind of stopped, and I think it was notable. I want to go back and watch law enforcement. Law enforcement was trying to tell George as they were bringing him clothes and shoes and things. They were like, look, man, how can we help you? Like, you're not supposed to be here. And we saw, notably, I think we saw that after the pretrial, and I will mention this because it's helpful. Emily, you're answering questions. No, we're just going to chat for a minute. After the pretrial, and I don't know if the prosecution will mention this, but after the pretrial stay away, no contact order went into effect, the calls to law enforcement ramped up because it's a do not pass go. It is a do not pass go. There is a no contact stay away. And if she calls the police, he gets arrested. That's it. If he's there, caveat, if he's there and she calls police and he has a no contact order, he goes to jail. And the 911 calls ramped up, and every single one started with, well, it's not an emergency, but he's here again. And there were 3 of those after the no contact order. So it was on that last one, when the police came out, they were like, look, man, what can we do to help you? You can't be here. Do you have anywhere else to go? And he's like, well, my mom's, I don't know if his parents, there was indication early on in trial that his parents said, look, if you're going to be here, you can't be with her or see her. I don't know if his parents also tried to restrict his drinking when he was there, because I could see someone who is deep within what his alcohol use. If the parents said, you can come stay with us, but not if you're going to drink, I can see him feeling like he had nowhere else to go with that. So I don't know, but those calls ramped up because it was a do not pass go that he was going to get arrested. So every time the police rolled out, you can see him being like, Sarah, what the fuck? Like, what the fuck? What the fuck now? A couple of those times, it looked like he was just asleep. It was asleep. She calls the police. That's what it looked like. And a couple of those times, it was the no contact order. It wasn't something else happened in the day. It was, he's here. However, police have to take that seriously. Those pretrial no contact orders haven't been litigated yet. It is meant to be a stopgap between whatever was going on where somebody got arrested and sorting it out in court. It's meant to be a pause to that. And it's meant to be a pause to that. So he did not listen to his defense attorney, did not listen to the judge. And when she said, come on over, he did. And then had the police called on him at least 3 times. Melanie, thank you for the super chat. Love watching your face with some of these exchanges. I was not expecting how all that went down today. It was unexpected. I can't imagine. So I was a prosecutor for over 10 years. So I kind of default into prosecutor brain first. And then I run both sides of the case because most lawyers will run both sides of the case. I default into prosecutor brain. And I'm sitting there wondering what that was like as the prosecutors were going through her phone data dump. They don't know what's in there. Law enforcement found the suitcase video, but as they're going through everything in her phone, going, what the fuck is on her phone? And then in that one video, seeing George with a phone, what else does he have on his phone and where did it go? Wild stuff. Because I think there was a broken phone in the blue suitcase on that property list, like a completely non-operational phone. I just wonder what might have been on that. It is absolutely telling. Also, her constantly putting her phone in his face. Melanie said another example of men can be victims too. Yes. Humans can victimize other humans. Humans can victimize other humans. That's just, and sometimes it's hard to sort out. And George said it in one of the videos. In one of the videos, he's like, well, she's a woman. So Flightless said today felt like 3 years. Yes, exhausted. I can't imagine how the lawyers feel. Yep, same. They feel the same, though they're not caught as off guard. The lawyers knew this was coming. So the lawyers are not as caught off guard as some of us are that are watching this case going, what just happened? They knew, but also I can't imagine the jury sitting there looking between those videos and Sarah Boone. Just looking back and forth. I saw a great question in the chat. I'm going to try to scroll back. Leona Sloan said, Emily, was there a no contact order on the night he passed today? Really confused me. No, that case ended up being dismissed the night that he passed. So it had been not that night. It had been dismissed in advance of that. So by the night that he passed, that case had been dismissed. She didn't want to prosecute. She told police she didn't want to prosecute. And so those cases that it was attached to were dropped. Sandy said, with all due respect, Your Honor, the chat can't that early. Exactly. Sarah Shuffles, JKU said, ending with I love you to death was powerful and should be in their closing. It should. Some of the things that Sarah said to him should absolutely be in their closing. He read in the suitcase video in the opening because he didn't know what else would come in. And so I don't know if he'll do it by transcript or play some of those videos again. Mango Jelly said, reminds me of Judge Newman. We've done enough on this day. Yes, we have. I know. I adore Judge Newman. What I really appreciate about Judge K is that he is firm, but he lets the attorneys talk, and then is firm, when it needs to be, and definitely reined in Owens today when he's like, no. Stop. We're done. Melanie said, does the defense get to respond to those videos at all? They can ask for a rebuttal, which is fairly rare. They knew the videos were coming in, so they should have done offense as the best defense during their case in chief. So generally, the rebuttal evidence only goes to the defense case in chief, and the defense knows what it's going to be. So the defense can choose to put in stuff in their case or not to forestall the prosecution from bringing it in. So generally, blocking it is one of the best ways, but they might not get a surreply or a surrebuttal. I don't think they can. They can't pull Sarah back up to explain it. She could have explained it in her testimony. She didn't. Kylie Needs a Holiday said, not a fearful person. She kept pushing to get a reaction of him snapping. Most of you are too scared to speak that way to an abuser, let alone video them. The video speaks volumes compared to her pictures. And the defense put in pictures. Cole said these really put the suitcase video in context. Yes, they did. The jury's reaction to going overtime tells me the prosecution is winning big. Rune Munch, I don't know if I took, what I take from that is the jury's like, let's get through this. I think they can see the end in sight as well. But also I do think they're invested in this. So let's see, we are, thank you for everybody. I see a lot of super chats that are compassion to other law nerds. You guys are absolutely incredible. So I see a lot of super chats reminding y'all to take care of each other, reminding you that this is never okay, and no one should be treated like this in a relationship at all. So I appreciate all of these supportive super chats of you guys supporting one another. Rosebud said, if I was unsure before, I'm not anymore. She's toxic and an abuser. This video is so sad. The videos are very, very hard to watch. Just very hard to watch. So for all of you that are survivors in the chat, I hope that when you needed to nope out that you did, because it is a lot. Maroon said constantly on edge. She said she did say that, waking him up and putting a phone in his face. She did say that. So let me, Dr. B, I'm still streaming. I'm still streaming. Members only. If you were there last night, we haven't gotten a copyright takedown on last night's members only live yet. So yay for us. Call. There we go. All right. Crazy Cat Queen said, yes, ma'am. Can I point out that none of these videos has Sarah recorded George doing anything abusive to her? And if there were, the defense would have played it. They played the video of him hitting the TV with a baseball bat and then becoming winded. Ew, those videos. Michelle said, I wonder, is she crying seeing all those videos of him? I don't think so. She didn't look that impacted in court, so I don't think so. Steven said, for me, she called PD whenever she felt afraid. When he was in the suitcase, she had every opportunity to call them. If she felt scared to get him and make him leave, she willfully left him in there. And we will see how the jury feels. But yeah, she was not worried about calling the police. That we have taken away. That she was not worried about calling the police. Shanique, thank you for the gifted memberships. Very much appreciated. Mountain Mama 63 said, former dispatcher, thanks for the shout out. Of course, it's hard work. Look, working in the criminal justice system, no matter whereabouts in that system you work, is difficult. There's a different level of patience required with first responders and dispatchers that is a different level than those of us that sometimes get things down the road. Defense attorneys have to deal with all of it, but at least it's a somewhat smaller volume than dispatch. Casey Cat, thank you for the gifted memberships. Let's see. Perhaps Sarah B has some version. I'm not going to speculate on anything other than what the docs said. She had lots of docs over 4 years. So she had lots of people. Emmylou, Emmylou said she would invite him over despite the no contact, call the police, in jail, no job, no money, dependent on her for the financial mercy. And I think the prosecution tried to point that out through some of the expert testimony, showing that she had some of those financial control aspects and the transportation and the rest of it. Mary said, ADB, I had a tooth pulled today and your education commentary is getting me through broth cups and pain. Thanks for everything. I hope it heals well. I hope it heals well for sure. So let's see. Lisa says, does she think this is a friend? I think the police showed up and she was like, if not friend, why friend shaped, and went in for the huggies. It was wild to watch it play out on video. I don't think I've ever seen a video on that type of call quite like that. So Vicky said, Vicky, thank you for the gifted memberships. I appreciate it. Getting it face said, do you think sometimes counsel doesn't object because they're too busy thinking about their own question strategy and miss things? It's possible. I think more often time it's strategy. There's a lot of things that it's like, I can let that one go, or that might backfire. We're going to see how that works out for you. So sometimes it's strategy. Sometimes it is. But also they have multiple counsels at table. So someone can always just like, hey, we can't let that go. So there's that. Let's see. Thank you guys. A lot of you had a lot of input in the chat, a lot of support in the chat. And so I'm going through those because not all of them are questions. And I wanted to make sure we got to some questions. A lot of commentary on no judgment, a lot of just conversation. That's the right word about what we were witnessing. We've been through a day today. Hannah, this super chat came in at 1:52 p.m. Emily, do you think the state is seemingly glossing over things instead of going in as they might have a final gotcha moment later? Or it will all be brought up in closing? Hannah, funny you should ask. They knew the videos were coming, and I think they just wanted to get to the videos in hindsight, but we don't know that while we're watching it. So, Hannah, I would love to know what you think. Let me know in the comments, because I think that that they just were like, we're just going to play the video. We're just going to play the video. That's all. So let's see. General said, can we appreciate Owen's passion for defending his client? He is doing it for free. His choice was interesting, but yes, he definitely brought some passion to it today. More energy is not something that we need to say to Owens today. He definitely brought the energy. We need a catchphrase for this judge. I don't know. I don't know yet, because he's really just pretty even keeled. So that, but the defense attorneys, I don't know what that feels like. Not been a defense attorney, to sit there and know those videos are coming. Like they know that's coming. Bless you. Yes, chat, you're right. Bless you is his phrase. See, chat is quick. Bless you. There we go. Judge K, bless you. We'll take it, Judge K. But his patients were great. So from soup to nuts was the attorneys, unfortunately. The attorney analogies. Tomorrow we can take a poll on whether or not vampires get brought up in closing. I kind of hope not at this point. So in the poll, I said, does the prosecution's case make more sense after the video? I should have said videos. I meant videos. I'm tired too. Yes, 84%, no, 4%, didn't change my opinion either way, 12%. So some of you were like, I wonder if they didn't change my opinion either way, were those of you that were like, no, I've been following this case close, so I knew what this was, so my opinion's not changed. For those of you that have not been following this case closely, have not seen a lot of Sarah Boone's behavior, like the jury hasn't, and came in kind of from a jury perspective, I wonder if the jury was sitting there like, what? Just what? Just what? Because today was a lot. I know there are lots of super chats that we're not going to get to today, and I apologize. Today was a difficult day, a long day. We had a late night on members only. There was a new podcast out for you. I'm going to go catch up on the news, because I can see from the text messages that there is room to chat about the news. Don't forget to download the Law & Order app, because I'm going to go figure out what the judge is doing in the Menendez case. And I'm going to, I'll probably do a reel or a short to put up, and then we'll talk about it later. So it has been a long day. Law Nerds, I'm going to go dive into that. I'm going to take a break first, but I'm going to go dive into that. I'll share something in the Law & Order app in a bit once I have thoughts and have figured out what is happening. Thank you for no spoilers and no breaking news in the chat. I'm going to go catch up a little bit with the day. I'll keep you posted in the app. Thank you guys for being in the app. We were over 80,000 Law Nerds in the app. We're almost at 800,000. Look, I love the parity in numbers. Can we make them match? I ask because I would love for the numbers to just match. Can we just make it match? Thank you guys. Thank you to my incredible mod team today. I know it was a hard day. Thank you to Team Baker and the production team. You guys, Law Nerds, we will see you tomorrow. I will contemplate what time we're going to start stream, and I will keep an eye on it. I will keep an eye on when they actually start arguments, but I do not want to be an hour behind. So I might start at 8 a.m. and be right around an hour behind. Since they are coming in so early tomorrow. Oh, wait, they're coming in at 8:30. Yeah, I might start 8:15. So I will let you know in the, I'll let you know in the app. And with that, you guys, take care of yourselves. Today was a long and a rough one, and I will see you tomorrow for day 5 and maybe the final day of the Sarah Boone case, ? Are we going to be on Verdict Watch tomorrow? Let me know what you think. And thank you for being here all the way to the end. Good night, Law Nerds.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.